Citizenship meaning and significance. Like any other modern state, India has two kinds of people, citizens and aliens. Citizens are full members of the Indian state and owe allegiance to it. They enjoy all civil and political rights. Aliens, on the other hand, are the citizens of some other state and hence, do not enjoy all the civil and political rights. They are of two categories, friendly aliens or enemy aliens. Friendly aliens are the subjects of those countries that have cordial relations with India. Enemy aliens, on the other hand, are the subjects of that country that is at war with India. They enjoy lesser rights than the friendly aliens. They do not enjoy protection against arrest and detention. Article 22. The Constitution confers the following rights and privileges on the citizens of India, and denies the same to aliens. 1. Right against discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. 2. Right to equality of opportunity in the matter of public employment. Article 16. 3. Right to freedom of speech and expression, assembly, association, movement, residence and profession. Article 19. 4. Cultural and educational rights. Articles 29 and 30. 5. Right to vote in elections to the Lok Sabha and State Legislative Assembly. 6. Right to contest for the membership of the Parliament and the State Legislature. 7. Eligibility to hold certain public offices, that is, President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of States, Attorney General of India and Advocate General of States. Along with the above rights, the citizens also owe certain duties towards the Indian state, as for example, paying taxes, respecting the national flag and national anthem, defending the country and so on. In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. Constitutional provisions. The Constitution deals with the citizenship from Articles 5 to 11 under Part 2. However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the persons who became citizens of India at its commencement, i.e., on 26 January 1950. It does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to citizenship. Accordingly, the Parliament has enacted the Citizenship Act, 1955, which has been amended in 1957, 1960, 1985, 1986, 1992, 2003, 2005 and 2015. According to the Constitution, the following four categories of persons became the citizens of India at its commencement, i.e., on 26 January 1950, 1. A person who had his domicile in India and also fulfilled any one of the three conditions, viz., if he was born in India, or if either of his parents was born in India, or if he has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution, became a citizen of India, Article 5. 2. A person who migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfilled any one of the two conditions, viz., in case he migrated to India before July 19, 19,481, he had been ordinarily resident in India since the date of his migration, or in case he migrated to India or after 19 July 1948, he had been registered as a citizen of India. But, a person could be so registered only if he had been resident in India for 6 months preceding the date of his application for registration, Article 6. 3. A person who migrated to Pakistan from India after 1st March 1947, but later returned to India for resettlement could become an Indian citizen. For this, he had to be resident in India for 6 months preceding the date of his application for registration to Article 7. 4. A person who, or any of whose parents or grandparents, was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country of his residence, whether before or after the commencement of the Constitution. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. Article 8. To sum up, these provisions deal with the citizenship of a. Persons domiciled in India, b. Persons migrated from Pakistan, c. Persons migrated to Pakistan but later returned, and d. Persons of Indian origin residing outside India. The other constitutional provisions with respect to the citizenship are as follows. 1. No person shall be a citizen of India or be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign state. Article 9. 2. Every person who is or is deemed to be a citizen of India shall continue to be such citizen, subject to the provisions of any law made by Parliament. Article 10. 3. Parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Article 11. Citizenship Act, 1955. The Citizenship Act, 1955, provides for acquisition and loss of citizenship after the commencement of the Constitution. This Act has been amended so far 8 times by the following Acts. 1. The Citizenship Amendment Act, 1957. 2. The Repealing and Amending Act, 1963. The Citizenship Amendment Act, 1985. 4. The Citizenship Amendment Act, 1986. 5. The Citizenship Amendment Act, 1992. 6. The Citizenship Amendment Act, 2003. 7. The Citizenship Amendment Act, 2005. 8. The Citizenship Amendment Act, 2015. Originally, the Citizenship Act, 1955, also provided for the Commonwealth citizenship. But, this provision was repealed by the Citizenship Amendment Act, 2003. Acquisition of citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, viz. Birth, descent, registration, naturalization and incorporation of territory. 1. By birth. A person born in India on or after 26 January 1950 but before 1 July 1987 is a citizen of India by birth irrespective of the nationality of his parents. A person born in India on or after 1 July 1987 is considered as a citizen of India only if either of his parents is a citizen of India at the time of his birth. Further, those born in India on or after 3 December 2004 are considered citizens of India only if both of their parents are citizens of India or one of whose parents is a citizen of India and the other is not an illegal migrant at the time of their birth. The children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. 2. By descent. A person born outside India on or after 26 January 1950 but before 10 December 1992 is a citizen of India by descent, if his father was a citizen of India at the time of his birth. A person born outside India on or after 10 December 1992 is considered as a citizen of India if either of his parents is a citizen of India at the time of his birth. From 3 December 2004 onwards, a person born outside India shall not be a citizen of India by descent, unless his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of the central government, after the expiry of the said period. An application for registration of the birth of a minor child to an Indian consulate shall be accompanied by an undertaking in writing from the parents of such minor child that he or she does not hold the passport of another country. Further, a minor who is a citizen of India by virtue of descent and is also a citizen of any other country shall cease to be a citizen of India if he does not renounce the citizenship or nationality of another country within 6 months of his attaining full age. 3. By registration. The central government may, on an application, register as a citizen of India any person, not being an illegal migrant, if he belongs to any of the following categories, namely, a. A person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. B. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. C. A person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. D. Minor children of persons who are citizens of India. E. A person of full age and capacity whose parents are registered as citizens of India. F. A person of full age and capacity who, or either of his parents, was earlier citizen of independent India, and is ordinarily resident in India for 12 months immediately before making an application for registration. G. A person of full age and capacity who has been registered as an overseas citizen of India card holder for 5 years, and who is ordinarily resident in India for 12 months before making an application for registration. A person shall be deemed to be of Indian origin if he, or either of his parents, was born in undivided India or in such other territory which became part of India after the 15th August 1947. All the above categories of persons must take an oath of allegiance before they are registered as citizens of India. The form of the oath is as follows. I, A.B. do solemnly affirm, or swear, that I will bear true faith and allegiance to the Constitution of India as by law established, and that I will faithfully observe the laws of India and fulfill my duties as a citizen of India. For by naturalization the central government may, on an application, grant a certificate of naturalization to any person, not being an illegal migrant, if he possesses the following qualifications. A. That he is not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens of that country by naturalization. B. That, if he is a citizen of any country, he undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. C. That he has either resided in India or been in the service of a government in India or partly the one and partly the other, throughout the period of 12 months immediately preceding the date of the application. D. That during the 14 years immediately preceding the said period of 12 months, he has either resided in India or been in the service of a government in India, or partly the one and partly the other, for periods amounting in the aggregate to not less than 11 years. E. That he is of good character. F. That he has an adequate knowledge of a language specified in the 8th schedule to the Constitution 3. And G. That in the event of a certificate of naturalization being granted to him, he intends to reside in India, or to enter into or continue in service under a government in India or under an international organization of which India is a member or under a society, company or body of persons established in India. However, the Government of India may waive all or any of the above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace or human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India. 5. By incorporation of territory. If any foreign territory becomes a part of India, the Government of India specifies the persons who among the people of the territory shall be the citizens of India. Such persons become the citizens of India from the notified date. For example, when Pondicherry became a part of India, the Government of India issued the Citizenship, Pondicherry, Order, 1962, under the Citizenship Act, 1955. 6. Special provisions as to citizenship of persons covered by the Assam Accord. The Citizenship Amendment Act, 1985, added the following special provisions as to citizenship of persons covered by the Assam Accord, which related to the foreigners issue. A. All persons of Indian origin who came to Assam before the 1st January 1966 from Bangladesh and who have been ordinarily residents in Assam since the date of their entry into Assam shall be deemed to be citizens of India as from the 1st January 1966. B. Every person of Indian origin who came to Assam on or after the 1st January 1966 but before the 25th March 1971 from Bangladesh and who has been ordinarily resident in Assam since the date of his entry into Assam and who has been detected to be a foreigner shall register himself. Such a registered person shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years from the date of detection as a foreigner. But, in the intervening period of 10 years, he shall have the same rights and obligations as a citizen of India, excepting the right to vote. Laws of Citizenship. The Citizenship Act, 1955, prescribes 3 ways of losing citizenship whether acquired under the Act or prior to it under the Constitution, viz. Renunciation, termination and deprivation. 1. By renunciation, any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Upon the registration of that declaration, that person ceases to be a citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Further, when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, he may resume Indian citizenship. 2. By termination, when an Indian citizen voluntarily, consciously, knowingly and without duress, undue influence or compulsion, acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which India is engaged. 3. By deprivation, it is a compulsory termination of Indian citizenship by the central government, if a. The citizen has obtained the citizenship by fraud, b. The citizen has shown disloyalty to the Constitution of India, c. The citizen has unlawfully traded or communicated with the enemy during a war, d. The citizen has, within 5 years after registration or naturalization, been imprisoned in any country for 2 years, and e. The citizen has been ordinarily resident out of India for 7 years continuously. For single citizenship, though the Indian constitution is federal and envisages a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of double citizenship. In USA, each person is not only a citizen of USA but also of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one set conferred by the national government and another by the state government. This system creates the problem of discrimination, that is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions, and so on. This problem is avoided in the system of single citizenship prevalent in India. In India, all citizens irrespective of the state in which they are born reside enjoy the same political and civil rights of citizenship all over the country and no discrimination is made between them. However, this general rule of absence of discrimination is subject to some exceptions, viz. 1. The Parliament, under Article 16, can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory, or local authority or other authority within that state or union territory. Accordingly, the Parliament enacted the Public Employment Requirement as to Residence Act, 1957 and thereby authorized the Government of India to prescribe residential qualification only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. As this act expired in 1974, there is no such provision for any state except Andhra Pradesh 5 and Telangana 5A. 2. The Constitution, under Article 15, prohibits discrimination against any citizen on grounds of religion, race, caste, sex or place of birth and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to the Indian citizens. For example, a state may offer concession in fees for education to its residents. 3. The freedom of movement and residence, under Article 19, is subjected to the protection of interests of any scheduled tribe. In other words, the right of outsiders to enter, reside and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. 4. In the case of Jammu and Kashmir, the state legislature is empowered to define the persons who are permanent residents of the state and confer any special rights and privileges in matters of employment under the state government, acquisition of immovable property in the state, settlement in the state and scholarships and such other forms of aid provided by the state government. 6. The Constitution of India, like that of Canada, has introduced the system of single citizenship and provided uniform rights, except in few cases, for the people of India to promote the feeling of fraternity and unity among them and to build an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes and ethnic disputes. Thus, the cherished goal of the founding fathers and the constitution makers to build an united and integrated Indian nation has not been fully realized. Overseas Citizenship of India. In September 2000, the Government of India, Ministry of External Affairs, had set up a high-level committee on the Indian diaspora under the chairmanship of L.M. Singhvi. The mandate of the committee was to make a comprehensive study of the global Indian diaspora and to recommend measures for a constructive relationship with them. The committee submitted its report in January 2002. It recommended the amendment of the Citizenship Act, 1955, to provide for grant of dual citizenship to the persons of Indian origin, PIOs, belonging to certain specified countries. Accordingly, the Citizenship Amendment Act 2003 made provision for acquisition of overseas citizenship of India, OCI, by the PIOs of 16 specified countries other than Pakistan and Bangladesh. It also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. Later, the Citizenship Amendment Act 2005 expanded the scope of grant of OCI for PIOs of all countries except Pakistan and Bangladesh as long as their home countries hold dual citizenship under their local laws. It must be noted here that the OCI is not actually a dual citizenship as the Indian Constitution forbids dual citizenship or dual nationality, Article 9. Again, the Citizenship Amendment Act 2015 has modified the provisions pertaining to the OCI in the Principal Act. It has introduced a new scheme called Overseas Citizen of India Cardholder, by merging the PIO card scheme and the OCI card scheme. The PIO card scheme was introduced on 19 August 2002 and thereafter the OCI card scheme was introduced on 1 December 2005. Both the schemes were running in parallel even though the OCI card scheme had become more popular. This was causing unnecessary confusion in the minds of applicants, keeping in view some problems being faced by applicants and to provide enhanced facilities to them. The Government of India decided to formulate one single scheme after merging the PIO and schemes, OCI containing positive attributes of both. Hence, for achieving this objective, the Citizenship Amendment Act 2015 was enacted. The PIO scheme was rescinded with 9 January 2015 and it was also notified that all existing PIO cardholders shall be deemed to be OCI cardholders with 09-01-2015.7. The Citizenship Amendment Act 2015 replaced the nomenclature of Overseas Citizen of India with that of overseas citizen of India cardholder, and made the following provisions in the Principal Act. I. Registration of overseas citizen of India cardholder. 1. The central government may, on an application made in this behalf, register as an overseas citizen of India cardholder, a. any person of full age and capacity, I. who is a citizen of another country, but was a citizen of India at the time of, or at any time after the commencement of the Constitution, or 2. who is a citizen of another country, but was eligible to become a citizen of India at the time of the commencement of the Constitution, or 3. who is a citizen of another country, but belonged to a territory that became part of India after the 15th August 1947, or 4. who is a child or a grandchild or a great-grandchild of such a citizen, or b. a person who is a minor child of a person mentioned in clause a, or c. a person who is a minor child, and whose both parents are citizens of India or one of the parents is a citizen of India, or d. spouse of foreign origin of a citizen of India or spouse of foreign origin of an overseas citizen of India cardholder and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. No person who or either of whose parents or grandparents or great-grandparents is or had been a citizen of Pakistan, Bangladesh or such other country as the central government may specify, shall be eligible for registration as an overseas citizen of India cardholder. 2. The central government may specify the date from which the existing persons of Indian origin cardholders shall be deemed to be overseas citizens of India cardholders. 3. Notwithstanding anything contained in point 1, the central government may, if it is satisfied that special circumstances exist, after recording the circumstances in writing, register a person as an overseas citizen of India cardholder. 2. Conferment of rights on overseas citizen of India cardholder. 1. An overseas citizen of India cardholder shall be entitled to such rights as the central government may specify in this behalf. 2. An overseas citizen of India cardholder shall not be entitled to the following rights, which are conferred on a citizen of India. A. He shall not be entitled to the right to equality of opportunity in matters of public employment. B. He shall not be eligible for election as president. C. He shall not be eligible for election as vice president. D. He shall not be eligible for appointment as a judge of the Supreme Court. E. He shall not be eligible for appointment as a judge of the High Court. F. He shall not be entitled for registration as a voter. G. He shall not be eligible for being a member of the House of the People or of the Council of States. H. He shall not be eligible for being a member of the State Legislative Assembly or the State's Legislative Council. I. He shall not be eligible for appointment to public services and posts in connection with affairs of the Union or of any state except for appointment in such services and posts as the central government may specify. 3. Renunciation of overseas citizen of India card. 1. If any overseas citizen of India cardholder makes in prescribed manner a declaration renouncing the card registering him as an overseas citizen of India cardholder, the declaration shall be registered by the central government, and upon such registration, that person shall cease to be an overseas citizen of India cardholder. 2. Where a person ceases to be an overseas citizen of India cardholder, the spouse of foreign origin of that person, who has obtained overseas citizen of India card, and every minor child of that person registered as an overseas citizen of India cardholder shall thereupon cease to be an overseas citizen of India cardholder. 4. Cancellation of registration as overseas citizen of India cardholder. The central government may cancel the registration of a person as an overseas citizen of India cardholder, if it is satisfied that a. The registration as an overseas citizen of India cardholder was obtained by means of fraud, false representation or the concealment of any material fact, or b. The overseas citizen of India cardholder has shown disaffection towards the Constitution of India, or c. The overseas citizen of India cardholder has, during any war in which India may be engaged, unlawfully traded or communicated with an enemy, or d. The overseas citizen of India cardholder has, within 5 years after registration, been sentenced to imprisonment for a term of not less than 2 years, or e. It is necessary so to do in the interests of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interests of the general public, or f. The marriage of an overseas citizen of India cardholder, I, has been dissolved by a competent court of law or otherwise, or 2. Has not been dissolved but, during the subsistence of such marriage, he has solemnized marriage with any other person. Table 6.1 comparing NRI, PI and OCI cardholder HSL No. Elements of comparison non-resident Indian, NRI, person of Indian origin, PIO, overseas citizen of India, OCI, cardholder 1. Who? An Indian citizen who is ordinarily residing outside India and holds an Indian passport. A person who or whose any of ancestors was an Indian national and who is presently holding another country's citizenship nationality, i.e. he is holding foreign passport. A person registered as overseas citizen of India, OCI, cardholder under the Citizenship Act, 1955. Following categories of foreign nationals are eligible for registration as overseas citizen of India, OCI, cardholder. 1. Who was a citizen of India at the time of. 2. Who is eligible, or at any time after the commencement of the Constitution, i.e. 26th January 1950, or 2. Who was eligible to become a citizen of India on 26th January 1950, or 3. Who belonged to a territory that became part of India after 15th August 1947, or 4. Who is a child or a grandchild or a great-grandchild of such a citizen, or 5. Who is a minor child of such persons mentioned above, or 6. Who is a minor child and whose both parents are citizens of India or one of the parents is a citizen of India, or 7. Spouse of foreign origin of a citizen of India or spouse of foreign origin of an overseas citizen of India cardholder registered under the Citizenship Act, 1955 and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. 3. How can one get eligible persons to apply online? 4. Where to apply? Till such time the online payment facility is introduced, the following instructions shall be followed, i. The printout of the online application form, completed in all respects, along with enclosures, demand draft and photograph in duplicate should be submitted to the Indian Mission Post having jurisdiction over the country of which the applicant is a citizen, or if he/she is not living in the country of his/her citizenship, to the Indian Mission Post having jurisdiction over the country of which the applicant is ordinarily a resident. 2. If the applicant is residing in India, the printout of the online application form, completed in all respects, along with enclosures, demand draft and photographs in duplicate should be submitted to the Foreigners Regional Registration Offices, FRROs, according to their jurisdictional control. 5. Fees. A. In case of application submitted in Indian Mission Post abroad $275 or equivalent in local currency. B. In case of application submitted in India Rs 15,006. Which nationals are ineligible? No person, who or either of whose parents or grandparents or great-grandparents is or had been a citizen of Pakistan, Bangladesh or such other country as the central government may specify, shall be eligible for registration as an overseas citizen of India cardholder. I. Multiple entry lifelong visa for visiting India for any purpose. However, OCI cardholders will require a special permission to undertake research work in India for which they may submit the application or benefits to the Indian Mission as post from available to concerned Indian. 2. Exemption from 7. What benefits one is entitled to? Citizens subject to notifications issued by no specific benefits registration with Foreigners Regional Registration Officer, FRO, or foreigners the registration officer government, for any length from time to stay in India. Time 3. Parity with non-resident Indians, NRIs, in respect of all facilities available to them in economic, financial, and educational fields except in matters relating to the acquisition of agricultural or plantation properties. 4. Registered overseas citizen of India card holder shall be treated at par with non-resident Indians in the matter of inter-country adoption of Indian children. Registered overseas citizen of India card holder shall be treated at par with resident Indian nationals in the matter of tariffs in airfares in domestic sectors in India. 6. Registered overseas citizen of India card holder shall be charged the same entry fee as domestic Indian visitors to visit national parks and wildlife sanctuaries in India. 7. Parity with non-resident Indians, NRI, in respect of a. Entry fees to be charged for visiting the national monuments, historical sites and museums in India. B. Pursuing the following professions in India, in pursuance of the provisions contained in the relevant acts, namely, a. Doctors, dentists, nurses and pharmacists, b. Advocates, c. Architects, and d. Chartered accountants. C. To appear for the All India Pre-Medical Test or such other tests to make them eligible for admission in pursuance of the provisions contained in the relevant acts. 8. State governments should ensure that the OCI card holder registration booklets of OCI card holders are treated as their identification for any services rendered to them. In case proof of residence is required, overseas citizens of India card holder may give an affidavit stating that a particular specific address may be treated as their place of residence in India. 8. Does he/she require visa for visiting India? No guest can visit India without visa for lifelong. 9. Is he/she required to register with the local police authorities in India? No guest if the period of stay is for more than 180 days. No. 10. What activities can be undertaken in India? All activities. Activity as per the type of visa obtain all activities except research work for which special permission is required from the Indian Mission Post foreign concerned. As per the Citizenship Act 1955, as per the Citizenship He/She Has Act 1955, a person to be registered as an OCI ordinarily card holder for 5 years. How can one he/she isn't resident in and who is ordinarily 11 acquire India for a resident in India for citizenship? Citizen period of 7-12 months before years making an application before for registration is making an eligible for grant of application Indian citizenship. For registration. Table 6.2 articles related to citizenship at a glance. Article No. Subject matter 5. Citizenship at the commencement of the Constitution. 6. Rights of citizenship of certain persons who have migrated to India from Pakistan. 7. Rights of citizenship of certain migrants to Pakistan. 8. Rights of citizenship of certain persons of Indian origin residing outside India. 9. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. 10. Continuance of the rights of citizenship. 11. Parliament to regulate the right of citizenship by Law Table 6.3 Citizenship Act 1955 at a glance, as amended up to 2015. Sections. Subject matter 1. Short title 2. Interpretation acquisition of citizenship. 3. Citizenship by birth. 4. Citizenship by descent. 5. Citizenship by registration. 6. Citizenship by naturalization. 6a. Special provisions as to citizenship of persons covered by the Assam Accord. 7. Citizenship by incorporation of territory. Overseas citizenship. 7a. Registration of overseas citizen of India card holder. 7b. Conferment of rights on overseas citizen of India card holder. 7c. Renunciation of overseas citizen of India card. 7d. Cancellation of registration as overseas citizen of India card holder. Termination of citizenship. 8. Renunciation of citizenship. 9. Termination of citizenship. 10. Deprivation of Citizenship Supplemental 11. Commonwealth Citizenship repealed. 12. Power to confer rights of Indian citizen on citizens of certain countries repealed. 13. Certificate of citizenship in case of doubt 14. Disposal of application under sections 5, 6 and 7 of 14A. Issue of national identity cards 15. Revision 15A. Review. 16. Delegation of powers 17. Offences 18. Power to make rules 19. Repeals. Repealed. Table 6.4 Schedules of the Citizenship Act 1955. At a glance, numbers, subject matter. First schedule, list of countries related to the Commonwealth citizenship, omitted by the 2003 amendment. Second schedule, of allegiance. Third schedule, qualifications for naturalization. Fourth schedule, list of countries related to the overseas citizenship, omitted by the 2005 amendment. Notes and references 1. On this date, the permit system for such migration was introduced. 2. This provision refers to migration after 1st March 1947 but before 26 January 1950. The question of citizenship of persons who migrated after 26 January 1950 has to be decided under the provisions of the Citizenship Act 1955. 3. The 8th schedule of the Constitution recognizes presently 22, originally 14, languages. 4. This will not apply if he is a student abroad, or is in the service of the government in India or an international organization of which India is a member, or has registered newly at an Indian consulate his intention to retain his Indian citizenship. 5. By virtue of Article 371-D inserted by the 32nd Constitutional Amendment Act, 1973. 5. Article 371-D has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act, 2014. 6. Article 35 in the Constitution, Application to Jammu and Kashmir, Order, 1954. This was issued by the President of India under powers conferred on him by Article 370 of the Constitution. 7. Annual Report 2015-16, Ministry of Home Affairs, Government of India, p. 262. 8. This table is downloaded from the website of Ministry of Home Affairs, Government of India. Fundamental rights. Fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA, i.e., Bill of Rights. Part 3 of the Constitution is rightly described as the Magna Carta of India. 1. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. The fundamental rights are guaranteed by the Constitution to all persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country, and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not of men. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are fundamental, also in the sense that they are most essential for the all-round development, material, intellectual, moral and spiritual, of the individuals. Originally, the Constitution provided for 7 fundamental rights with 1. Right to equality, Articles 14-18, 2. Right to freedom, Articles 19-22, 3. Right against exploitation, Articles 23-24, 4. Right to freedom of religion, Articles 25-28, 5. Cultural and educational rights, Articles 29-30, 6. Right to property, Article 31, 7. Right to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act, 1978.
It is made a legal right under Article 300 in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of fundamental rights. The fundamental rights guaranteed by the Constitution are characterized by the following. 1. Some of them are available only to the citizens, while others are available to all persons, whether citizens, foreigners or legal persons like corporations or companies. 2. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike the balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. 3. Most of them are available against the arbitrary action of the state, with a few exceptions like those against the state's action and against the action of private individuals. When the rights that are available against the state's action only are violated by the private individuals, there are no constitutional remedies but only ordinary legal remedies. 4. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. 5. They are justiciable, allowing persons to courts for their
enforcement, if and when they are violated. 6. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the High Courts. 7. They are not sacrosanct or permanent. The Parliament can curtail or repeal them but only by a Constitutional Amendment Act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. The amendability of fundamental rights is explained in detail in Chapter 11. 8. They can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression, i.e., external emergency, and not on the ground of armed rebellion, i.e., internal emergency. The suspension of fundamental rights during a national emergency is explained in detail in Chapter 16. 9. Their scope of operation is limited by Article 31A, saving of laws providing for acquisition of estates, etc., Article 31B, validation of certain acts and regulations included in the 9th Schedule, and Article 31C, saving of laws giving effect to certain directive principles. 10. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous services can be restricted or abrogated by the Parliament, Article 33. 11. Their application can be restricted while martial law is in force in any area. Martial law means military rule, imposed under abnormal circumstances to restore order, Article 34. It is different from the imposition of national emergency. 12. Most of them are directly enforceable, self-executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament and not by state legislatures so that uniformity throughout the country is maintained, Article 35. Definition of state. The term, state, has been used in different provisions concerning the fundamental rights. Hence, Article 12 has defined the term for the purposes of Part 3. According to it, the state includes the following: a. Government and Parliament of India, that is, executive and legislative organs of the Union Government. B. Government and legislature of states, that is, executive and legislative organs of state government. C. All local authorities, that is, municipalities, panchayats,
district boards, improvement trusts, etc. D. All other authorities, that is, statutory or non-statutory authorities like LIC, ONGC, SEL, etc. Thus, state has been defined in a wider sense so as to include all its agencies. It is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state, under Article 12. Laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressly provides for the doctrine of judicial review. This power has been conferred on the Supreme Court, Article 32, and the High Courts, Article 226, that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term, law, in Article 13 has been given a wide connotation so as to include the following: a. Permanent laws enacted by the Parliament or the state legislatures. B. Temporary laws like ordinances issued by the President or the state governors. C. Statutory instruments in the nature of delegated legislation, executive legislation, like order, bylaw, rule, regulation or notification. And D. Non-legislative sources of law, that is, custom or usage having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right and hence can be declared as void. Category consists of 1. Right to equality, Articles 14-18, a. Equality before law and equal protection of laws, Article 14. B. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, Article 15. C. Equality of opportunity in matters of public employment, Article 16. D. Abolition of untouchability and prohibition of its practice, Article 17. E. Abolition of titles except military and academic, Article 18. 2. Right to freedom, Articles 19-22, a. Protection of 6 rights regarding freedom of I. Speech and expression, 2. Assembly, 3. Association, 4. Movement, we, residence, and 6. Profession, Article 19. B. Protection in respect of conviction for offences, Article 20. C. Protection of life and personal liberty, Article 21. D. Right to elementary education, Article 21a. E. Protection against arrest and detention in certain cases, Article 22. 3. Right against exploitation, Articles 23-24, a. Prohibition of traffic in human beings and forced labor, Article 23. B. Prohibition of employment of children in factories, etc., Article 24. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Keswananda Baki Case 2, 1973, that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence can be declared as void. Table 7.1 Fundamental Rights at a glance. 4. Right to freedom of religion, Article 25-28, a. Freedom of conscience and free profession, practice and propagation of religion, Article 25. B. Freedom to manage religious affairs, Article 26. C. Freedom from payment of taxes for promotion of any religion, Article 27. D. Freedom from attending religious instruction or worship in certain educational institutions, Article 28. 5. Cultural and educational rights, Articles 29-30, a. Protection of language, script and culture of minorities, Article 29. B. Right of minorities to establish and administer educational institutions, Article 30. 6. Right to constitutional remedies, Article 32. Right to move the Supreme Court for the enforcement of fundamental rights including the writs of I. Habeas corpus. 2. Mandamus. 3. Prohibition. 4. Certiorari. And we. Quo warranto. Article 32. Table 7.2 Fundamental Rights. FR. Of foreigners are available only to citizens and not to foreigners are available to both citizens and foreigners, except enemy aliens. 1. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 15. 1. Equality before law and equal protection of laws. Article 14. 2. Equality of opportunity in matters of public employment. Article 16. 2. Protection in respect of conviction for offences. Article 20. 3. Protection of 6 rights regarding freedom of I. Speech and expression. 2. Assembly. 3. Association. 4. Movement. We. Residence. And 6. Profession. Article 19. 3. Protection of life and personal liberty. Article 21.
4. Protection of language, script and culture of minorities. Article 29. 4. Right to elementary education. Article 21A. 5. Right of minorities to establish and administer educational institutions. Article 30. 5. Protection against arrest and detention in certain cases. Article 22. 6. Prohibition of traffic in human beings and forced labor. Article 23. 7. Prohibition of employment of children in factories, etc. Article 24. 8. Freedom of conscience and free profession, practice and propagation of religion. Article 25. 9. Freedom to manage religious affairs. Article 26. 10. Freedom from payment of taxes for promotion of any religion. Article 27. 11. Freedom from attending religious instruction or worship in certain educational institutions. Article 28. Right to equality. 1. Equality before law and equal protection of laws. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision confers rights on all persons, whether citizens or foreigners. Moreover, the word person includes legal persons, viz., statutory corporations, companies, registered societies or any other type of legal person. The concept of equality before law is of British origin, while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes a. The absence of any special privileges in favor of any person, b. The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and c. No person, whether rich or poor, high or low, official or non-official, is above the law. The second concept, on the other hand, connotes a. The equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws, b. The similar application of the same laws to all persons who are similarly situated, and c. The like should be treated alike without any discrimination. Thus, the former is a negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. While Article 14 forbids class legislation, it permits reasonable classification of persons, objects and transactions by the law. But the classification should not be arbitrary, artificial or evasive. Rather, it should be based on an intelligible differential and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law, propounded by A. V. Dicey, the British jurist. His concept has the following 3 elements or aspects. I. Absence of arbitrary power, that is, no man can be punished except for a breach of law. 2. Equality before the law, that is, equal subjection of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. 3. 3. The primacy of the rights of the individual, that is, the Constitution is the result of the rights of the individual as defined and enforced by the courts of law rather than the Constitution being the source of the individual rights. The first and the second elements are applicable to the Indian system and not the third one. In the Indian system, the Constitution is the source of the individual rights. The Supreme Court held that the rule of law, as embodied in Article 14, is a basic feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Exceptions to equality. The rule of equality before law is not absolute and there are constitutional and other exceptions to it. These are mentioned below. 1. The President of India and the Governor of States enjoy the following immunities. Article 361 I. The President or the Governor is not answerable to any court for the exercise and performance of the powers and duties of his office. 2. No criminal proceedings shall be instituted or continued against the President or the Governor in any court during his term of office. 3. No process for the arrest or imprisonment of the President or the Governor shall be issued from any court during his term of office. 4. No civil proceedings against the President or the Governor shall be instituted during his term of office in any court in respect of any act done by him in his personal capacity, whether before or after he entered upon his office, until the expiration of 2 months next after notice has been delivered to him. 2. No person shall be liable to any civil or criminal proceedings in any court in respect of the publication in a newspaper, or by radio or television, of a substantially true report of any proceedings of either House of Parliament or either House of the Legislature of a state. Article 361-A. 3. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof. Article 105. 4. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof. Article 194. 5. Article 31-C is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that, where Article 31-C comes in, Article 14 goes out. 6. The foreign sovereigns, rulers, ambassadors and diplomats enjoy immunity from criminal and civil proceedings. 7. The UN and its agencies enjoy the diplomatic immunity. 2. Prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex or place of birth. The 2 crucial words in this provision are discrimination and only. The word discrimination means to make an adverse distinction with regard to, or to distinguish unfavorably from others. The use of the word only connotes that discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex, or place of birth with regard to a. Access to shops, public restaurants, hotels and places of public entertainment, or b. The use of wells, tanks, bathing ghats, road and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. This provision prohibits discrimination both by the state and private individuals, while the former provision prohibits discrimination only by the state. There are 3 exceptions to this general rule of non-discrimination. A. The state is permitted to make any special provision for women and children. For example, reservation of seats for women in local bodies or provision of free education for children. B. The state is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. For example, reservation of seats or fee concessions in public educational institutions. C. The state is empowered to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes regarding their admission to educational institutions including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. The last provision was added by the 93rd Amendment Act of 2005. In order to give effect to this provision, the Centre enacted the Central Educational Institutions Reservation in Admission Act 2006, providing a quota of 27% for candidates belonging to the other backward classes, OBCs, in all central higher educational institutions including the Indian Institutes of Technology, IITs, and the Indian Institutes of Management, IIMs. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act. But the court directed the central government to exclude the creamy layer, advanced sections, among the OBCs while implementing the law. Creamy layer: the children of the following different categories of people belong to creamy layer among OBCs and thus will not get the quota benefit. 1. Persons holding constitutional posts like President, Vice President, judges of SC and HCs, chairman and members of UPSC and SPSCs, CEC, CAG and so on. 2. Group A, Class I and Group B, Class 2 officers of the All India, Central and State Services, and employees holding equivalent posts in PSUs, banks, insurance organizations, universities etc., and also in private employment. 3. Persons who are in the rank of colonel and above in the army and equivalent posts in the navy, the air force and the paramilitary forces. 4. Professionals like doctors, lawyers, engineers, artists, authors, consultants and so on. 5. Persons engaged in trade, business and industry. 6. People holding agricultural land above a certain limit and vacant land or buildings in urban areas. 7. Persons having gross annual income of more than 6 lakh or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was 1 lakh. It was subsequently revised to 2.5 lakh in 2004, 4.5 lakh in 2008 and 6 lakh in 2013. 3. Equality of opportunity in public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. No citizen can be discriminated against or be ineligible for any employment or office under the state on grounds of only religion, race, caste, sex, descent, place of birth or residence. There are 3 exceptions to this general rule of equality of opportunity in public employment. A. Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority. As the Public Employment Requirement as to Residence Act of 1957 expired in 1974, there is no such provision for any state except Andhra Pradesh 5 and Telangana 5A. B. The state can provide for reservation of appointments or posts in favor of any backward class that is not adequately represented in the state services. C. A law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to the particular religion or denomination. Mandal Commission and Aftermath. In 1979, the Morarji Desai government appointed the second 6 Backward Classes Commission under the chairmanship of B.P. Mandal, a member of Parliament, in terms of Article 340 of the Constitution to investigate the conditions of the socially and educationally backward classes and suggest measures for their advancement. The Commission submitted its report in 1980 and identified as many as 3,743 castes as socially and educationally backward classes. They constitute nearly 52% component of the population, excluding the scheduled castes, SCs, and the scheduled tribes, STs. The Commission recommended for reservation of 27% government jobs for the other backward classes, OBCs, so that the total reservation for all SCs, STs and OBCs, amounts to 50%. It was after 10 years in 1990 that the VP Singh government declared reservation of 27% government jobs for the OBCs. Again in 1991, the Narasimha Rao government introduced two changes: a preference to the poorer sections. Among the OBCs in the 27% quota, i.e., adoption of the economic criteria in granting reservation, and b. reservation of another 10% of jobs for poorer, economically backward, sections of higher castes who are not covered by any existing schemes of reservation. In the famous Mandal Case Act, 1992, the scope and extent of Article 16(4), which provides for reservation of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. Though the court has rejected the additional reservation of 10% for poorer sections of higher castes, it upheld the constitutional validity of 27% reservation for the OBCs with certain conditions, viz. a. The advanced sections among the OBCs, the creamy layer, should be excluded from the list of beneficiaries of reservation. b. No reservation in promotions. Reservation should be confined to initial appointments only. Any existing reservation in promotions can continue for 5 years only, i.e., up to 1997. c. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. d. The carry forward rule, in case of unfilled, backlog, vacancies is valid. But it should not violate 50% rule. e. A permanent statutory body should be established to examine complaints of over-inclusion and under-inclusion in the list of OBCs. With regard to the above rulings of the Supreme Court, the government has taken the following actions. A. Ram Nandan Committee was appointed to identify the creamy layer among the OBCs. It submitted its report in 1993, which was accepted. B. National Commission for Backward Classes was established in 1993 by an Act of Parliament. It considers inclusions in and exclusions from the lists of castes notified as backward for the purpose of job reservation. C. In order to nullify the ruling with regard to reservation in promotions, the 77th Amendment Act was enacted in 1995. It added a new provision in Article 16 that empowers the state to provide for reservation in promotions of any services under the state in favor of the SCs and STs that are not adequately represented in the state services. Again, the 85th Amendment Act of 2001 provides for consequential seniority in the case of promotion by virtue of rule of reservation for the government servants belonging to the SCs and STs with retrospective effect from June 1995. d. The ruling with regard to backlog vacancies was nullified by the 81st Amendment Act of 2000. It added another new provision in Article 16 that empowers the state to consider the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years. Such class of vacancies are not to be combined with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on total number of vacancies of that year. In brief, it ends the 50% ceiling on reservation in backlog vacancies. e. The 76th Amendment Act of 1994 has placed the Tamil Nadu Reservations Act 9 of 1994 in the 9th schedule to protect it from judicial review as it provided for 69% of reservation, far exceeding the 50% ceiling. For abolition of untouchability, Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act 1955 to enlarge the scope and make penal provisions more stringent. The Act defines civil right as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution or in the Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense but the practice as it had developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. Hence, it does not cover social boycott of a few individuals or their exclusion from religious services, etc. Under the Protection of Civil Rights Act, 1955, the offences committed on the ground of untouchability are punishable either by imprisonment up to 6 months or by fine up to 500 or both. A person convicted of the offence of untouchability is disqualified for election to the parliament or state. Legislature. The Act declares the following acts as offences. A. Preventing any person from entering any place of public worship or from worshipping therein. B. Justifying untouchability on traditional, religious, philosophical or other grounds. C. Denying access to any shop, hotel or places of public entertainment. D. Insulting a person belonging to scheduled caste on the ground of untouchability. E. Refusing to admit persons in hospitals, educational institutions or hostels established for public benefit. F. Preaching untouchability directly or indirectly. And G. Refusing to sell goods or render services to any person. The Supreme Court held that the right under Article 17 is available against private individuals and it is the constitutional obligation of the state to take necessary action to ensure that this right is not violated. 5. Abolition of titles. Article 18 abolishes titles and makes 4 provisions in that regard. A. It prohibits the state from conferring any title, except a military or academic distinction, on anybody, whether a citizen or a foreigner. B. It prohibits a citizen of India from accepting any title from any foreign state. C. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the President. D. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument or office from or under any foreign state without the consent of the President. From the above, it is clear that the hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Dewan Bahadur, etc., which were conferred by colonial states are banned by Article 18 as these are against the principle of equal status of all. In 199610, the Supreme Court upheld the constitutional validity of the national awards, Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri. It ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only hereditary titles of nobility. Therefore, they are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. However, it also ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. These national awards were instituted in 1954. The Janata Party government headed by Morarji Desai discontinued them in 1977. But they were again revived in 1980 by the Indira Gandhi government. Right to freedom 1. Protection of 6 rights. Article 19 guarantees to all citizens the 6 rights. These are: I. Right to freedom of speech and expression. 2. Right to assemble peaceably and without arms. 3. Right to form associations or unions or cooperative societies. 10. 4. Right to move freely throughout the territory of India. We. Right to reside and settle in any part of the territory of India. 6. Right to practice any profession or to carry on any occupation, trade or business. Originally, Article 19 contained 7 rights. But the right to acquire, hold and dispose of property was deleted by the 44th Amendment Act of 1978. These 6 rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company but not to foreigners or legal persons like companies or corporations, etc. The state can impose, reasonable, restrictions on the enjoyment of these 6 rights only on the grounds mentioned in the Article 19 itself and not on any other grounds. Freedom of speech and expression, it implies that every citizen has the right to express his views, opinions, belief and convictions freely by word of mouth, writing, printing, picturing or in any other manner. The Supreme Court held that the freedom of speech and expression includes the following. A. Right to propagate one's views as well as views of others. B. Freedom of the press. C. Freedom of commercial advertisements. D. Right against tapping of telephonic conversation. E. Right to telecast, that is, government has no monopoly on electronic media. F. Right against bund called by a political party or organization. G. Right to know about government activities. H. Freedom of silence. I. Right against imposition of pre-censorship on a newspaper. J. Right to demonstration or picketing but not right to strike. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Freedom of assembly. Every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstrations and take out processions. This freedom can be exercised only on public land and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies, or one that causes breach of public peace or one that involves arms. This right does not include the right to strike. The state can impose reasonable restrictions on the exercise of right of assembly on 2 grounds, namely, sovereignty and integrity of India and public order including the maintenance of traffic in the area concerned. Under Section 144 of Criminal Procedure Code, 1973, a magistrate can restrain an assembly, meeting or procession if there is a risk of obstruction, annoyance or danger to human life, health or safety or a disturbance of the public tranquility or a riot or any affray. Under Section 141 of the Indian Penal Code, as assembly of 5 or more persons becomes unlawful if the object is a. To resist the execution of any law or legal process, b. To forcibly occupy the property of some person, c. To commit any mischief or criminal trespass, d. To force some person to do an illegal act, and e. To threaten the government or its officials on exercising lawful powers. Freedom of association. All citizens have the right to form associations or unions or cooperative societies. 10b. It includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions or any body of persons. It not only includes the right to start an association or union but also to continue with the association or union as such. Further, it covers the negative right of not to form or join an association or union. Reasonable restrictions can be imposed on the exercise of this right by the state on the grounds of sovereignty and integrity of India, public order and morality. Subject to these restrictions, the citizens have complete liberty to form associations or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade unions have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike can be controlled by an appropriate industrial law. Freedom of movement. This freedom entitles every citizen to move freely throughout the territory of the country. He can move freely from one state to another or from one place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling and not parochialism. The grounds of imposing reasonable restrictions on this freedom are 2, namely, the interests of general public and the protection of interests of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. The Supreme Court held that the freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. The Bombay High Court validated the restrictions on the movement of persons affected by AIDS. The freedom of movement has two dimensions, viz. Internal, right to move inside the country, and external, right to move out of the country and right to come back to the country. Article 19 protects only the first dimension. The second dimension is dealt by Article 21, right to life and personal liberty. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. This right has two parts. A. The right to reside in any part of the country, which means to stay at any place temporarily, and B. The right to settle in any part of the country, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism and avoids narrow-mindedness. The state can impose reasonable restrictions on the exercise of this right on two grounds, namely, the interest of general public and the protection of interests of any scheduled tribes. The right of outsiders to reside and settle in tribal areas is restricted to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. In many parts of the country, the TRBILs have been permitted to regulate their property rights in accordance with their customary rules and laws. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. Freedom of profession, etc. All citizens are given the right to practice any profession or to carry on any occupation, trade or business. This right is very wide as it covers all the means of earning one's livelihood. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to a. Prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business, and b. Carry on by itself any trade, business, industry or service whether to the exclusion, complete or partial, of citizens or otherwise. Thus, no objection can be made when the state carries on a trade, business, industry or service either as a monopoly, complete or partial, to the exclusion of citizens, all or some only, or in competition with any citizen. The state is not required to justify its monopoly. This right does not include the right to carry on a profession or business or trade or occupation that is immoral, trafficking in women or children, or dangerous, harmful drugs or explosives, etc. The state can absolutely prohibit these or regulate them through licensing. 2. Protection in respect of conviction for offences. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. It contains 3 provisions in that direction. A. No ex post facto law, no person shall be, I. Convicted of any offence except for violation of a law in force at the time of the commission of the act, nor 2. Subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. B. No double jeopardy, no person shall be prosecuted and punished for the same offence more than once. C. No self-incrimination, no person accused of any offence shall be compelled to be a witness against himself. An ex post facto law is one that imposes penalties retrospectively, that is, upon acts already done or which increases the penalties for such acts. The enactment of such a law is prohibited by the first provision of Article 20. However, this limitation is imposed only on criminal laws and not on civil laws or tax laws. In other words, a civil liability or a tax can be imposed retrospectively. Further, This provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. Finally, the protection, immunity, under this provision cannot be claimed in case of preventive detention or demanding security from a person. The protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. The protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to I. Compulsory production of material objects. 2. Compulsion to give thumb impression, specimen signature, blood specimens, and 3. Compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. 3. Protection of life and personal liberty. Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. In the famous Gopalan case 11, 1950, the Supreme Court has taken a narrow interpretation of the Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive the right to life and personal liberty of a person based on a law. This is because of the expression, procedure established by law, in Article 21, which is different from the expression, due process of law, contained in the American Constitution. Hence, the validity of a law that has prescribed a procedure cannot be questioned on the ground that the law is unreasonable, unfair or unjust. Secondly, the Supreme Court held that the personal liberty means only liberty relating to the person or body of the individual. But, in Menka Case 12, 1978, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of the Article 21. Therefore, it ruled that the right to life and personal liberty of a person can be deprived by a law provided the procedure prescribed by that law is reasonable, fair and just. In other words, it has introduced the American expression, due process of law. In effect, the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. Further, the court held that the right to life, as embodied in Article 21, is not merely confined to animal existence or survival, but it includes within its ambit the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete and worth living. It also ruled that the expression, personal liberty, in Article 21 is of the widest amplitude and it covers a variety of rights that go to constitute the personal liberties of a man. The Supreme Court has reaffirmed its judgment in the Menka case in the subsequent cases. It has declared the following rights as part of Article 21. 1. Right to live with human dignity. 2. Right to decent environment including pollution-free water and air and protection against hazardous industries. 3. Right to livelihood. 4. Right to privacy. 5. Right to shelter. 6. Right to health. 7. Right to free education up to 14 years of age. 8. Right to free legal aid. 9. Right against solitary confinement. 10. Right to speedy trial. 11. Right against handcuffing. 12. Right against inhuman treatment. 13. Right against delayed execution. 14. Right to travel abroad. 15. Right against bonded labor. 16. Right against custodial harassment. 17. Right to emergency medical aid. 18. Right to timely medical treatment in government hospital. 19. Right not to be driven out of a state. 20. Right to fair trial. 21. Right of prisoner to have necessities of life. 22. Right of women to be treated with decency and dignity. 23. Right against public hanging. 24. Right to hearing. 25. Right to information. 26. Right to reputation. 27. Right of appeal from a judgment of conviction. 28. Right to social security and protection of the family. 29. Right to social and economic justice and empowerment. 30. Right against malefactors. 31. Right to appropriate life insurance policy. 32. Right to sleep. 33. Right to freedom from noise pollution. 34. Right to electricity. 4. Right to education. Article 21 declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only elementary education a fundamental right and not higher or professional education. This provision was added by the 86th Constitutional Amendment Act of 2002. This amendment is a major milestone in the country's aim to achieve education for all. The government described this step as the dawn of the second revolution in the chapter of citizens' rights. Even before this amendment, the Constitution contained a provision for free and compulsory education for children under Article 45 in Part 4. However, being a directive principle, it was not enforceable by the courts. Now, there is scope for judicial intervention in this regard. This amendment changed the subject matter of Article 45 in Directive Principles. It now reads, the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. It also added a new fundamental duty under Article 5(1) that reads, it shall be the duty of every citizen of India to provide opportunities for education to his child or ward between the age of 6 and 14 years. In 1993 itself, the Supreme Court recognized a fundamental right to primary education in the right to life under Article 21. It held that every child or citizen of this country has a right to free education until he completes the age of 14 years. Thereafter, his right to education is subject to the limits of economic capacity and development of the state. In this judgment, the court overruled its earlier judgment, 1992, which declared that there was a fundamental right to education up to any level including professional education like medicine and engineering. In pursuance of Article 2(1), the Parliament enacted the Right of Children to Free and Compulsory Education, RTE, Act, 2009. This Act seeks to provide that every child has the right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. This legislation is anchored in the belief that the values of equality, social justice and democracy and the creation of a just and humane society can be achieved only through provision of inclusive elementary education to all. 12(5) Protection against arrest and detention. Article 22 grants protection to persons who are arrested or detained. Detention is of two types, namely, punitive and preventive. Punitive detention is to punish a person for an offense committed by him after trial and conviction in a court. Preventive detention, on the other hand, means detention of a person without trial and conviction by a court. Its purpose is not to punish a person for a past offense but to prevent him from committing an offense in the near future. Thus, preventive detention is only a precautionary measure and based on suspicion. The Article 22 has two parts. The first part deals with the cases of ordinary law and the second part deals with the cases of preventive detention law. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. I. Right to be informed of the grounds of arrest. 2. Right to consult and be defended by a legal practitioner. 3. Right to be produced before a magistrate within 24 hours, excluding the journey time. 4. Right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. The Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of a court, civil arrest, arrest on failure to pay the income tax, and deportation of an alien. They apply only to an act of a criminal or quasi-criminal nature or some activity prejudicial to public interest. B. The second part of Article 22 grants protection to persons who are arrested or detained under the preventive detention law. This protection is available to both citizens as well as aliens and includes the following. I. The detention of a person cannot exceed 3 months unless an advisory board reports sufficient cause for extended detention. The board is to consist of judges of a high court. 2. The grounds of detention should be communicated to the detainee. However, the facts considered to be against the public interest need not be disclosed. 3. The detainee should be afforded an opportunity to make a representation against the detention order. Article 22 also authorizes the Parliament to prescribe the circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. B. The maximum period for which a person can be detained in any classes of cases under a preventive detention law. And C. The procedure to be followed by an advisory board in an inquiry. The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. However, this provision has not yet been brought into force, hence, the original period of 3 months still continues. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislatures. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with defence, foreign affairs and the security of India. Both the Parliament as well as the state legislatures can concurrently make a law of preventive detention for reasons connected with the security of a state, the maintenance of public order and the maintenance of supplies and services essential to the community. The preventive detention laws made by the Parliament are a. Preventive Detention Act, 1950. Expired in 1969. B. Maintenance of Internal Security Act, MISA, 1971. Repealed in 1978. C. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, COFEPOSA, 1974. D. National Security Act, NASA, 1980. E. Prevention of black marketing and maintenance of supplies of essential Commodities Act, BMSICA, 1980. F. Terrorist and Disruptive Activities Prevention Act, TADA, 1985. Repealed in 1995. G. Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, PITNPSA, 1988. H. Prevention of Terrorism Act, POTA, 2002. Repealed in 2004. It is unfortunate to know that no democratic country in the world has made preventive detention as an integral part of the Constitution as has been done in India. It is unknown in USA. It was resorted to in Britain only during First and Second World War time. In India, preventive detention existed even during the British rule. For example, the Bengal State Prisoners Regulation of 1818 and the Defence of India Act of 1939 provided for preventive detention. Right against exploitation 1. Prohibition of traffic in human beings and forced labour. Article 23 prohibits traffic in human beings, bigar, forced labour, and other similar forms of forced labour. Any contravention of this provision shall be an offence punishable in accordance with law. This right is available to both citizens and non-citizens. It protects the individual not only against the state but also against private persons. The expression, traffic in human beings include a. Selling and buying of men, women and children like goods, b. Immoral traffic in women and children, including prostitution, c. Devdasis, and d. Slavery. To punish these acts, the Parliament has made the Immoral Traffic Prevention Act 13, 1956. The term bigar means compulsory work without remuneration. It was a peculiar Indian system under which the local zamindars sometimes used to force their tenants to render services without any payment. In addition to bigar, the Article 23 prohibits other, similar forms of forced labor, like bonded labor. The term, forced labor, means compelling a person to work against his will. The word, force, includes not only physical or legal force but also force arising from the compulsion of economic circumstances. That is, working for less than the minimum wage. In this regard, the Bonded Labor System, Abolition, Act, 1976, the Minimum Wages Act, 1948, the Contract Labor Act, 1970 and the Equal Remuneration Act, 1976 were made. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purposes, as for example, military service or social service, for which it is not bound to pay. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste or class. 2. Prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine or other hazardous activities like construction work or railway. But it does not prohibit their employment in any harmless or innocent work. The Child Labor, Prohibition and Regulation, Act, 1986, is the most important law in this direction. In addition, the Employment of Children Act, 1938, the Factories Act, 1948, the Mines Act, 1952, the Merchant Shipping Act, 1958, the Plantation Labor Act, 1951, the Motor Transport Workers Act, 1951, Apprentices Act, 1961, the Bidi and Cigar Workers Act, 1966, and other similar acts prohibit the employment of children below certain age. In 1996, the Supreme Court directed the establishment of Child Labor Rehabilitation Welfare Fund in which the offending employer should deposit a fine of 20,000 for each child employed by him. It also issued directions for the improvement of education, health and nutrition of children. The Commissions for Protection of Child Rights Act, 2005 was enacted to provide for the establishment of a National Commission and State Commissions for Protection of Child Rights and Children's Courts for providing speedy trial of offences against children or of violation of child rights. In 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dhabas, restaurants, shops, factories, resorts, spas, tea shops and so on. It warned that anyone employing children below 14 years of age would be liable for prosecution and penal action. Child Labor Amendment, 2016, the Child Labor, Prohibition and Regulation, Amendment Act, 2016, amended the Child Labor, Prohibition and Regulation, Act, 1986. It has renamed the Principal Act as the Child and Adolescent Labor, Prohibition and Regulation, Act, 1986. The Amendment Act prohibits the employment of children below 14 years in all occupations and processes. Earlier, this prohibition was applicable to 18 occupations and 65 processes. Further, the Amendment Act prohibits the employment of adolescents, 14 to 18 years of age, in certain hazardous occupations and processes. The Amendment Act also introduces more stringent punishment for the offenders. It is an imprisonment of 6 months to 2 years, or a fine of 20,000 to 50,000, or both. In case of repeated offences, the imprisonment is of 1 year to 3 years. Right to freedom of religion 1. Freedom of conscience and free profession, practice and propagation of religion. Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. The implications of these are: a. Freedom of conscience, in the freedom of an individual to mold his relation with God or creatures in whatever way he desires. b. right to profess, declaration of one's religious beliefs and faith openly and freely. C. Right to practice, performance of religious worship, rituals, ceremonies and exhibition of beliefs and ideas. D. Right to propagate, transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion. But it does not include a right to convert another person to one's own religion. Forcible conversions impinge on the freedom of conscience, guaranteed to all the persons alike. From the above, it is clear that Article 25 covers not only religious beliefs, doctrines, but also religious practices, rituals. Moreover, these rights are available to all persons, citizens as well as non-citizens. However, these rights are subject to public order, morality, health and other provisions relating to fundamental rights. Further, the state is permitted to a. Regulate or restrict any economic, financial, political or other secular activity associated with religious practice, and b. Provide for social welfare and reform or throw open Hindu religious institutions of a public character to all classes and sections of Hindus. Article 25 also contains two explanations. 1. Wearing and carrying of kirpans is to be included in the profession of the Sikh religion, and 2. The Hindus, in this context, include Sikhs, Jains and Buddhists. 14.2. Freedom to manage religious affairs. According to Article 26, every religious denomination or any of its sections shall have the following rights. A. Right to establish and maintain institutions for religious and charitable purposes. B. Right to manage its own affairs in matters of religion. C. Right to own and acquire movable and immovable property. And D. Right to administer such property in accordance with law. Article 25 guarantees rights of individuals, while Article 26 guarantees rights of religious denominations or their sections. In other words, Article 26 protects collective freedom of religion. Like the rights under Article 25, the rights under Article 26 are also subject to public order, morality and health but not subject to other provisions relating to the fundamental rights. The Supreme Court held that a religious denomination must satisfy three conditions. A. It should be a collection of individuals who have a system of beliefs, doctrines, which they regard as conducive to their spiritual well-being. B. It should have a common organization. And C. It should be designated by a distinctive name. Under the above criteria, the Supreme Court held that the Ramakrishna Mission and Ananda Marga are religious denominations within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. 3. Freedom from taxation for promotion of a religion. Article 27 lays down that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. In other words, the state should not spend the public money collected by way of tax for the promotion or maintenance of any particular religion. This provision prohibits the state from favoring, patronizing and supporting one religion over the other. This means that the taxes can be used for the promotion or maintenance of all religions. This provision prohibits only levy of a tax and not a fee. This is because the purpose of a fee is to control secular administration of religious institutions and not to promote or maintain religion. Thus, a fee can be levied on pilgrims to provide them some special service or safety measures. Similarly, a fee can be levied on religious endowments for meeting the regulation expenditure. 4. Freedom from attending religious instruction. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of state funds. However, this provision shall not apply to an educational institution administered by the state but established under any endowment or trust, requiring imparting of religious instruction in such institution. Further, no person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to attend any religious instruction or worship in that institution without his consent. In case of a minor, the consent of his guardian is needed. Thus, Article 28 distinguishes between four types of educational institutions. A. Institutions wholly maintained by the state. B. Institutions administered by the state but established under any endowment or trust. C. Institutions recognized by the state. D. Institutions receiving aid from the state. In A. Religious instruction is completely prohibited, while in B. Religious instruction is permitted. In C and D. Religious instruction is permitted on a voluntary basis. Cultural and educational rights. 1. Protection of interests of minorities. Article 29 provides that any section of the citizens residing in any part of India having a distinct language, script or culture of its own, shall have the right to conserve the same. Further, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, or language. The first provision protects the right of a group, while the second provision guarantees the right of a citizen as an individual irrespective of the community to which he belongs. Article 29 grants protection to both religious minorities as well as linguistic minorities. However, the Supreme Court held that the scope of this article is not necessarily restricted to minorities only, as it is commonly assumed to be. This is because of the use of words, section of citizens in the article that include minorities as well as majority. The Supreme Court also held that the right to conserve the language includes the right to agitate for the protection of the language. Hence, the political speeches or promises made for the conservation of the language of a section of the citizens does not amount to corrupt practice under the Representation of the People Act, 1951. 2. Right of minorities to establish and administer educational institutions. Article 30 grants the following rights to minorities, whether religious or linguistic. A. All minorities shall have the right to establish and administer educational institutions of their choice. B. The compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. This provision was added by the 44th Amendment Act of 1978 to protect the right of minorities in this regard. The Act deleted the right to property as a fundamental right. Article 31. C. In granting aid, the state shall not discriminate against any educational institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious or linguistic, and does not extend to any section of citizens, as under Article 29. However, the term minority has not been defined anywhere in the Constitution. The right under Article 30 also includes the right of a minority to impart education to its children in its own language. Minority educational institutions are of three types. A. Institutions that seek recognition as well as aid from the state. B. Institutions that seek only recognition from the state and not aid. And C. Institutions that neither seek recognition nor aid from the state. The institutions of first and second type are subject to the regulatory power of the state with regard to syllabus prescription, academic standards, discipline, sanitation, employment of teaching staff, and so on. The institutions of third type are free to administer their affairs but subject to operation of general laws like contract law, labor law, industrial law, tax law, economic regulations, and so on. In a judgment delivered in the Secretary of Malankara Syrian Catholic College Case 14A, 2007, the Supreme Court has summarized the general principles relating to establishment and administration of minority educational institutions in the following way. 1. The right of minorities to establish and administer educational institutions of their choice comprises the following rights. I. To choose its governing body in whom the founders of the institution have faith and confidence to conduct and manage the affairs of the institution. 2. To appoint teaching staff, teachers, lecturers, and headmasters, principals, as also non-teaching staff, and to take action if there is dereliction of duty on the part of any of its employees. 3. To admit eligible students of their choice and to set up a reasonable fee structure. And 4. to use its properties and assets for the benefit of the institution. 2. The right conferred on minorities under Article 30 is only to ensure equality with the majority and not intended to place the minorities in a more advantageous position vis-à-vis the majority. There is no reverse discrimination in favor of minorities. The general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc., applicable to all, will equally apply to minority institutions also. 3. The right to establish and administer educational institutions is not absolute. Nor does it include the right to maladminister. There can be regulatory measures for ensuring educational character and standards and maintaining academic excellence. There can be checks on administration as are necessary to ensure that the administration is efficient and sound, so as to serve the academic needs of the institution. Regulations made by the state concerning generally the welfare of students and teachers, regulations laying down eligibility criteria and qualifications for appointment, as also conditions of service of employees, both teaching and non-teaching, regulations to prevent exploitation or oppression of employees, and regulations prescribing syllabus and curriculum of study fall under this category. Such regulations do not in any manner interfere with the right under Article 30, 1. 4. Subject to the eligibility conditions qualifications prescribed by the state being met, the unaided minority educational institutions will have the freedom to appoint teachers lecturers by adopting any rational procedure of selection. 5. Extension of aid by the state does not alter the nature and character of the minority educational institutions. The conditions can be imposed by the state to ensure proper utilization of the aid, without however diluting or abridging the right under Article 30, 1. Right to constitutional remedies. A mere declaration of fundamental rights in the Constitution is meaningless, useless and worthless without providing an effective machinery for their enforcement, if and when they are violated. Hence, Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental rights protected is in itself a fundamental right. This makes the fundamental rights real. That is why Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abridged or taken away even by way of an amendment to the Constitution. It contains the following 4 provisions. A. The right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental rights is guaranteed. B. The Supreme Court shall have power to issue directions or orders or writs for the enforcement of any of the fundamental rights. The writs issued may include a habeas corpus, mandamus, prohibition, certiorari and quo warranto. C. Parliament can empower any other court to issue directions, orders and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. Any other court here does not include high courts because Article 226 has already conferred these powers on the high courts. D. The right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Thus the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental rights during a national emergency. Article 359. It is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental rights of the citizens. It has been vested with the original and wide powers for that purpose. Original, because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Wide, because its power is not restricted to issuing of orders or directions but also writs of all kinds. The purpose of Article 32 is to provide a guaranteed, effective, expeditious, inexpensive and summary remedy for the protection of the fundamental rights. only the fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other right like non-fundamental constitutional rights, statutory rights, customary rights and so on. The violation of a fundamental right is the sine qua non for the exercise of the right conferred by Article 32. In other words, the Supreme Court, under Article 32, cannot determine a question that does not involve fundamental rights. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or a legislation unless it directly infringes any of the fundamental rights. In case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. It vests original powers in the High Court to issue directions, orders and writs of all kinds for the enforcement of the fundamental rights. It means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Since the right guaranteed by Article 32, i.e., the right to move the Supreme Court where a fundamental right is infringed, is in itself a fundamental right, the availability of alternate remedy is no but to relief under Article 32. However, the Supreme Court has ruled that where relief through High Court is available under Article 226, the aggrieved party should first move the High Court. Writs, types and scope the Supreme Court, under Article 32, and the High Courts, under Article 226, can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. Further, the Parliament, under Article 32, can empower any other court to issue these writs. Since no such provision has been made so far, only the Supreme Court and the High Courts can issue the writs and not any other court. Before 1950, only the High Courts of Calcutta, Bombay and Madras had the power to issue the writs. Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king who was, and is still, described as the fountain of justice. Later, the High Court started issuing these writs as extraordinary remedies to uphold the rights and liberties of the British people. The writ jurisdiction of the Supreme Court differs from that of a High Court in three respects. 1. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas a High Court can issue writs not only for the enforcement of fundamental rights but also for any other purpose. The expression, for any other purpose, refers to the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court, in this respect, is narrower than that of High Court. 2. The Supreme Court can issue writs against a person or government throughout the territory of India, whereas a High Court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. 15. Thus, the territorial jurisdiction of the Supreme Court for the purpose of issuing writs is wider than that of a High Court. 3. The remedy under Article 32 is in itself a fundamental right and hence, the Supreme Court may not refuse to exercise its writ jurisdiction. On the other hand, a remedy under Article 226 is discretionary and hence, a High Court may refuse to exercise its writ jurisdiction. Article 32 does not merely confer power on the Supreme Court as Article 226 does on a High Court to issue writs for the enforcement of fundamental rights or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as a defender and guarantor of the fundamental rights. Now, we will proceed to understand the meaning and scope of different kinds of writs mentioned in Articles 32 and 226 of the Constitution. Habeas corpus, it is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person, to produce the body of the latter before it. The court then examines the cause and legality of detention. It would set the detained person free, if the detention is found to be illegal. Thus, This writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the a. detention is lawful, b. the proceeding is for contempt of a legislature or a court, c. detention is by a competent court, and d. detention is outside the jurisdiction of the court. Mandamus, it literally means, we command. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal or government for the same purpose. The writ of mandamus cannot be issued, a. against a private individual or body, b. to enforce departmental instruction that does not possess statutory force, c. when the duty is discretionary and not mandatory, d. to enforce a contractual obligation, e. against the President of India or the state governors, and f. against the Chief Justice of a High Court acting in judicial capacity. Prohibition literally, it means, to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus that directs activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari in the literal sense, it means, to be certified, or, to be informed. It is issued by a higher court to a lower court or tribunal either to transfer a case pending with the latter to itself or to squash the order of the latter in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. Previously, the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting rights of individuals. Like prohibition, certiorari is also not available against legislative bodies and private individuals or bodies. Quo warranto in the literal sense, it means, by what authority or warrant. It is issued by the court to enquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. The writ can be issued only in case of a substantive public office of a permanent character created by a statute or by the Constitution. It cannot be issued in cases of ministerial office or private office. Unlike the other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. Armed Forces and Fundamental Rights Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous forces. The objective of this provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on Parliament and not on state legislatures. Any such law made by Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Accordingly, the Parliament has enacted the Army Act, 1950, the Navy Act, 1950, the Air Force Act, 1950, the Police Forces, Restriction of Rights, Act, 1966, the Border Security Force Act and so on. These impose restrictions on their freedom of speech, right to form associations, right to be members of trade unions or political associations, right to communicate with the press, right to attend public meetings or demonstrations, etc. The expression members of the armed forces also covers such employees of the armed forces as barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors who are non-combatants. A parliamentary law enacted under Article 33 can also exclude the court-martials, tribunals established under the military law, from the writ jurisdiction of the Supreme Court and the High Courts, so far as the enforcement of fundamental rights is concerned. Table 7.3 Martial Law vs. National Emergency. Martial Law. National Emergency. 1. It affects only fundamental rights. 1. It affects not only fundamental rights but also center-state relations, distribution of revenues and legislative powers between center and states, and may extend the tenure of the parliament. 2. It suspends the government and ordinary law courts. 2. It continues the government and ordinary law courts. 3. It is imposed to restore the breakdown of law. 3. It can be imposed only on 3 grounds: war, an order due to any external aggression or armed rebellion. Reason: 4. It is imposed in 4. It is imposed either in the whole country or in any some specific area part of the country. 5. It has no specific provision in the 5. It has specific and detailed provision in the Constitution. It is Constitution. It is explicit. Implicit. Martial law and fundamental rights. Article 34 provides for the restrictions on fundamental rights while martial law is in force in any area within the territory of India. It empowers the Parliament to indemnify any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law was in force. The Parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered or other act done under martial law in such area. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. The concept of martial law has been borrowed in India from the English common law. However, the expression, martial law, has not been defined anywhere in the Constitution. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary law. It thus implies the suspension of ordinary law and the government by military tribunals. It is different from the military law that is applicable to the armed forces. There is also no specific or express provision in the Constitution that authorizes the executive to declare martial law. However, it is implicit in Article 34 under which martial law can be declared in any area within the territory of India. The martial law is imposed under the extraordinary circumstances like war, invasion, insurrection, rebellion, riot or any violent resistance to law. Its justification is to repel force by force for maintaining or restoring order in the society. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of the civilians, can punish the civilians and even condemn them to death. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. The declaration of a martial law under Article 34 is different from the declaration of a national emergency under Article 352. The differences between the two are summarized in Table 7.3. Affecting certain fundamental rights. Article 35 lays down that the power to make laws, to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislatures. This provision ensures that there is uniformity throughout India with regard to the nature of those fundamental rights and punishment for their infringement. In this direction, Article 35 contains the following provisions: 1. The Parliament shall have, and the legislature of a state shall not have, power to make laws with respect to the following matters: a. Prescribing residence as a condition for certain employments or appointments in a state or union territory or local authority or other authority, Article 16. b. Empowering courts other than the Supreme Court and the High Courts to issue directions, orders and writs of all kinds for the enforcement of fundamental rights, Article 32. c. Restricting or abrogating the application of fundamental rights to members of armed forces, police forces, etc., Article 33. d. Indemnifying any government servant or any other person for any act done during the operation of martial law in any area, Article 34. 2. Parliament shall have, and the legislature of a state shall not have, powers to make laws for prescribing punishment for those acts that are declared to be offences under the fundamental rights. These include the following: A. Untouchability, Article 17. B. Traffic in human beings and forced labor, Article 23. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishment for the above acts, thus making it obligatory on the part of the Parliament to enact such laws. 3. Any law in force at the commencement of the Constitution with respect to any of the matters specified above is to continue in force until altered or repealed or amended by the Parliament. It should be noted that Article 35 extends the competence of the Parliament to make a law on the matters specified above, even though some of those matters may fall within the sphere of the state legislatures, i.e., state list. Present position of right to property. Originally, the right to property was one of the 7 fundamental rights under Part 3 of the Constitution. It was dealt by Article 19, 1, f, and Article 31. Article 19, 1, f, guaranteed to every citizen the right to acquire, hold and dispose of property. Article 31, on the other hand, guaranteed to every person, whether citizen or non-citizen, right against deprivation of his property. It provided that no person shall be deprived of his property except by authority of law. It empowered the state to acquire or requisition the property of a person on 2 conditions: A. It should be for public purpose, and B. It should provide for payment of compensation, amount, to the owner. Since the commencement of the Constitution, the fundamental right to property has been the most controversial. It has caused confrontations between the Supreme Court and the Parliament. It has led to a number of constitutional amendments, that is, 1st, 4th, 7th, 25th, 39th, 40th and 42nd Amendments. Through these amendments, Articles 31A, 31B and 31C have been added and modified from time to nullify the effect of Supreme Court judgments and to protect certain laws from being challenged on the grounds of contravention of fundamental rights. Most of the litigation centered around the obligation of the state to pay compensation for acquisition or requisition of private property. Therefore, the 44th Amendment Act of 1978 abolished the right to property as a fundamental right by repealing Article 19, 1, f, and Article 31 from Part 3. Instead, the Act inserted a new Article 300 in Part 12 under the heading, Right to Property. It provides that no person shall be deprived of his property except by authority of law. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. The right to property as a legal right, as distinct from the fundamental rights, has the following implications: A. It can be regulated, i.e., curtailed, abridged or modified without constitutional amendment by an ordinary law of the Parliament. B. It protects private property against executive action but not against legislative action. C. In case of violation, the aggrieved person cannot directly move the Supreme Court under Article 32, right to constitutional remedies including writs, for its enforcement. He can move the High Court under Article 226. D. No guaranteed right to compensation in case of acquisition or requisition of the private property by the state. Though the fundamental right to property under Part 3 has been abolished, the Part 3 still carries 2 provisions which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. These 2 cases where compensation has to be paid are: A. When the state acquires the property of a minority educational institution, Article 30, and B. When the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limits, Article 31A. The first provision was added by the 44th Amendment Act, 1978, while the second provision was added by the 17th Amendment Act, 1964. Further, Articles 31A, 31B and 31C have been retained as exceptions to the fundamental rights. Exceptions to fundamental rights. 1. Saving of laws providing for acquisition of estates, etc. Article 31A(16) saves 5 categories of laws from being challenged and invalidated on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, and Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. They are related to agricultural land reforms, industry and commerce and include the following: a. Acquisition of estates 17 and related rights by the state, b. Taking over the management of properties by the state, c. Amalgamation of corporations, d. Extinguishment or modification of rights of directors or shareholders of corporations, and e. Extinguishment or modification of mining leases. Article 3(1) does not immunize a state law from judicial review unless it has been reserved for the President's consideration and has received his assent. This article also provides for the payment of compensation at market value when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limit. 2. Validation of certain acts and regulations. Article 31B saves the acts and regulations included in the 9th Schedule 18 from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Thus, the scope of Article 31B is wider than Article 31A. Article 31B immunizes any law included in the 9th Schedule from all the fundamental rights whether or not the law falls under any of the 5 categories specified in Article 31A. However, in a significant judgment delivered in I.R. Coelhone Case 18A, 2007, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the 9th Schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th Schedule. It said that the laws placed under the 9th Schedule after 24 April 1973 are open to challenge in court if they violated fundamental rights guaranteed under Articles 14, 15, 19 and 21 or the basic structure of the Constitution. It was on 24 April 1973 that the Supreme Court first propounded the doctrine of basic structure or basic features of the Constitution in its landmark verdict in the Keswananda Vati Case 19. Originally, in 1951, the 9th Schedule contained only 13 acts and regulations, but at present, in 2016, their number is 282.20 of these. The acts and regulations of the state legislature deal with land reforms and abolition of the zamindari system, and that of the parliament deal with other matters. 3. Saving of laws giving effect to certain directive principles. Article 31C, as inserted by the 25th Amendment Act of 1971, contained the following 2 provisions: a. No law that seeks to implement the socialistic directive principles specified in Article 39, b. 21 or c. 22 shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, or Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. b. No law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Keswananda Vati Case 23, 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. The 42nd Amendment Act, 1976, extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles specified in Part 4 of the Constitution and not merely in Article 39, b. or c. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills Case 24, 1980. Criticism of fundamental rights. The fundamental rights enshrined in Part 3 of the Constitution have met with a wide and varied criticism. The arguments of the critics are: 1. Excessive limitations. They are subjected to innumerable exceptions, restrictions, qualifications and explanations. Hence, the critics remarked that the Constitution grants fundamental rights with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental rights should be renamed as Limitations on Fundamental Rights or Fundamental Rights and Limitations Thereon. 2. No social and economic rights. The list is not comprehensive as it mainly consists of political rights. It makes no provision for important social and economic rights like right to social security, right to work, right to employment, right to rest and leisure, and so on. These rights are made available to the citizens of advanced democratic countries. Also, the socialistic constitutions of erstwhile USSR or China provided for such rights. 3. No clarity. They are stated in a vague, indefinite and ambiguous manner. The various phrases and words used in the chapter like public order, minorities, reasonable restriction, public interest, and so on are not clearly defined. The language used to describe them is very complicated and beyond the comprehension of the common man. It is alleged that the Constitution was made by the lawyers for the lawyers. Sir Ivor Jennings called the Constitution of India a paradise for lawyers. 4. No permanency. They are not sacrosanct or immutable as the Parliament can curtail or abolish them, as for example, the abolition of the fundamental right to property in 1978. Hence, they can become a play tool in the hands of politicians having majority support in the Parliament. The judicially innovated doctrine of basic structure is the only limitation on the authority of Parliament to curtail or abolish the fundamental right. 5. Suspension during emergency. The suspension of their enforcement during the operation of national emergency, except Articles 20 and 21, is another blot on the efficacy of these rights. This provision cuts at the roots of democratic system in the country by placing the rights of the millions of innocent people in continuous jeopardy. According to the critics, the fundamental rights should be enjoyable in all situations, emergency or no emergency. 6. Expensive remedy. The judiciary has been made responsible for defending and protecting these rights against the interference of the legislatures and executives. However, the judicial process is too expensive and hinders the common man from getting his rights enforced through the courts. Hence, the critics say that the rights benefit mainly the rich section of the Indian society. 7. Preventive detention. The critics assert that the provision for preventive detention, Article 22, takes away the spirit and substance of the chapter on fundamental rights. It confers arbitrary powers on the state and negates individual liberty. It justifies the criticism that the Constitution of India deals more with the rights of the state against the individual than with the rights of the individual against the state. Notably, no democratic country in the world has made preventive detention as an integral part of their constitutions as has been made in India. 8. No consistent philosophy. According to some critics, the chapter on fundamental rights is not the product of any philosophical principle. Sir Ivor Jennings expressed this view when he said that the fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. 25. The critics say that this creates difficulty for the Supreme Court and the High Courts in interpreting the fundamental rights. Significance of fundamental rights. In spite of the above criticism and shortcomings, the fundamental rights are significant in the following respects. 1. They constitute the bedrock of democratic system in the country. 2. They provide necessary conditions for the material and moral protection of man. 3. They serve as a formidable bulwark of individual liberty. 4. They facilitate the establishment of rule of law in the country. 5. They protect the interests of minorities and weaker sections of society. 6. They strengthen the secular fabric of the Indian state. 7. They check the absoluteness of the authority of the government. 8. They lay down the foundation stone of social equality and social justice. 9. They ensure the dignity and respect of individuals. 10. They facilitate the participation of people in the political and administrative process. Rights outside Part 3. Besides the fundamental rights included in Part 3, there are certain other rights contained in other parts of the Constitution. These rights are known as constitutional rights or legal rights or non-fundamental rights. They are: 1. No tax shall be levied or collected except by authority of law, Article 265 in Part 12. 2. No person shall be deprived of his property save by authority of law, Article 300 in Part 12. 3. Trade, commerce and intercourse throughout the territory of India shall be free, Article 301 in Part 13. 4. The elections to the Lok Sabha and the State Legislative Assembly shall be on the basis of adult suffrage, Article 326 in Part 15. Even though the above rights are also equally justiciable, they are different from the fundamental rights. In case of violation of a fundamental right, the aggrieved person can directly move the Supreme Court for its enforcement under Article 32, which is in itself a fundamental right. But, in case of violation of the above rights, the aggrieved person cannot avail this constitutional remedy. He can move the High Court by an ordinary suit or under Article 226, writ jurisdiction of High Court. Table 7.4 Articles related to fundamental rights at a glance. Article No. Subject Matter General 12. Definition of State 13. Laws inconsistent with or in derogation of the fundamental rights. Right to equality 14. Equality before law 15. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth 16. Equality of opportunity in matters of public employment 17. Abolition of untouchability 18. Abolition of titles. Right to freedom 19. Protection of certain rights regarding freedom of speech, etc. 20. Protection in respect of conviction for offences 21. Protection of life and personal liberty 21a. Right to education. 22. Protection against arrest and detention in certain cases. Article No. Subject Matter Right against exploitation 23. Prohibition of traffic in human beings and forced labor 24. Prohibition of employment of children in factories, etc. Right to freedom of religion 25. Freedom of conscience and free profession, practice and propagation of religion 26. Freedom to manage religious affairs 27. Freedom as to payment of taxes for promotion of any particular religion 28. Freedom as to attendance at religious instruction or religious worship in certain educational institutions. Cultural and educational rights 29. Protection of interests of minorities 30. Right of minorities to establish and administer educational institutions 31. Compulsory acquisition of property, repealed. Saving of certain laws 31a. Saving of laws providing for acquisition of estates, etc. 31b. Validation of certain acts and regulations 31c. Saving of laws giving effect to certain directive principles 31d. Saving of laws in respect of anti-national activities, repealed. Right to constitutional remedies. 32. Remedies for enforcement of rights conferred by this Part 32a. Constitutional validity of state laws not to be considered in proceedings under Article 32, repealed. 33. Power of Parliament to modify the rights conferred by this part in their application to forces, etc. 34. Restriction on rights conferred by this part while martial law is in force in any area 35. Legislation to give effect to the provisions of this part. Notes and references. 1. Magna Carta is the Charter of Rights issued by King John of England in 1215 under pressure from the barons. This is the first written document relating to the fundamental rights of citizens. 2. Case 1 under Bharti vs. State of Kerala, 1973. 3. Dicey observe, no man is above the law, but every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. every official from the Prime Minister down to a constable or a collector of taxes, is under the same responsibility for every act done without legal justification as any other citizen. A wee dicey Introduction to the Study of the Law of the Constitution, Macmillan, 1931 edition p. 183191. For this second provision was added by the First Amendment Act of 1951. 5. By virtue of Article 371d inserted by the 32nd Amendment Act of 1973. 5a Article 371d has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act, 2014. 6. The first Backward Classes Commission was appointed in 1953 under the chairmanship of Kaka Kalalka. It submitted its report in 1955. 7. In 1963, the Supreme Court ruled that more than 50% reservation of jobs in a single year would be unconstitutional. 8. Indira Sohni v. Union of India, 1992. 9. The Tamil Nadu Backward Classes, Scheduled Castes and Scheduled Tribes, Reservation of Seats in Educational Institutions and of Appointments or Posts in the Services under the State Act, 1994. 10. Balaji Raghavan v. Union of India, 1996. 10a. The provision for cooperative societies was made by the 97th Constitutional Amendment Act of 2011. 10b. Ibid 11. A.K. Gopalan v. State of Madras, 1950. 12. Maneka Gandhi v. Union of India, 1978. 12a. The Constitution, 86th Amendment, Act, 2002 and the Right of Children to Free and Compulsory Education Act, 2009 have come into force with 1st April 2010. 13. Originally known as the Suppression of Immoral Traffic in Women and Girls Act, 1956. 14. In this clause, the reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jaina and Buddhist religion, and the reference to Hindu religious institutions shall be construed accordingly. Article 25. 14a. Secretary of the Malankara Syrian Catholic College vs. T. Jose, 2007. 15. The second provision was added by the 15th Constitutional Amendment Act of 1963. 16. Added by the first Constitutional Amendment Act of 1951 and amended by the 4th, 17th and 44th Amendments. 17. The expression estate includes any jagir, inam, mulfi or other similar grant, any Janman right in Tamil Nadu and Kerala and any land held for agricultural purposes. 18. Article 31b along with the 9th schedule was added by the first Constitutional Amendment Act of 1951. 18a. Ayya Koelhone vs. State of Tamil Nadu, 2007. 19. Keswananda Bharti v. State of Kerala, 1973. 20. Though the last entry is numbered 284, the actual total number is 282. This is because the three entries, 87, 92 and 130, have been deleted and one entry is numbered as 257A. 21. Article 39b says, the state shall direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. 22. Article 39c says, the state shall direct its policy towards securing that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. 23. Eswananda Bharti v. State of Kerala, 1973. 24. Minerva Mills v. Union of India, 1980. 25. Sir Ivor Jennings wrote, a thread of 19th century liberalism runs through it. There are consequences of the political problems of Britain in it. There are relics of the bitter experience in opposition to British rule. And there is evidence of a desire to reform some of the social institutions which time and circumstances have developed in India. The result is a series of complex formulae, in 24 articles, some of them lengthy, which must become the basis of a vast and complicated case law. Directive principles of state policy. Directive principles of state policy are enumerated in Part 4 of the Constitution from Articles 36 to 511. The framers of the Constitution borrowed this idea from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. Dr. B.R. Ambedkar described these principles as novel features of the Indian Constitution. The directive principles along with the fundamental rights contain the philosophy of the Constitution and is the soul of the Constitution. Granville Austin has described the directive principles and the fundamental rights as the conscience of the Constitution. 2. Features of the directive principles. 1. The phrase, directive principles of state policy, denotes the ideals that the state should keep in mind while formulating policies and enacting laws. These are the constitutional instructions or recommendations to the state in legislative, executive and administrative matters. According to Article 36, the term, state, in Part 4 has the same meaning as in Part 3 dealing with fundamental rights. Therefore, it includes the legislative and executive organs of the central and state governments, all local authorities and all other public authorities in the country. 2. The directive principles resemble the instrument of instructions enumerated in the Government of India Act of 1935. In the words of Dr. B.R. Ambedkar, the directive principles are like the instrument of instructions, which were issued to the Governor-General and to the governors of the colonies of India by the British government under the Government of India Act of 1935. What is called directive principles is merely another name for the instrument of instructions. The only difference is that they are instructions to the legislature and the executive. 3. The directive principles constitute a very comprehensive economic, social and political program for a modern democratic state. They aim at realizing the high ideals of justice, liberty, equality and fraternity as outlined in the preamble to the Constitution. They embody the concept of a welfare state, and not that of a police state, which existed during the colonial era. 3. In brief, they seek to establish economic and social democracy in the country. 4. The directive principles are non-justiciable in nature, that is, they are not legally enforceable by the courts for their violation. Therefore, the government, central, state and local, cannot be compelled to implement them. Nevertheless, the Constitution, Article 37, itself says that these principles are fundamental in the governance of the country and it shall be the duty of the state to apply these principles in making laws. 5. The directive principles, though non-justiciable in nature, help the courts in examining and determining the constitutional validity of a law. The Supreme Court has ruled many a times that in determining the constitutionality of any law, if a court finds that the law in question seeks to give effect to a directive principle, it may consider such law to be reasonable in relation to Article 14, equality before law, or Article 19, 6 freedoms, and thus save such law from unconstitutionality. Classification of the directive principles. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into 3 broad categories, viz., socialistic, Gandhian and liberal intellectual. Socialistic principles. These principles reflect the ideology of socialism. They lay down the framework of a democratic socialist state, aimed at providing social and economic justice, and set the path towards welfare state. They direct the state, 1. To promote the welfare of the people by securing a social order permeated by justice, social, economic and political, and to minimize inequalities in income, status, facilities and opportunities. 4. Article 38. 2. To secure the right to adequate means of livelihood for all citizens. B. The equitable distribution of material resources of the community for the common good. C. Prevention of concentration of wealth and means of production. D. Equal pay for equal work for men and women. E. Preservation of the health and strength of workers and children against forcible abuse. And F. Opportunities for healthy development of children. 5. Article 39. 3. To promote equal justice and to provide free legal aid to the poor. 6. Article 39A. 4. To secure the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement. Article 41. 5. To make provision for just and humane conditions of work and maternity relief. Article 42. 6. To secure a living wage. 7. A decent standard of life and social and cultural opportunities for all workers. Article 43. 7. To take steps to secure the participation of workers in the management of industries. 8. Article 43A. 8. To raise the level of nutrition and the standard of living of people and to improve public health. Article 47. Gandhian principles. These principles are based on Gandhian ideology. They represent the program of reconstruction enunciated by Gandhi during the national movement. In order to fulfill the dreams of Gandhi, some of his ideas were included as directive principles. They require the state, 1. To organize village panchayats and endow them with necessary powers, and authority to enable them to function as units of self-government. Article 40. 2. To promote cottage industries on an individual or cooperation basis in rural areas. Article 43. 3. To promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. 8a. Article 43b. 4. To promote the educational and economic interests of SCs, STs, and other weaker sections of the society and to protect them from social injustice and exploitation. Article 46. 5. To prohibit the consumption of intoxicating drinks and drugs which are injurious to health. Article 47. 6. To prohibit the slaughter of cows, calves and other milch and draught cattle and to improve their breeds. Article 48. Liberal intellectual principles. The principles included in this category represent the ideology of liberalism. They direct the state, 1. To secure for all citizens a uniform civil code throughout the country. Article 44. 2. To provide early childhood care and education for all children until they complete the age of 6 years. 9. Article 45. 3. To organize agriculture and animal husbandry on modern and scientific lines. Article 48. 4. To protect and improve the environment and to safeguard forests and wildlife. 10. Article 48a. 5. To protect monuments, places and objects of artistic or historic interest which are declared to be of national importance. Article 49. 6. To separate the judiciary from the executive in the public services of the state. Article 50. 7. To promote international peace and security and maintain just and honorable relations between nations, to foster respect for international law and treaty obligations, and to encourage settlement of international disputes by arbitration. Article 51. New Directive Principles. The 42nd Amendment Act of 1976 added 4 new directive principles to the original list. They require the state, 1. To secure opportunities for healthy development of children. Article 39. 2. To promote equal justice and to provide free legal aid to the poor. Article 39a. 3. To take steps to secure the participation of workers in the management of industries. Article 43a. 4. To protect and improve the environment and to safeguard forests and wildlife. Article 48a. The 44th Amendment Act of 1978 added one more directive principle, which requires the state to minimize inequalities in income, status, facilities and opportunities. Article 38. The 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21a. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. The 97th Amendment Act of 2011 added a new directive principle relating to cooperative societies. It requires the state to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. Article 43b. Sanctioned behind directive principles. Sir B. N. Roy, the constitutional advisor to the Constituent Assembly, recommended that the rights of an individual should be divided into two categories, justiciable and non-justiciable, which was accepted by the drafting committee. Consequently, the fundamental rights, which are justiciable in nature, are incorporated in Part 3, and the directive principles, which are non-justiciable in nature, are incorporated in Part 4 of the Constitution. Though the directive principles are non-justiciable, the Constitution, Article 37, makes it clear that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Thus, they impose a moral obligation on the state authorities for their application, but the real force behind them is political, that is, public opinion. As observed by Alladi Krishna Swami Iyer, no ministry responsible to the people can afford lightheartedly to ignore the provisions in Part 4 of the Constitution. Similarly, Dr. B.R. Ambedkar said in the Constituent Assembly that a government which rests on popular vote can hardly ignore the directive principles while shaping its policy. If any government ignores them, it will certainly have to answer for that before the electorate at the election time. 11. The framers of the Constitution made the directive principles non-justiciable and legally non-enforceable because 1. The country did not possess sufficient financial resources to implement them. 2. The presence of vast diversity and backwardness in the country would stand in the way of their implementation. 3. The newly born independent Indian state with its many preoccupations might be crushed under the burden unless it was free to decide the order, the time, the place and the mode of fulfilling them. The constitution makers, therefore, taking a pragmatic view, refrained from giving teeth to these principles. They believed more in an awakened public opinion rather than in court procedures as the ultimate sanction for the fulfillment of these principles. 12. Criticism of the directive principles. The directive principles of state policy have been criticized by some members of the Constituent Assembly as well as other constitutional and political experts on the following grounds. 1. No legal force. The directives have been criticized mainly because of their non-justiciable character. While K.T. Shah dubbed them as pious superfluities and compared them with a check on a bank, payable only when the resources of the bank permit. 13. Nasiruddin contended that these principles are no better than the New Year's resolutions, which are broken on the 2nd of January. Even as T.T. Krishnamachari described the directives as a veritable dustbin of sentiments, K.C. Weir called them as a manifesto of aims and aspirations and opined that they serve as mere moral homily, and Sir Ivor Jennings thought they are only as pious aspirations. Two illogically arranged critics opine that the directives are not arranged in a logical manner based on a consistent philosophy. According to N. Srinivasan, the directives are neither properly classified nor logically arranged. The declaration mixes up relatively unimportant issues with the most vital economic and social questions. It combines rather incongruously the modern with the old and provisions suggested by the reason and science with provisions based purely on sentiment and prejudice. 14. Sir Ivor Jennings too pointed out that these principles have no consistent philosophy. 3. Conservative. According to Sir Ivor Jennings, the directives are based on the political philosophy of the 19th century England. He remarked, the ghosts of Sidney Webb and Beatrice Webb stalk through the pages of the text. Part 4 of the Constitution expresses Fabian socialism without the socialism. He opined that the directives are deemed to be suitable in India in the middle of the 20th century. The question whether they are suitable for the 21st century cannot be answered, but it is quite probable that they will be entirely outmoded. 15.4. Constitutional conflict. K. Santanam has pointed out that the directives lead to a constitutional conflict, a. between the centre and the states, b. between the President and the Prime Minister, and c. between the Governor and the Chief Minister. According to him, the centre can give directions to the states with regard to the implementation of these principles, and in case of non-compliance, can dismiss the state government. Similarly, when the Prime Minister gets a bill which violates the directive principles, passed by the Parliament, the President may reject the bill on the ground that these principles are fundamental to the governance of the country and hence, the Ministry has no right to ignore them. The same constitutional conflict may occur between the Governor and the Chief Minister at the state level. Utility of directive principles. In spite of the above criticisms and shortcomings, the directive principles are not an unnecessary appendage to the Constitution. The Constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singhvi, an eminent jurist and diplomat, the directives are the life-giving provisions of the Constitution. They constitute the stuff of the Constitution and its philosophy of social justice. 16. M.C. Tugla, former Chief Justice of India, is of the opinion that, if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then be not only democracy in the political sense, but also a welfare state looking after the welfare of its citizens. 17. Dr. B.R. Ambedkar had pointed out that the directives have great value because they lay down that the goal of Indian polity is economic democracy, as distinguished from political democracy. Granville Austin opined that the directive principles are aimed at furthering the goals of the social revolution or to foster this revolution by establishing the conditions necessary for its achievement. 18. Sir B. N. Roy, the constitutional advisor to the Constituent Assembly, stated that the directive principles are intended as moral precepts for the authorities of the state. They have at least an educative value. According to M.C. Setalvad, the former Attorney General of India, the directive principles, although confer no legal rights and create no legal remedies, are significant and useful in the following ways. 1. They are like an instrument of instructions or general recommendations addressed to all authorities in the Indian Union. They remind them of the basic principles of the new social and economic order, which the Constitution aims at building. 2. They have served as useful beacon lights to the courts. They have helped the courts in exercising their power of judicial review, that is, the power to determine the constitutional validity of a law. 3. They form the dominating background to all state action, legislative or executive, and also a guide to the courts in some respects. 4. They amplify the preamble, which solemnly resolves to secure to all citizens of India justice, liberty, equality and fraternity. The directives also play the following roles. 1. They facilitate stability and continuity in domestic and foreign policies in political, economic and social spheres in spite of the changes of the party in power. 2. They are supplementary to the fundamental rights of the citizens. They are intended to fill in the vacuum in Part 3 by providing for social and economic rights. 3. Their implementation creates a favorable atmosphere for the full and proper enjoyment of the fundamental rights by the citizens. Political democracy, without economic democracy, has no meaning. 4. They enable the opposition to exercise influence and control over the operations of the government. The opposition can blame the ruling party on the ground that its activities are opposed to the directives. 5. They serve as a crucial test for the performance of the government. The people can examine the policies and programs of the government in the light of these constitutional declarations. 6. They serve as common political manifesto. A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher and friend in its legislative and executive acts. 19. Conflict between fundamental rights and directive principles. The justiciability of fundamental rights and non-justiciability of directive principles on the one hand and the moral obligation of state to implement directive principles, Article 37, on the other hand have led to a conflict between the two since the commencement of the Constitution. In the Champakam Dorai Rajan case 20, 1951, the Supreme Court ruled that in case of any conflict between the fundamental rights and the directive principles, the former would prevail. It declared that the directive principles have to conform to and run as subsidiary to the fundamental rights. But it also held that the fundamental rights could be amended by the Parliament by enacting constitutional amendment acts. As a result, the Parliament made the First Amendment Act, 1951, the 4th Amendment Act, 1955, and the 17th Amendment Act, 1964, to implement some of the directives. The above situation underwent a major change in 1967 following the Supreme Court's judgment in the Golkanath Case 21, 1967. In that case, the Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights, which are sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of the directive principles. The Parliament reacted to the Supreme Court's judgment in the Golkanath Case, 1967, by enacting the 24th Amendment Act, 1971, and the 25th Amendment Act, 1971. The 24th Amendment Act declared that the Parliament has the power to abridge or take away any of the fundamental rights by enacting constitutional amendment acts. The 25th Amendment Act inserted a new Article 31C which contained the following two provisions. 1. No law which seeks to implement the socialistic directive principles specified in Article 39, b. 22 and c. 23 shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, Article 19, protection of 6 rights in respect of speech, assembly, movement, etc., or Article 31, right to property. 2. No law containing a declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. Table 8.1 Distinction between fundamental rights and directive principles. Fundamental rights. Directive principles. 1. These are negative as they prohibit the state. 1. These are positive as they require the state. 2. From doing certain do certain things. 2. These are justiciable, that is, they are legally enforceable by the courts in case of their violation. 2. These are non-justiciable, that is, they are not legally enforceable by the courts for their violation. 3. They aim at establishing political democracy in the country. 3. They aim at establishing social and economic democracy in the country. 4. These have legal sanctions. 4. These have moral and political sanctions. 5. They promote the welfare of the individual. Hence, they are personal and individualistic. 5. They promote the welfare of the community. Hence, they are societarian and socialistic. 6. They do not require any legislation for their implementation. They are automatically enforced. 6. They require legislation for their implementation. They are not automatically enforced. 7. The courts are bound to. 7. The courts cannot declare a law violative of any of the directive principles as unconstitutional, any of the fundamental, and invalid. However, they can uphold the rights as unconstitutional validity of a law on the ground that it was enacted and invalid. To give effect to a directive. In the Keswananda Vaki Case 24, 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence, cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. Later, the 42nd Amendment Act, 1976, extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles and not merely those specified in Article 39, b, and c. In other words, the 42nd Amendment Act accorded the position of legal primacy and supremacy to the directive principles over the fundamental rights conferred by Articles 14, 19 and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills Case 25, 1980. It means that the directive principles were once again made subordinate to the fundamental rights. But the fundamental rights conferred by Article 14 and Article 19 were accepted as subordinate to the directive principles specified in Article 39, b, and c. Further, Article 31, right to property, was abolished by the 44th Amendment Act, 1978. In the Minerva Mills case, 1980, the Supreme Court also held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. They together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one no less than the other. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between the two is an essential feature of the basic structure of the Constitution. The goals set out by the directive principles have to be achieved without the abrogation of the means provided by the fundamental rights. Therefore, the present position is that the fundamental rights enjoy a supremacy over the directive principles. Yet, this does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles, so long as the amendment does not damage or destroy the basic structure of the Constitution. Implementation of directive principles since 1950, the successive governments at the center and in the states have made several laws and formulated various programs for implementing the directive principles. These are mentioned below. 1. The Planning Commission was established in 1950 to take up the development of the country in a planned manner. The successive 5-year plans aimed at securing socio-economic justice and reducing inequalities of income, status and opportunities. In 2015, the Planning Commission was replaced by a new body called Niti Aayog, National Institution for Transforming India. Almost all the states have passed land reform laws to bring changes in the agrarian society and to improve the conditions of the rural masses. These measures include a. Abolition of intermediaries like zamindars, jagirdars, inamdars, etc. b. Tenancy reforms like security of tenure, fair rents, etc. c. Imposition of ceilings on land holdings. d. Distribution of surplus land among the landless laborers, and e. Cooperative farming. 3. The Minimum Wages Act, 1948, the Payment of Wages Act, 1936, the Payment of Bonus Act, 1965, the Contract Labor Regulation and Abolition Act, 1970, the Child Labor Prohibition and Regulation Act, 1986, the Bonded Labor System Abolition Act, 1976, the Trade Unions Act, 1926, the Factories Act, 1948, the Mines Act, 1952, the Industrial Disputes Act, 1947, the Workmen's Compensation Act, 1923, and so on have been enacted to protect the interests of the labor sections. In 2006, the government banned the child labor. In 2016, the Child Labor Prohibition and Regulation Act, 1986, was renamed as the Child and Adolescent Labor Prohibition and Regulation Act, 1986. 4. The Maternity Benefit Act, 1961, and the Equal Remuneration Act, 1976, have been made to protect the interests of women workers. 5. Various measures have been taken to utilize the financial resources for promoting the common good. These include nationalization of life insurance, 1956, the nationalization of 14 leading commercial banks, 1969, nationalization of general insurance, 1971, abolition of privy purses, 1971, and so on. 6. The Legal Services Authorities Act, 1987, has established a nationwide network to provide free and competent legal aid to the poor and to organize Lok Adalats for promoting equal justice. Lok Adalat is a statutory forum for conciliatory settlement of legal disputes. It has been given the status of a civil court. Its awards are enforceable, binding on the parties and final as no appeal lies before any court against them. 7. Khadi and Village Industries Board, Khadi and Village Industries Commission, Small Scale Industries Board, National Small Industries Corporation, Handloom Board, Handicrafts Board, Coir Board, silk board and so on have been set up for the development of cottage industries in rural areas. 8. The Community Development Program, 1952, Hill Area Development Program, 1960, Drought Prone Area Program, 1973, Minimum Needs Program, 1974, Integrated Rural Development Program, 1978, Jawahar Rozgar Yojana, 1989, Swarnajayanti Gram Swarozgar Yojana, 1999, Sampurna Gramina Rozgar Yojana, 2001, National Rural Employment Guarantee Program, 2006, and so on have been launched for raising the standard of living of people. 9. The Wildlife Protection Act, 1972 and the Forest Conservation Act, 1980, have been enacted to safeguard the wildlife and the forests respectively. Further, the Water and Air Acts have provided for the establishment of the central and state pollution control boards, which are engaged in the protection and improvement of environment. The National Forest Policy, 1988, aims at the protection, conservation and development of forests. 10. Agriculture has been modernized by providing improved agricultural inputs, seeds, fertilizers and irrigation facilities. Various steps have also been taken to organize animal husbandry on modern and scientific lines. 11. Tritiya Panchayati Raj system, at village, taluka and zilla levels, has been introduced to translate into reality Gandhiji's dream of every village being a republic. The 73rd Amendment Act, 1992, has been enacted to provide constitutional status and protection to these Panchayati Raj institutions. 12 seats are reserved for SCs, STs and other weaker sections in educational institutions, government services and representative bodies. The Untouchability Offences Act, 1955, which was renamed as the Protection of Civil Rights Act in 1976, and the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, 1989, have been enacted to protect the SCs and STs from social injustice and exploitation. The 65th Constitutional Amendment Act of 1990 established the National Commission for Scheduled Castes and Scheduled Tribes to protect the interests of SCs and STs. The 89th Constitutional Amendment Act of 2003 bifurcated this combined commission into two separate bodies, namely, National Commission for Scheduled Castes and National Commission for Scheduled Tribes. 12 various national level commissions have been established to promote and protect the social, educational and economic interests of the weaker sections of the society. These include the National Commission for Backward Classes, 1993, the National Commission for Minorities, 1993, the National Commission for Women, 1992, and the National Commission for Protection of Child Rights, 2007. 13. The Criminal Procedure Code, 1973, separated the judiciary from the executive in the public services of the state. Prior to this separation, the district authorities like the collector, the subdivisional officer, the tahsildar and so on used to exercise judicial powers along with the traditional executive powers. After the separation, the judicial powers were taken away from these executive authorities and vested in the hands of district judicial magistrates who work under the direct control of the State High Court. 14. The Ancient and Historical Monument and Archaeological Sites and Remains Act, 1951, has been enacted to protect the monuments, places and objects of national importance. 15. Primary health centers and hospitals have been established throughout the country to improve the public health. Also, special programs have been launched to eradicate widespread diseases like malaria, TB, leprosy, AIDS, cancer, filaria, Kala-Azar, guinea worm, yos, Japanese encephalitis and so on. 16. Laws to prohibit the slaughter of cows, calves, and bullocks have been enacted in some states. 17. Some states have initiated the old age pension schemes for people above 65 years. 18. India has been following the policy of non-alignment and Panchashil to promote international peace and security. In spite of the above steps by the central and state governments, The directive principles have not been implemented fully and effectively due to several reasons like inadequate financial resources, unfavorable socio-economic conditions, population explosion, strained center-state relations, and so on. Directives outside Part 4. Apart from the directives included in Part 4, there are some other directives contained in other parts of the Constitution. They 1. Claims of SCs and STs to services. The claims of the members of the scheduled castes and the scheduled tribes shall be taken into consideration, consistently with the maintenance of efficiency of administration, in the making of appointments to services and posts in connection with the affairs of the Union or a state. Article 335 in Part 16. 2. Instruction in mother tongue. It shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 350 in Part 17. 3. Development of the Hindi language. It shall be the duty of the Union to promote the spread of the Hindi language and to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India. Article 351 in Part 17. The above directives are also non-justiciable in nature. However, they are also given equal importance and attention by the judiciary on the ground that all parts of the Constitution must be read together. Table 8.2 Articles related to Directive Principles of State Policy at a glance. Article No. Subject Matter 36. Definition of State 37. Application of the principles contained in this part 38. State to secure a social order for the promotion of welfare of the people 39. Certain principles of policy to be followed by the state. 39A Equal justice and free legal aid 40. Organization of village panchayats 41. Right to work, to education and to public assistance in certain cases 42. Provision for just and humane conditions of work and maternity relief 43. Living wage, etc. for workers 43A. Participation of workers in management of industries 43B. Promotion of cooperative societies 44. Uniform Civil Code for the citizens 45. Provision for early childhood care and education to children below the age of 6 years 46. Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections 47. Duty of the state to raise the level of nutrition and the standard of living and to improve public health 48. Organization of agriculture and animal husbandry 48A. Protection and improvement of environment and safeguarding of forests and wildlife 49. Protection of monuments and places and objects of national importance 50. Separation of judiciary from executive 51. Promotion of international peace and security notes and references 1. Actually, directive principles are mentioned in Articles 38 to 51. Article 36 deals with the definition of state while Article 37 deals with the nature and significance of directive principles. 2. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, p. 75. 3. A police state is mainly concerned with the maintenance of law and order and defense of the country against external aggression. Such a restrictive concept of state is based on the 19th century theory of individualism or laissez-faire. For this second provision was added by the 44th Constitutional Amendment Act of 1978. 5. The last point, F, was modified by the 42nd Constitutional Amendment Act of 1976. 6. This directive was added by the 42nd Constitutional Amendment Act of 1976. 7. Living wage is different from minimum wage, which includes the bare needs of life like food, shelter and clothing. In addition to these bare needs, a living wage includes education, health, insurance, etc. A fair wage is a mean between living wage and minimum wage. 8. This directive was added by the 42nd Constitutional Amendment Act of 1976. 8. This directive was added by the 97th Constitutional Amendment Act of 2011. 9. This directive was changed by the 86th Constitutional Amendment Act of 2002. Originally, it made a provision for free and compulsory education for all children until they complete the age of 14 years. 10. This directive was added by the 42nd Constitutional Amendment Act of 1976. 11. Constituent Assembly Debates, Volume 7, p. 476. 12. MP Jain, Indian Constitutional Law, Vadhva, 3rd edition, 1978, p. 595. 13. Constituent Assembly Debates, Volume 7, p. 470. 14. N. Srinivasan, Democratic Government in India, p. 182. 15. Sir Ivor Jennings, Some Characteristics of the Indian Constitution, 1953, p. 3133. 16. Journal of Constitutional and Parliamentary Studies, June 1975. 17. M. C. Chugla, An Ambassador Speaks, p. 35. 18. Granville Austin, The Indian Constitution, Cornerstone of a Nation.
Oxford, 1966,
p. 1552. 19. P. V. Gajendra, The Constitution of India, Its Philosophy and Postulates, p. 11. 20. State of Madras v. Champakam Dorai Rajan, 1951. 21. Golaknath v. State of Punjab, 1967. 22. Article 39, b, says, the state shall direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. 23. Article 39, c, says, the state shall direct its policy towards securing that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. 24. Keswananda Bharti v. State of Kerala, 1973. 25. Minerva Mills v. Union of India, 1980. Fundamental duties. The rights and duties of the citizens are correlative and inseparable. The original constitution contained only the fundamental rights and not the fundamental duties. In other words, the framers of the constitution did not feel it necessary to incorporate the fundamental duties of the citizens in the constitution. However, they incorporated the duties of the state in the constitution in the form of directive principles of state polity. Later in 1976, the fundamental duties of citizens were added in the T Constitution. In 2002, one more fundamental duty was added. The fundamental duties in the Indian Constitution are inspired by the Constitution of erstwhile USSR. Notably, none of the constitutions of major democratic countries like USA, Canada, France, Germany, Australia and so on specifically contain a list of duties of citizens. Japanese constitution is, perhaps, the only democratic constitution in world which contains a list of duties of citizens. The socialist countries, on the contrary, gave equal importance to the fundamental rights and duties of their citizens. Hence, the Constitution of erstwhile USSR declared that the citizens' exercise of their rights and freedoms was inseparable from the performance of their duties and obligations. Swan Singh Committee recommendations. In 1976, the Congress Party set up the Sardar Swan Singh Committee to make recommendations about fundamental duties, the need and necessity of which was felt during the operation of the internal emergency, 1975-1977. The committee recommended the inclusion of a separate chapter on fundamental duties in the Constitution. It stressed that the citizens should become conscious that in addition to the enjoyment of rights, they also have certain duties to perform as well. The Congress government at center accepted these recommendations and enacted the 42nd Constitutional Amendment Act in 1976. This amendment added a new part, namely, Part IVA to the Constitution. This new part consists of only one article, that is, Article 5(1), which for the first time specified a code of 10 fundamental duties of the citizens. The ruling Congress party declared the non-inclusion of fundamental duties in the Constitution as a historical mistake and claimed that what the framers of the Constitution failed to do was being done now. Though the Swan Singh Committee suggested the incorporation of 8 fundamental duties in the Constitution, the 42nd Constitutional Amendment Act, 1976, included 10 fundamental duties. Interestingly, certain recommendations of the committee were not accepted by the Congress party and hence, not incorporated in the Constitution. These include: 1. The Parliament may provide for the imposition of such penalty or punishment as may be considered appropriate for any non-compliance with or refusal to observe any of the duties. 2. No law imposing such penalty or punishment shall be called in question in any court on the ground of infringement of any of fundamental rights or on the ground of repugnancy to any other provision of the Constitution. 3. Duty to pay taxes should also be a fundamental duty of the citizens. List of fundamental duties according to Article 51A. It shall be the duty of every citizen of India, a. to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, b. to cherish and follow the noble ideals that inspired the national struggle for freedom, c. to uphold and protect the sovereignty, unity and integrity of India, d. to defend the country and render national service when called upon to do so, e. to promote harmony and the spirit of common brotherhood amongst all the people of India transcending religious, linguistic and regional or sectional diversities and to renounce practices derogatory to the dignity of women, f. to value and preserve the rich heritage of the country's composite culture, g. to protect and improve the natural environment including forests, lakes, rivers and wildlife and to have compassion for living creatures, h. to develop scientific temper, humanism and the spirit of inquiry and reform, I. to safeguard public property and to abjure violence, j. to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, and k. to provide opportunities for education to his child or ward between the age of 6 and 14 years. This duty was added by the 86th Constitutional Amendment Act, 2002. Features of the fundamental duties. Following points can be noted with regard to the characteristics of the fundamental duties. 1. Some of them are moral duties while others are civic duties. For instance, cherishing noble ideals of freedom struggle is a moral precept and respecting the Constitution, national flag and national anthem is a civic duty. 2. They refer to such values which have been a part of the Indian tradition, mythology, religions and practices. In other words, they essentially contain just a codification of tasks integral to the Indian way of life. 3. Unlike some of the fundamental rights which extend to all persons whether citizens or foreigners, 1. The fundamental duties are confined to citizens only and do not extend to foreigners. 4. Like the directive principles, the fundamental duties are also non-justiciable. The Constitution does not provide for their direct enforcement by the courts. Moreover, there is not legal sanction against their violation. However, the Parliament is free to enforce them by suitable legislation. Criticism of fundamental duties. The fundamental duties mentioned in Part IV of the Constitution have been criticized on the following grounds. 1. The list of duties is not exhaustive as it does not cover other important duties like casting vote, paying taxes, family planning and so on. In fact, duty to pay taxes was recommended by the Swan Singh Committee. 2. Some of the duties are vague, ambiguous and difficult to be understood by the common man. For example, different interpretations can be given to the phrases like noble ideals, composite culture, scientific temper, and so on too. 3. They have been described by the critics as a code of moral precepts due to their non-justiciable character. Interestingly, the Swan Singh Committee had suggested for penalty or punishment for the non-performance of fundamental duties. 4. Their inclusion in the Constitution was described by the critics as superfluous. This is because the duties included in the Constitution as fundamental would be performed by the people even though they were not incorporated in the Constitution. 3. 5. The critics said that the inclusion of fundamental duties as an appendage to Part 4 of the Constitution has reduced their value and significance. They should have been added after Part 3 so as to keep them on par with fundamental rights. Significance of fundamental duties. In spite of criticisms and opposition, the fundamental duties are considered significant from the following viewpoints. 1. They serve as a reminder to the citizens that while enjoying their rights, they should also be conscious of duties they owe to their country, their society and to their fellow citizens. 2. They serve as a warning against the anti-national and antisocial activities,
like burning the national flag,
destroying public property and so on. 3. They serve as a source of
inspiration for the citizens
and promote a sense of discipline and commitment among them. They create a feeling that the citizens are not mere spectators but active participants in the realization of national goals. 4. They help the courts in examining and determining the constitutional validity of a law. In 1992, the Supreme Court ruled that in determining the constitutionality of any law, if a court finds that the law in question seeks to give effect to a fundamental duty, it may consider such law to be reasonable in relation to Article 14, equality before law, or Article 19, 6 freedoms, and thus save such law from unconstitutionality. 5. They are enforceable by law. Hence, the Parliament can provide for the imposition of appropriate penalty or punishment for failure to fulfill any of them. H.R. Gokhale, the then Law Minister, gave the following reason for incorporating the fundamental duties in the Constitution after 26 years of its inauguration, in post-independent India, particularly on the eve of emergency in June 1975. A section of the people showed no anxiety to fulfill their fundamental obligations of respecting the established legal order. The provisions of chapter on fundamental duties would have a sobering effect on these restless spirits who have had a host of anti-national, subversive and unconstitutional agitations in the past. Indira Gandhi, the then Prime Minister, justified the inclusion of fundamental duties in the Constitution and argued that their inclusion would help to strengthen democracy. She said, "The moral value of fundamental duties would be not to smooth the rights but to establish a democratic balance by making the people conscious of their duties equally as they are conscious of their rights." The opposition in the Parliament strongly opposed the inclusion of fundamental duties in the Constitution by the Congress government. However, the new Janata government headed by Morarji Desai in the post-emergency period did not annul the fundamental duties. Notably, the new government sought to undo many changes introduced in the Constitution by the 42nd Amendment Act, 1976, through the 43rd Amendment Act, 1977, and the 44th Amendment Act, 1978. This shows that there was an eventual consensus on the necessity and desirability of including the fundamental duties in the Constitution. This is more clear with the addition of one more fundamental duty in 2002 by the 86th Amendment Act. Verma Committee Observations. The Verma Committee on Fundamental Duties of the Citizens, 1999, identified the existence of legal provisions for the implementation of some of the fundamental duties. They are mentioned below. 1. The Prevention of Insults to National Honour Act, 1971, prevents disrespect to the Constitution of India, the national flag and the national anthem. 2. The various criminal laws in force provide for punishments for encouraging enmity between different sections of people on grounds of language, race, place of birth, religion and so on. 3. The Protection of Civil Rights Act 4, 1955, provides for punishments for offences related to caste and religion. 4. The Indian Penal Code, IPC, declares the imputations and assertions prejudicial to national integration as punishable offences. 5. The Unlawful Activities Prevention Act of 1967 provides for the declaration of a communal organization as an unlawful association. 6. The Representation of People Act, 1951, provides for the disqualification of members of the Parliament or a state legislature for indulging in corrupt practice, that is, soliciting votes on the ground of religion or promoting enmity between different sections of people on grounds of caste, race, language, religion and so on. 7. The Wildlife Protection Act of 1972 prohibits trade in rare and endangered species. 8. The Forest Conservation Act of 1980 checks indiscriminate deforestation and diversion of forest land for non-forest purposes. Notes and references. 1. The fundamental rights guaranteed by Articles 14, 20, 21, 21, 22, 23, 24, 25, 26, 27 and 28 are available to all persons whether citizens or foreigners.
2. D.D. Chawla,
The then President of the National Forum of Lawyers and Legal Aid, Delhi, observed, the duties may be spelt out in a more concrete form, one is left guessing the noble ideals. To some even the Bhagat Singh cult may be such an ideal as inspired our national struggle. Again, what is the rich heritage of our composite culture and what is scientific temper, humanism and the spirit of inquiry and reform? The values are beyond the ken of the general run of the people and carry no meaning to them. Duties should be such and so worded as to catch the imagination of the common man. D.D. Chawla, The Concept of Fundamental Duties, Socialist India, New Delhi, 23 October 1976, p. 44-45. 3. C.K. Daftari, former Attorney General of India, while opposing the inclusion of fundamental duties in the Constitution, said that more than 99.9% of the citizens were law-abiding and there was no need to tell them about their duties. He argued that as long as the people are satisfied and contented, they willingly perform their duties. He said, to tell them what their duties are implies that they are not content. If that is the case after 26 years, it is not their fault. A.K. Sen also opposed the inclusion of fundamental duties in the Constitution and remarked, a democratic setup, instead of thriving on the willing cooperation and confidence of people, is reduced to the position of a harsh schoolmaster asking the student to stand up on the classroom bench because he has not done the homework. To begin with, it were the people of India who created the sovereign Democratic Republic of India in 1950, but the Republic is now claiming to be the master of the citizens, enjoining habitual obedience to its command to do his duty. The state's confidence in the citizens is obviously shaken. For this act was known as the Untouchability Offences Act till 1976.
Amendment of the Constitution like any other written constitution.
The Constitution of India also provides for its amendment in order to adjust itself to the changing conditions and needs. However, the procedure laid down for its amendment is neither as easy as in Britain nor as difficult as in USA. In other words, the Indian Constitution is neither flexible nor rigid but a synthesis of both. Article 368 in Part XX of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. It states that the Parliament may, in exercise of its constituent power, amend by way of addition, variation or repeal any provision of the Constitution in accordance with the procedure laid down for the purpose. However, the Parliament cannot amend those provisions which form the basic structure of the Constitution. This was ruled by the Supreme Court in the Keswananda Vati Case 1, 1973. Procedure for amendment. The procedure for the amendment of the Constitution as laid down in Article 368 is as follows. 1. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament and not in the state legislatures.
2. The bill can be introduced
either by a minister or by a private member and does not require prior permission of the President. 3. The bill must be passed in each house by a special majority, that is, a majority, that is, more than 50% of the total membership of the House and a majority of 2/3 of the members of the House present and voting. 4. Each House must pass the bill separately. In case of a disagreement between the two Houses, there is no provision for holding a joint sitting of the two Houses for the purpose of deliberation and passage of the bill. 5. If the bill seeks to amend the federal provisions of the Constitution, It must also be ratified by the legislatures of half of the states by a simple majority, that is, a majority of the members of the House present and voting. 6. After duly passed by both the Houses of Parliament and ratified by the state legislatures, where necessary, the bill is presented to the President for assent. 7. The President must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill for reconsideration of the Parliament. 28. After the President's assent, the bill becomes an act, i.e., a constitutional amendment act, and the Constitution stands amended in accordance with the terms of the act. Types of amendments. Article 368 provides for two types of amendments, that is, by a special majority of Parliament and also through the ratification of half of the states by a simple majority. But some other articles provide for the amendment of certain provisions of the Constitution by a simple majority of Parliament, that is, a majority of the members of each House present and voting, similar to the ordinary legislative process. Notably, these amendments are not deemed to be amendments of the Constitution for the purposes of Article 368. Therefore, the Constitution can be amended in three ways: a. Amendment by simple majority of the Parliament, b. Amendment by special majority of the Parliament, and c. Amendment by special majority of the Parliament and the ratification of half of the state legislatures. By simple majority of Parliament, a number of provisions in the Constitution can be amended by a simple majority of the two Houses of Parliament outside the scope of Article 368. These provisions include: 1. Admission or establishment of new states. 2. Formation of new states and alteration of areas, boundaries or names of existing states. 3. Abolition or creation of legislative councils in states. 4. Second Schedule, emoluments, allowances, privileges and so on of the President, the Governors, the Speakers, Judges, etc. 5. Quorum in Parliament. 6. Salaries and allowances of the Members of Parliament. 7. Rules of procedure in Parliament. 8. Privileges of the Parliament, its members and its committees. 9. Use of English language in Parliament. 10. Number of poisson judges in the Supreme Court. 11. Conferment of more jurisdiction on the Supreme Court. 12. Use of official language. 13. Citizenship, acquisition and termination. 14. Elections to Parliament and state legislatures. 15. Delimitation of constituencies. 16. Union territories. 17. Fifth Schedule, administration of scheduled areas and scheduled tribes. 18. Sixth Schedule, administration of tribal areas. By special majority of Parliament, the majority of the provisions in the Constitution need to be amended by a special majority of the Parliament, that is, a majority, that is, more than 50% of the total membership of each House and a majority of 2/3 of the members of each House present and voting. The expression, total membership, means the total number of members comprising the House. Irrespective of fact whether there are vacancies or absentees. Strictly speaking, the special majority is required only for voting at the third reading stage of the bill, but by way of abundant caution the requirement for special majority has been provided for in the rules of the Houses in respect of all the effective stages of the bill. 3. The provisions which can be amended by this way includes: I. Fundamental rights. 2. Directive principles of state policy, and 3. All other provisions which are not covered by the first and third categories. By special majority of Parliament and consent of states, those provisions of the Constitution which are related to the federal structure of the polity can be amended by a special majority of the Parliament and also with the consent of half of the state legislatures by a simple majority. If one or some or all the remaining states take no action on the bill, it does not matter. The moment half of the states give their consent, the formality is completed. There is no time limit within which the states should give their consent to the bill. The following provisions can be amended in this way: 1. Election of the President and its manner. 2. Extent of the executive power of the Union and the states. 3. Supreme Court and High Courts. 4. Distribution of legislative powers between the Union and the states. 5. Any of the lists in the 7th schedule. 6. Representation of states in Parliament. 7. Power of Parliament to amend the Constitution and its procedure, Article 368 itself. Criticism of the amendment procedure. Critics have criticized the amendment procedure of the Constitution on the following grounds. 1. There is no provision for a special body like Constitutional Convention, as in USA, or Constitutional Assembly for amending the Constitution. The constituent power is vested in the Parliament and only in few cases. In the state legislatures. 2. The power to initiate an amendment to the Constitution lies with the Parliament. Hence, unlike in USA 4, the state legislatures cannot initiate any bill or proposal for amending the Constitution except in one case, that is, passing a resolution requesting the Parliament for the creation or abolition of legislative councils in the states. Here also, the Parliament can either approve or disapprove such a resolution or may not take any action on it. 3. Major part of the Constitution can be amended by the Parliament alone, either by a special majority or by a simple majority. Only in few cases, the consent of the state legislatures is required, and that too, only half of them, while in USA, it is 3/4 of the states. 4. The Constitution does not prescribe the time frame within which the state legislatures should ratify or reject an amendment submitted to them. Also, it is silent on the issue whether the states can withdraw their approval after according the same. 5. There is no provision for holding a joint sitting of both the Houses of Parliament if there is a deadlock over the passage of a constitutional amendment bill. On the other hand, a provision for a joint sitting is made in the case of an ordinary bill. 6. The process of amendment is similar to that of a legislative process. Except for the special majority, the constitutional amendment bills are to be passed by the Parliament in the same way as ordinary bills. 7. The provisions relating to the amendment procedure are too sketchy. Hence, they leave a wide scope for taking the matters to the judiciary. Despite these defects, it cannot be denied that the process has proved to be simple and easy and has succeeded in meeting the changed needs and conditions. The procedure is not so flexible as to allow the ruling parties to change it according to their whims. Nor is it so rigid as to be incapable of adapting itself to the changing needs. It, as rightly said by K.C. Weir, strikes a good balance between flexibility and rigidity. 5. In this context, Pandit Jawaharlal Nehru said in the Constituent Assembly, "While we want this constitution to be as solid and permanent as we can make it, there is no permanence in a constitution. There should be a certain flexibility. If you make any constitution rigid and permanent, you stop the nation's growth, the growth of a living, vital, organic people." 6. Similarly, Dr. B.R. Ambedkar observed in the Constituent Assembly that the Assembly has not only refrained from putting a seal of finality and infallibility upon this Constitution by denying the people the right to amend the Constitution as in Canada, or by making the amendment of the Constitution subject to the fulfillment of extraordinary terms and conditions as in America or Australia, but has provided for a facile procedure for amending the Constitution. 7. K.C. Weir has admired the variety of amendment procedures contained in the Constitution of India. He said, "This variety in the amending process is wise but rarely found." According to Granville Austin, the amending process has proved itself one of the most ably conceived aspects of the Constitution. Although it appears complicated, it is merely diverse. 8 Notes and References. 1. Keswananda Varki v. State of Kerala, 1973. 2. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to a constitutional amendment bill. 3. Subhas C. Kashyap, Our Parliament, National Book Trust, 1999, p. 168. 4. In USA, an amendment can also be proposed by a constitutional convention called by the Congress, American legislature, on the petition of 2/3 of the state legislatures. 5. K.C. Weir, Modern Constitutions, 1966, p. 43. 6. Constituent Assembly Debates, Vol. 7, E32223. 7 Constituent Assembly Debates, Wall 9, p. 976. 8 Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, p. 25.
Basic structure of the Constitution. Emergence of the basic structure. He questioned whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. In the Shankari Prasad Case 1, 1951, the constitutional validity of the First Amendment Act, 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. The word law in Article 13 includes only ordinary laws and not the constitutional amendment acts, constituent laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a constitutional amendment act, and such a law will not be void under Article 13. But in the Golaknath Case 2, 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act, 1964, which inserted certain state acts in the 9th Schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence, the Parliament cannot abridge or take away any of these rights. A constitutional amendment act is also a law within the meaning of Article 13 and hence, would be void for violating any of the fundamental rights. The Parliament reacted to the Supreme Court's judgment in the Golaknath Case, 1967, by enacting the 24th Amendment Act, 1971. This act amended Articles 13 and 368. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. However, in the Keswananda Bharti Case 3, 1973, the Supreme Court overruled its judgment in the Golaknath Case, 1967. It upheld the validity of the 24th Amendment Act, 1971, and stated that Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure, or basic features, of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi Case 3A, 1975. In this case, the Supreme Court invalidated a provision of the 39th Amendment Act, 1975, which kept the election disputes involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act, 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of Parliament, and no amendment can be questioned in any court on any ground, including that of the contravention of any of the fundamental rights. However, the Supreme Court in the Minerva Mills Case 4, 1980, invalidated this provision as it excluded judicial review, which is a basic feature of the Constitution. Applying the doctrine of basic structure with respect to Article 368, the court held that, since the Constitution had conferred a limited amending power on the Parliament, the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of the Constitution, and, therefore, the
Limitations on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expand its amending powers so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic features. The dunny of a limited power cannot by the exercise of that power convert the limited power into an unlimited one. Again in the Vaman Rao case 5, 1981, the Supreme Court adhered to the doctrine of the basic structure, and further clarified that it would apply to constitutional amendments enacted after 24 April 1973, i.e., the date of the judgment in the Keswananda Vaki case. Elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution including the fundamental rights but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. From the various judgments, the following have emerged as basic features of the Constitution or elements, components, ingredients of the basic structure of the Constitution. 1. Supremacy of the Constitution. 2. Sovereign, democratic and republican nature of the Indian polity. 3. Secular character of the Constitution. 4. Separation of powers between the legislature, the executive and the judiciary. 5. Federal character of the Constitution. 6. Unity and integrity of the nation. 7. Welfare state, socio-economic justice. 8. Judicial review. 9. Freedom and dignity of the individual. 10. Parliamentary system. 11. Rule of law. 12. Harmony and balance between fundamental rights and directive principles. 13. Principle of equality. 14. Free and fair elections.
15. Independence of judiciary. 16. Limited power of Parliament to amend the Constitution.
17. Effective access to justice. 18. Principles, or essence, underlying fundamental rights. 19. Powers of the Supreme Court under Articles 32, 136, 141 and 1426. 20. Powers of the High Courts under Articles 226 and 2277. Table 11.1. Evolution of the basic structure of the Constitution. SL No. Name of the case, year, elements of the basic structure, as declared by the Supreme Court. 1. Keswananda Vaki Case 3, 1973, popularly known as the Fundamental Rights Case. 1. Supremacy of the Constitution. 2. Separation of powers between the legislature, the executive and the judiciary. 3. Republic and democratic form of government. 4. Secular character of the Constitution. 5. Federal character of the Constitution. 6. Sovereignty and unity of India. 7. Freedom and dignity of the individual. 8. Mandate to build a welfare state. 9. Parliamentary system. 1. India as a sovereign democratic republic. 2. Equality of status and opportunity of an individual. Indira Nehru Gandhi Case 3A, 1975. 3. Secularism and freedom of 2. Popularly known as the Election Conscience and Religion Case. 4. Government of laws and not of men, i.e., rule of law. 5. Judicial review. 6. Free and fair elections which is implied in democracy. 3. Minerva Mills Case 4, 1980. 1. Limited power of Parliament to amend the Constitution. 2. Judicial review. 3. Harmony and balance between fundamental rights and directive principles. 4. Central Coalfields Limited Case 8, 1980, effective access to justice. 5. Bhim Singh Ji Case 9, 1981, welfare state, socio-economic justice. 6. SP Sampath Kumar Case 10, 1987, 1. Rule of law. 2. Judicial review. 7. P. Sambamurthy Case 11, 1987, 1. Rule of law. 2. Judicial review. 8. Delhi Judicial Service Association Case 12, 1991, powers of the Supreme Court under Articles 32, 136, 141 and 142 9. Indra Sohni Case 13, 1992, popularly known as the Mandal Case, Rule of Law Kumar Padma Prasad Case 14.
10. 1992, Independence of Judiciary 11.
Kihoto Holoho Case 15, 1993, popularly known as Defection Case 1. Free and fair elections 2. Sovereign, democratic, republican structure 12. Raghunath Rao Case 16, 1993, 1. Principle of equality 2. Unity and integrity of India 13. S.R. Bommai Case 17, 1994, 1. Federalism 2. Secularism 3. Democracy 4. Unity and integrity of the nation 5. Social justice 6. Judicial review 14. L. Chandra Kumar Case 18, 1997, powers of the High Courts under Articles 226 and 227 15. Indra Sohni 2 Case 19, 2000, Principle of Equality 16. All India Judges Association Case 20, 2002, Independent Judicial System 17. Kuldeep Nair Case 21, 2006, 1. Democracy 2. Free and Fair Elections 18. M. Nagraj Case 22, 2006, Principle of Equality 19. I.R. Coelhone Case 23, 2007, popularly known as 9 Schedule Case 1. Rule of Law 2. Separation of Powers 3. Principles, or essence, underlying fundamental rights 4. Judicial Review 5. Principle of Equality 20. Ram Jethmalani Case 24, 2011, powers of the Supreme Court under Article 32.
21 Namit Sharma
Case 25, 2013, Freedom and Dignity of the Individual Madras Bar Association Case 26-1. Judicial Review 22. 2014, 2. Powers of the High Courts under Articles 226 and 227 Notes and References 1. Shankari Prasad v. Union of India, 1951, 2. Golaknath v. State of Punjab, 1967, 3. Keswananda Bharti v. State of Kerala, 1973, 3a. Indira Nehru Gandhi v. Raj Narayan, 1975, 4. Minerva Mills v. Union of India, 1980, 5. Vaman Rao v. Union of India, 1981, 6. For the subject matter of these articles, see Appendix 1. 7 Ibid. 8 Central Coalfields Limited, v. Jaswal Coalco, 1980, 9. Bhim Singh Ji v. Union of India, 1981, 10. S.P. Sampath Kumar v. Union of India, 1987, 11. P. Sambamurthy v. State of AP, 1987, 12. Delhi Judicial Service Association v. State of Gujarat, 1991, 13. Indra Sohni v. Union of India, 1992, 14. Kumar Padma Prasad v. Union of India, 1992, 15. Kihoto Holoho v. Zachailu, 1993, 16. Raghunath Rao v. Union of India, 1993, 17. S.R. Bommai v. Union of India, 1994, 18. L. Chandra Kumar v. Union of India, 1997, 19. Indra Sohni 2 v. Union of India, 2000, 20. All India Judges Association v. Union of India, 2002, 21. Kuldeep Nair v. Union of India, 2006, 22. M. Nagraj v. Union of India, 2006, 23. I.R. Coelhone v. State of Tamil Nadu, 2007, 24. Ram Jethmalani v. Union of India, 2011, 25. Namit Sharma v. Union of India, 2013, 26. Madras Bar Association v Union of India, 2014. Part 2 System of Government 12. Parliamentary System 13. Federal System 14. Center-State Relations 15. Interstate Relations 16. Emergency Provisions. Parliamentary System. The Constitution of India provides for a parliamentary form of government, both at the centre and in the states. Articles 74 and 75 deal with the parliamentary system at the centre, and Articles 163 and 164 in the T states. Modern democratic governments are classified into parliamentary and presidential on the basis of nature of relations between the executive and the legislative organs of the government. The parliamentary system of government is the one in which the executive is responsible to the legislature for its policies and acts. The presidential system of government, on the other hand, is one in which the executive is not responsible to the legislature for its policies and acts, and is constitutionally independent of the legislature in respect of its term of office. The parliamentary government is also known as cabinet government or responsible government or Westminster model of government, and is prevalent in Britain, Japan, Canada, India among others. The presidential government, on the other hand, is also known as non-responsible or non-parliamentary or fixed executive system of government, and is prevalent in USA, Brazil, Russia, Sri Lanka among others. Ivor Jennings called the parliamentary system as cabinet system, because the cabinet is the nucleus of power in a parliamentary system. The parliamentary government is also known as responsible government, as the cabinet, the real executive, is accountable to the parliament and stays in office so long as it enjoys the latter's confidence. It is described as Westminster model of government, after the location of the British Parliament, where the parliamentary system originated. In the past, the British constitutional and political experts described the Prime Minister as primus inter pares, first among equals, in relation to the cabinet. In the recent period, the Prime Minister's power, influence and position have increased significantly vis-à-vis the cabinet. He has come to play a dominant role in the British politico-administrative system. Hence, the later political analysts, like Crossman, Mackintosh and others, have described the British system of government as prime ministerial government. The same description holds good in the Indian context too. Features of parliamentary government. The features or principles of parliamentary government in India: 1. Nominal and real executives. The President is the nominal executive, de jure executive or titular executive, while the Prime Minister is the real executive, de facto executive. Thus, the President is head of the state, while the Prime Minister is head of the government. Article 74 provides for a council of ministers headed by the Prime Minister to aid and advise the President in the exercise of his functions. The advice so tendered is binding on the President. 1. 2. Majority party rule. The political party which secures majority seats in the Lok Sabha forms the government. The leader of that party is appointed as the Prime Minister by the President. Other ministers are appointed by the President on the advice of the Prime Minister. However, when no single party gets the majority, a coalition of parties may be invited by the President to form the government. 3. Collective responsibility. This is the bedrock principle of parliamentary government. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular. Article 75. They act as a team, and swim and sink together. The principle of collective responsibility implies that the Lok Sabha can remove the ministry, i.e., Council of Ministers headed by the Prime Minister, from office by passing a vote of no confidence. For political homogeneity, usually members of the Council of Ministers belong to the same political party, and hence they share the same political ideology. In case of coalition government, the ministers are bound by consensus. 5. Double membership. The ministers are members of both the legislature and the executive. This means that a person cannot be a minister without being a member of the parliament. The Constitution stipulates that a minister who is not a member of the Parliament for a period of 6 consecutive months ceases to be a minister. 6. Leadership of the Prime Minister. The Prime Minister plays the leadership role in this system of government. He is the leader of Council of Ministers, leader of the Parliament and leader of the party in power. In these capacities, he plays a significant and highly crucial role in the functioning of the government. 7. Dissolution of the lower house. The lower house of the Parliament, Lok Sabha, can be dissolved by the President on recommendation of the Prime Minister. In other words, the Prime Minister can advise the President to dissolve the Lok Sabha before the expiry of its term and hold fresh elections. This means that the executive enjoys the right to get the legislature dissolved in a parliamentary system. 8. Secrecy. The ministers operate on the principle of secrecy of procedure and cannot divulge information about their proceedings, policies and decisions. They take the oath of secrecy before entering their office. The oath of secrecy to the ministers is administered by the President. Features of presidential government. Unlike the Indian Constitution, the American Constitution provides for the presidential form of government. The features of the American presidential system of government are as follows. The American president is both the head of the state and the head of government. As the head of state, he occupies a ceremonial position. As the head of government, he leads the executive organ of government. B. The president is elected by an electoral college for a fixed tenure of 4 years. He cannot be removed by the Congress except by impeachment for a grave unconstitutional act. C. The President governs with the help of a cabinet or a smaller body called kitchen cabinet. It is only an advisory body and consists of non-elected departmental secretaries. They are selected and appointed by him, are responsible only to him, and can be removed by him any time. D. The President and his secretaries are not responsible to the Congress for their acts. They neither possess membership in the Congress nor attend its sessions. E. The President cannot dissolve the House of Representatives, the lower house of the Congress. F. The doctrine of separation of powers is the basis of the American presidential system. The legislative, executive and judicial powers of the government are separated and vested in the 3 independent organs of the government. Merits of the parliamentary system. The parliamentary system of government has the following merits. 1. Harmony between legislature and executive. The greatest advantage of the parliamentary system is that it ensures harmonious relationship and cooperation between the legislative and executive organs of the government. The executive is a part of the legislature and both are interdependent at work. As a result, there is less scope for disputes and conflicts between the 2 organs. 2. Responsible government. By its very nature, the parliamentary system establishes a responsible government. The ministers are responsible to the Parliament for all their acts of omission and commission. The Parliament exercises control over the ministers through various devices like question hour, discussions, adjournment motion, no confidence motion, etc. 3. Prevents despotism. Under this system, the executive authority is vested in a group of individuals, council of ministers, and not in a single person. This dispersal of authority checks the dictatorial tendencies of the executive. Moreover, the executive is responsible to the Parliament and can be removed by a no-confidence motion. 4. Ready alternative government. In case the ruling party loses its majority, the head of the state can invite the opposition party to form the government. This means an alternative government can be formed without fresh elections. Hence, Dr. Jennings says, the leader of the opposition is the alternative prime minister. 5. Wide representation. In a parliamentary system, the executive consists of a group of individuals, i.e., ministers who are representatives of the people. Hence, it is possible to provide representation to all sections and regions in the government. The Prime Minister, while selecting his ministers, can take this factor into consideration. Demerits of the parliamentary system. In spite of the above merits, the parliamentary system suffers from the following demerits. 1. Unstable government. The parliamentary system does not provide a stable government. There is no guarantee that a government can survive its tenure. The ministers depend on the mercy of the majority legislators for their continuity and survival in office. A no-confidence motion or political defection or evils of multi-party coalition can make the government unstable. The government headed by Morarji Desai, Charan Singh, VP Singh, Chandra Shekhar, Deva Gowda and I.K. Gujral are some such examples. To no continuity of policies, the parliamentary system is not conducive for the formulation and implementation of long-term policies. This is due to the uncertainty of the tenure of the government. A change in the ruling party is usually followed by changes in the policies of the government. For example, the Janata government headed by Morarji Desai in 1977 reversed a large number of policies of the previous Congress government. The same was repeated by the Congress government after it came back to power in 1980. 3. Dictatorship of the cabinet. When the ruling party enjoys absolute majority in the parliament, the cabinet becomes autocratic and exercises nearly unlimited powers. H. J. Lusky says that the parliamentary system gives the executive an opportunity for tyranny. Ramsay Muir, the former British Prime Minister, also complained of the dictatorship of the cabinet too. This phenomena was witnessed during the era of Indira Gandhi and Rajiv Gandhi. 4. Against separation of powers in the parliamentary system, the legislature and the executive are together and inseparable. The cabinet acts as the leader of legislature as well as the executive. As Bagehot points out, the cabinet is a hyphen that joins the buckle that binds the executive and legislative departments together. Hence, the whole system of government goes against the letter and spirit of the theory of separation of powers. 3. In fact, there is a fusion of powers. 5. Government by amateurs. The parliamentary system is not conducive to administrative efficiency as the ministers are not experts in their fields. The Prime Minister has a limited choice in the selection of ministers. His choice is restricted to the members of parliament alone and does not extend to external talent. Moreover, the ministers devote most of their time to parliamentary work, cabinet meetings and party activities. Now, let us compare the parliamentary and presidential systems in terms of their features, merits and demerits. Table 12.1 Comparing parliamentary and presidential systems. Parliamentary system, presidential system. Features.
1. Dual executive.
1. Single executive. 2. Majority party rule. 2. President and legislators elected. 3. Collective responsibility. Separately for a fixed term. 4. Political homogeneity. 3. Non-responsibility. 5. Double membership. 4. Political homogeneity may not exist. 6. Leadership of prime. 5. Single membership minister. 6. Domination of president. 7. Dissolution of lower house. 7. No dissolution of lower house. 8. Fusion of powers. 8. Separation of powers. Merits, demerits. 1. Harmony between legislature. 1. Conflict between legislature and executive. 2. Responsible government. 2. Non-responsible government. 3. Prevents despotism. 3. May lead to autocracy. 4. Wide representation. 4. Narrow representation. Demerits, merits. 1. Unstable government. 1. Stable government. 2. No continuity of policies. 2. Definiteness in policies. 3. Against separation of powers. 3. Based on separation of powers. 4. Government by amateurs. 4. Government by experts. Reasons for adopting parliamentary system. A plea was made in favor of US presidential system of government in the Constituent Assembly. 4. But the founding fathers preferred the British parliamentary system due to the following reasons. 1. Familiarity with the system. The constitution makers were somewhat familiar with the parliamentary system as it had been in operation in India during the British rule. K. M. Munshi argued that, for the last 30 or 40 years, some kind of responsibility has been introduced in the governance of this country. Our constitutional traditions have become parliamentary. After this experience, why should we go back and buy a novel experience? 5. To preference to more responsibility, Dr. B.R. Ambedkar pointed out in the Constituent Assembly that a democratic executive must satisfy two conditions: stability and responsibility. Unfortunately, it has not been possible so far to devise a system which can ensure both in equal degree. The American system gives more stability but less responsibility. The British system, on the other hand, gives more responsibility but less stability. The draft constitution, in recommending the parliamentary system of executive, has preferred more responsibility to more stability. 6.3. Need to avoid legislative, executive conflicts. The framers of the constitution wanted to avoid the conflicts between the legislature and the executive which are bound to occur in the presidential system prevalent in USA. They thought that an infant democracy could not afford to take the risk of a perpetual cleavage, feud or conflict or threatened conflict between these two organs of the government. They wanted a form of government that would be conducive to the manifold development of the country. For nature of Indian society, India is one of the most heterogeneous states and most complex plural societies in the world. Hence, the constitution makers adopted the parliamentary system as it offers greater scope for giving representation to various sections, interests and regions in the government. This promotes a national spirit among the people and builds a united India. Whether the parliamentary system should be continued or should be replaced by the presidential system has been a point of discussion and debate in our country since the 1970s. This matter was considered in detail by the Swarn Singh Committee appointed by the Congress government in 1975. The committee opined that the parliamentary system has been doing well and hence, there is no need to replace it by the presidential system. Distinction between Indian and British models. The parliamentary system of government in India is largely based on the British parliamentary system. However, it never became a replica of the British system and differs in the following respects. 1. India has a republican system in place of British monarchical system. In other words, the head of the state in India, that is, President, is elected, while the head of the state in Britain, that is, King or Queen, enjoys a hereditary position. 2. The British system is based on the doctrine of the sovereignty of Parliament, while the Parliament is not supreme in India and enjoys limited and restricted powers due to a written constitution, federal system, judicial review and fundamental rights. 7. 3. In Britain, the Prime Minister should be a member of the lower house, House of Commons, of the Parliament. In India, the Prime Minister may be a member of any of the two houses of Parliament. 84. Usually, the members of Parliament alone are appointed as ministers in Britain. In India, a person who is not a member of Parliament can also be appointed as minister, but for a maximum period of 6 months. 5. Britain has the system of legal responsibility of the minister while India has no such system. Unlike in Britain, the ministers in India are not required to countersign the official acts of the head of the state. 6. Shadow Cabinet is an unique institution of the British cabinet system. It is formed by the opposition party to balance the ruling cabinet and to prepare its members for future ministerial office. There is no such institution in India. Notes and references. 1. The 42nd and 44th Amendment Acts of 1976 and 1978 respectively have made the ministerial advice binding on the President. 2. How Britain is Governed is a popular book written by him. 3. This theory was propounded by Montesquieu, a French political thinker, in his book The Spirit of Laws, 1748, to promote individual liberty. He stated that concentration of powers in one person or a body of persons would result in despotism and negate individual liberty. 4. K.T. Shah favored the adoption of the presidential system. 5. Constituent Assembly Debates, Volume 7, p. 2845. 6. Constituent Assembly Debates, Volume 7, p. 32. 7. For details in this regard, see the section on the sovereignty of Parliament, in Chapter 22. 8. For example, 3 Prime Ministers, Indira Gandhi, 1966, Deve Gowda, 1996, and Manmohan Singh, 2004, were members of the Rajya Sabha.
Federal
Some
system.
political scientists have classified governments into unitary and federal on the basis of the nature of relations between the national government and the regional governments. By definition, a unitary government is one in which all the powers are vested in the national government, and the regional governments, if at all exist, derive their authority from the national government. A federal government, on the other hand, is one in which powers are divided between the national government and the regional governments by the constitution itself, and both operate in their respective jurisdictions independently. Britain, France, Japan, China, Italy, Belgium, Norway, Sweden, Spain and so on have the unitary model of government, while the US, Switzerland, Australia, Canada, Russia, Brazil, Argentina and so on have the federal model of government. In a federal model, the national government is known as the federal government or the central government or the union government, and the regional government is known as the state government or the provincial government. The specific features of the federal and unitary governments are mentioned below in a comparative manner. Table 13.1, comparing features of federal and unitary governments. Federal government, unitary government.
1.
Dual government, that is, 1. Single government, that is, the national government and national government which may create regional government, regional governments. 2. Written constitution. 2. Constitution may be written, France, or unwritten, Britain. 3. Division of powers between the national and regional government. 3. No division of powers. All powers are vested in the national government. 4. Supremacy of the Constitution. 4. Constitution may be supreme, Japan, or may not be supreme, Britain. 5. Rigid Constitution. 5. Constitution may be rigid, France, or flexible, Britain. 6. Independent judiciary. 6. Judiciary may be independent or may not be independent. 7. Bicameral legislature. 7. Legislature may be bicameral, Britain, or unicameral, China. The term federation is derived from a Latin word foedus, which means treaty or agreement. Thus, a federation is a new state, political system, which is formed through a treaty or an agreement between the various units. The units of a federation are known by various names like states, as in US, or cantons, as in Switzerland, or provinces, as in Canada, or republics, as in Russia. A federation can be formed in two ways, that is, by way of integration or by way of disintegration. In the first case, a number of militarily weak or economically backward states, independent, come together to form a big and a strong union, as for example, the US. In the second case, a big unitary state is converted into a federation by granting autonomy to the provinces to promote regional interest, for example, Canada. The US is the first and the oldest federation in the world. It was formed in 1787 following the American Revolution, 1775-83. It comprises 50 states, originally 13 states, and is taken as the model of federation. The Canadian Federation, comprising 10 provinces, originally 4 provinces, is also quite old, formed in 1867. The Constitution of India provides for a federal system of government in the country. The framers adopted the federal system due to two main reasons: the large size of the country and its socio-cultural diversity. They realized that the federal system not only ensures the efficient governance of the country but also reconciles national unity with regional autonomy. However, the term federation has nowhere been used in the Constitution. Instead, Article 1 of the Constitution describes India as a union of states. According to Dr. B.R. Ambedkar, the phrase union of states has been preferred to federation of states to indicate two things: I. The Indian Federation is not the result of an agreement among the states like the American Federation, and 2. The states have no right to secede from the Federation. The Federation is union because it is indestructible. 1. The Indian federal system is based on the Canadian model, and not on the American model. The Canadian model differs fundamentally from the American model insofar as it establishes a very strong center. The Indian Federation resembles the Canadian Federation, in its formation, i.e., by way of disintegration, 2. In its preference to the term union. The Canadian Federation is also called a union, and 3. In its centralizing tendency, i.e., vesting more powers in the center vis-à-vis the states. Federal features of the Constitution. The federal features of the Constitution of India are explained below. 1. Dual polity. The Constitution establishes a dual polity consisting the union at the center and the states at the periphery. Each is endowed with sovereign powers to be exercised in the field assigned to them respectively by the Constitution. The Union government deals with the matters of national importance like defense, foreign affairs, currency, communication and so on. The state governments, on the other hand, look after the matters of regional and local importance like public order, agriculture, health, local government and so on. 2. Written Constitution. The Constitution is not only a written document but also the lengthiest constitution of the world. Originally, it contained a preamble, 395 articles, divided into 22 parts, and 8 schedules. 2. At present, 2016, it consists of a preamble, about 465 articles, divided into 25 parts, and 12 schedules. 3. It specifies the structure, organization, powers and functions of both the central and state governments and prescribes the limits within which they must operate. Thus, it avoids the misunderstandings and disagreements between the two. 3. Division of powers. The Constitution divided the powers between the center and the states in terms of the Union list, state list and concurrent list in the 7th schedule. The Union list consists of 100 subjects, originally 97, the state list 61 subjects, originally 66, and the concurrent list 52 subjects, originally 47. Both the center and the states can make laws on the subjects of the concurrent list, but in case of a conflict, the central law prevails. The residuary subjects, i.e., which are not mentioned in any of the 3 lists, are given to the center. 4. Supremacy of the Constitution. The Constitution is the supreme, or the highest, law of the land. The laws enacted by the center and the states must conform to its provisions. Otherwise, they can be declared invalid by the Supreme Court or the High Courts through their power of judicial review. Thus, the organs of the government, legislative, executive and judicial, at both the levels must operate within the jurisdiction prescribed by the Constitution. 5. Rigid Constitution. The division of powers established by the Constitution as well as the supremacy of the Constitution can be maintained only if the method of its amendment is rigid. Hence, the Constitution is rigid to the extent that those provisions which are concerned with the federal structure, i.e., center-state relations and judicial organization, can be amended only by the joint action of the central and state governments. Such provisions require for their amendment a special majority of the Parliament and also an approval of half of the state legislatures. 6. Independent judiciary. The Constitution establishes an independent judiciary headed by the Supreme Court for 2 purposes. 1. To protect the supremacy of the Constitution by exercising the power of judicial review, and 2. To settle the disputes between the center and the states or between the states. The Constitution contains various measures like security of tenure to judges, fixed service conditions and so on to make the judiciary independent of the government. 7. Bicameralism. The Constitution provides for a bicameral legislature consisting of an upper house, Rajya Sabha, and a lower house, Lok Sabha. The Rajya Sabha represents the states of Indian Federation, while the Lok Sabha represents the people of India as a whole. The Rajya Sabha, even though a less powerful chamber, is required to maintain the federal equilibrium by protecting the interests of the states against the undue interference of the center. Unitary features of the Constitution. Besides the above federal features, the Indian Constitution also possesses the following unitary or non-federal features. One straw in center. The division of powers is in favor of the center and highly inequitable from the federal angle. Firstly, the union list contains more subjects than the state list. Secondly, the more important subjects have been included in the union list. Thirdly, the center has overriding authority over the concurrent list. Finally, the residuary powers have also been left with the center, while in the US, they are vested in the states. Thus, the Constitution has made the center very strong. Two states not indestructible. Unlike in other federations, the states in India have no right to territorial integrity. The parliament can by unilateral action change the area, boundaries or name of any state. Moreover, it requires only a simple majority and not a special majority. Hence, the Indian Federation is an indestructible union of destructible states. The American Federation, on the other hand, is described as an indestructible union of indestructible states. Three single constitution. Usually, in a federation, the states have the right to frame their own constitution separate from that of the center. In India, on the contrary, no such power is given to the states. The Constitution of India embodies not only the constitution of the center but also those of the states. Both the center and the states must operate within this single frame. The only exception in this regard is the case of Jammu and Kashmir, which has its own state constitution. 54. Flexibility of the constitution. The process of constitutional amendment is less rigid than what is found in other federations. The bulk of the constitution can be amended by the unilateral action of the parliament, either by simple majority or by special majority. Further, the power to initiate an amendment to the constitution lies only with the center. In US, the states can also propose an amendment to the constitution. 5. No equality of states representation. The states are given representation in the Rajya Sabha on the basis of population. Hence, the membership varies from 1 to 31. In US, on the other hand, the principle of equality of representation of states in the upper house is fully recognized. Thus, the American Senate has 100 members, 2 from each state. This principle is regarded as a safeguard for smaller states. 6. Emergency provisions. The Constitution stipulates 3 types of emergencies: national, state and financial. During an emergency, the central government becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation is not found in any other federation. 7. Single citizenship. In spite of a dual polity, the Constitution of India, like that of Canada, adopted the system of single citizenship. There is only Indian citizenship and no separate state citizenship. All citizens, irrespective of the state in which they are born or reside, enjoy the same rights all over the country. The other federal states like US, Switzerland and Australia have dual citizenship, that is, national citizenship as well as state citizenship. 8. Integrated judiciary. The Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the state high courts below it. This single system of courts enforces both the central laws as well as the state laws. In US, on the other hand, there is a double system of courts whereby the federal laws are enforced by the federal judiciary and the state laws by the state judiciary. 9. All India services. In US, the federal government and the state governments have their separate public services. In India also, the center and the states have their separate public services. But, in addition, there are All India services, IAS, IPS, and IFS, which are common to both the center and the states. The members of these services are recruited and trained by the center, which also poses ultimate control over them. Thus, these services violate the principle of federalism under the Constitution. 10. Integrated audit machinery. The Controller and Auditor General of India audits the accounts of not only the central government but also those of the states. But, his appointment and removal is done by the President without consulting the states. Hence, This office restricts the financial autonomy of the states. The American Comptroller General, on the contrary, has no role with respect to the accounts of the states. 11. Parliament's authority over the state list. Even in the limited sphere of authority allotted to them, the states do not have exclusive control. The Parliament is empowered to legislate on any subject of the state list if Rajya Sabha passes a resolution to that effect in the national interest. This means that the legislative competence of the Parliament can be extended without amending the Constitution. Notably, this can be done when there is no emergency of any kind. 12. Appointment of Governor. The Governor, who is the head of the state, is appointed by the President. He holds office during the pleasure of the President. He also acts as an agent of the Centre. Through him, the Centre exercises control over the states. The American Constitution, on the contrary, provided for an elected head in the states. In this respect, India adopted the Canadian system. 13. Integrated election machinery. The Election Commission conducts elections not only to the central legislature but also to the state legislatures. But this body is constituted by the President and the states have no say in this matter. The position is same with regard to the removal of its members as well. On the other hand, US has separate machineries for the conduct of elections at the federal and state levels. 14. Veto over the state bills. The governor is empowered to reserve certain types of bills passed by the state legislature for the consideration of the President. The President can withhold his assent to such bills not only in the first instance but also in the second instance. Thus, the President enjoys absolute veto, and not suspensive veto, over the state bills. But in US and Australia, the states are autonomous within their fields and there is no provision for any such reservation. Critical evaluation of the federal system. From the above, it is clear that the Constitution of India has deviated from the traditional federal systems like US, Switzerland and Australia and incorporated a large number of unitary or non-federal features, tilting the balance of power in favor of the centre. This has prompted the constitutional experts to challenge the federal character of the Indian Constitution. Thus, K.C. Weir described the Constitution of India as quasi-federal. He remarked that Indian Union is a unitary state with subsidiary federal features rather than a federal state with subsidiary unitary features. 6. According to K. Santanam, the two factors have been responsible for increasing the unitary bias, tendency of centralization, of the Constitution. These are I. The dominance of the centre in the financial sphere and the dependence of the states upon the central grants, and 2. The emergence of a powerful planning commission which controls the developmental process in the states. He observed, India has practically functioned as a unitary state though the Union and the states have tried to function formally and legally as a federation. 7. However, there are other political scientists who do not agree with the above descriptions. Thus, Paul Appleby characterizes the Indian system as extremely federal. Morris Jones 9 termed it as a bargaining federalism. Ivor Jennings 10 has described it as a federation with a strong centralizing tendency. He observed that the Indian Constitution is mainly federal with unique safeguards for enforcing national unity and growth. Alexandroes 11 stated that India is a case sui generis, i.e., unique in character. Granville Austin 12 called the Indian federalism as a cooperative federalism. He said that though the Constitution of India has created a strong central government, it has not made the state governments weak and has not reduced them to the level of administrative agencies for the execution of policies of the central government. He described the Indian Federation as a new kind of federation to meet India's peculiar needs. On the nature of Indian Constitution, Dr. B.R. Ambedkar made the following observation in the Constituent Assembly. The Constitution is a federal constitution in as much as it establishes a dual polity. The Union is not a league of states, united in a loose relationship, nor are the states the agencies of the Union, deriving powers from it. Both the Union and the states are created by the Constitution, both derive their respective authority from the Constitution. 13. He further observed, "Yet the constitution avoids the tight mold of federalism and could be both unitary as well as federal according to the requirements of time and circumstances." 14. While replying to the criticism of over-centralization in the constitution, he stated, "A serious complaint is made on the ground that there is too much centralization and the states have been reduced to municipalities. It is clear that this view is not only an exaggeration but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relations between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principle of federalism is that the legislative and executive authority is partitioned between the center and the states not by any law to be made by the center but by the Constitution itself. This is what the Constitution does. The states are in no way dependent upon the center for their legislative or executive authority. The states and the center are co-equal in this matter. It is difficult to see how such a constitution can be called centralism. It is, therefore, wrong to say that the states have been placed under the center. The center cannot by its own will alter the boundary of this partition. Nor can the judiciary. 15. In Bommai Case 16, 1994, the Supreme Court laid down that the Constitution is federal and characterized federalism as its basic feature. It observed, "The fact that under the scheme of our Constitution, greater power is conferred upon the center vis-à-vis the states does not mean that the states are mere appendages of the center. The states have an independent constitutional existence. They are not satellites or agents of the center. Within the sphere allotted to them, the states are supreme. The fact that during emergency and in certain other eventualities their powers are overridden or invaded by the center is not destructive of the essential federal feature of the Constitution. They are exceptions and the exceptions are not a rule. Let it be said that the federalism in the Indian Constitution is not a matter of administrative convenience, but one of principle, the outcome of our own process and a recognition of the ground realities. In fact, the federalism in India represents a compromise between the following two conflicting considerations. 17. I. Normal division of powers under which states enjoy autonomy within their own spheres, and 2. Need for national integrity and a strong union government under exceptional circumstances. The following trends in the working of Indian political system reflects its federal spirit. I. Territorial disputes between states, for example, between Maharashtra and Karnataka over Belgaum. 2. Disputes between states over sharing of river water, for example, between Karnataka and Tamil Nadu over Koveri water. 3. The emergence of regional parties and their coming to power in states like Andhra Pradesh, Tamil Nadu, etc. 4. The creation of new states to fulfill the regional aspirations. For example, Mizoram or recently Jharkhand. We demand of the states for more financial grants from the center to meet their developmental needs. 6. Assertion of autonomy by the states and their resistance to the interference from the center. 7. Supreme Court's imposition of several procedural limitations on the use of Article 356, President's rule in the states, by the center. 18 Notes and references. 1. Constituent Assembly Debates, Volume 7, p. 43. 2. The American Constitution originally consisted only 7 articles, the Australian 128 and the Canadian 147. 3. The various amendments carried out since 1951 have deleted about 20 articles and 1 part, 7, and added about 90 articles, 4 parts, IVA, IXA, IXB and XIVA, and 4 schedules, 9, 10, 11 and 12. 4. A majority of second march of the members of each house present and voting and a majority of the total membership of each house. 5. Jammu and Kashmir enjoys a special status by virtue of Article 370 of the Constitution of India.
6. K.C. Weir, Federal Government,
1951, p. 28. 7. K. Santanam, Union-State Relations in India, 1960, pp. 50-70. 8. Paul Appleby, Public Administration in India, 1953, p. 51. 9. Maurice Jones, The Government and Politics in India, 1960, p. 14. 10. Ivor Jennings, Some Characteristics of the Indian Constitution, 1953, p. 1. 11. C. H. Alexandrois, Constitutional Development in India, 1957, pp. 15770. 12. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, pp. 18688. 13. Constituent Assembly Debates, Vol 8, p. 33. 14. Ibid, Vol 7, pp. 33-34. 15. Dr. B. R. Ambedkar's speech in the Constituent Assembly on 25 November 1949 reproduced in the Constitution and the Constituent Assembly, Lok Sabha Secretariat, 1990, p. 176. 16. S.R. Bommai v. Union of India, 1994. 17. Subhash C. Kashyap, Our Parliament, National Book Trust, 1999 edition, p. 40. 18. S.R. Bommai v. Union of India, 1994. For the details of the judgment, see President's Rule, in Chapter 16. Centre-state relations. The Constitution of India, being federal in structure, divides all powers, legislative, executive and financial, between the centre and the states. However, there is no division of judicial power, as the Constitution has established an integrated judicial system to enforce both the central laws as well as state laws. Though the centre and the states are supreme in their respective fields, the maximum harmony and coordination between them is essential for the effective operation of the federal system. Hence, the Constitution contains elaborate provisions to regulate the various dimensions of the relations between the centre and the states. The centre-state relations can be studied under three heads: times legislative relations, times administrative relations, times financial relations. Legislative relations. Articles 245 to 255 in Part 11 of the Constitution deal with the legislative relations between the centre and the states. Besides these, there are some other articles dealing with the same subject. Like any other federal constitution, the Indian Constitution also divides the legislative powers between the centre and the states with respect to both the territory and the subjects of legislation. Further, the Constitution provides for the parliamentary legislation in the state field under 5 extraordinary situations, as well as the centre's control over the state legislation in certain cases. Thus, there are 4 aspects in the centre-states legislative relations, viz. Times territorial extent of central and state legislation, times distribution of legislative subjects, times parliamentary legislation in the state field, and times centre's control over the state legislation. 1. Territorial extent of central and state legislation. The Constitution defines the territorial limits of the legislative powers vested in the centre and the states in the following way. I. The Parliament can make laws for the whole or any part of the territory of India. The territory of India includes the states, the union territories, and any other area for the time being included in the territory of India. 2. A state legislature can make laws for the whole or any part of the state. The laws made by a state legislature are not applicable outside the state, except when there is a sufficient nexus between the state and the object. 3. The Parliament alone can make extraterritorial legislation. Thus, the laws of the Parliament are also applicable to the Indian citizens and their property in any part of the world. However, the Constitution places certain restrictions on the plenary territorial jurisdiction of the Parliament. In other words, the laws of Parliament are not applicable in the following areas. I. The President can make regulations for the peace, progress and good government of the 4 union territories, the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli and Daman and Diu. A regulation so made has the same force and effect as an Act of Parliament. It may also repeal or amend any Act of Parliament in relation to these union territories. 2. The governor is empowered to direct that an act of parliament does not apply to a scheduled area in the state or apply with specified modifications and exceptions.
3. The governor of
Assam may likewise direct that an act of parliament does not apply to a tribal area, autonomous district, in the state or apply with specified modifications and exceptions. The president enjoys the same power with respect to tribal areas, autonomous districts, in Meghalaya, Tripura and Mizoram. 2. Distribution of legislative subjects. The constitution provides for a threefold distribution of legislative subjects between the center and the states, viz. List I, the Union List, List 2, the State List, and List 3, the Concurrent List. In the 7th Schedule, I, the Parliament has exclusive powers to make laws with respect to any of the matters enumerated in the Union List. This list has at present 100 subjects, originally 971 subjects, like defense, banking, foreign affairs, currency, atomic energy, insurance, communication, interstate trade and commerce, census, audit and so on. 2. The state legislature has, in normal circumstances, exclusive powers to make laws with respect to any of the matters enumerated in the state list. This has at present 61 subjects, originally 662 subjects, like public order, police, public health and sanitation, agriculture, prisons, local government, fisheries, markets, theatres, gambling and so on. 3. Both the Parliament and state legislature can make laws with respect to any of the matters enumerated in the concurrent list. This list has at present 52 subjects, originally 473 subjects, like criminal law and procedure, civil procedure, marriage and divorce, population control and family planning, electricity, labor welfare, economic and social planning, drugs, newspapers, books and printing press, and others. The 42nd Amendment Act of 1976 transferred 5 subjects to concurrent list from state list, that is, A. Education, B. Forests, C. Weights and measures, D. Protection of wild animals and birds, and E. Administration of justice, constitution and organization of all courts except the Supreme Court and the High Courts. The power to make laws with respect to residuary subjects, i.e., the matters which are not enumerated in any of the 3 lists, is vested in the Parliament. This residuary power of legislation includes the power to levy residuary
taxes. From the above scheme, it is clear that the matters of national importance and the matters which require uniformity of legislation nationwide are included in the Union List. The matters of regional and local importance and the matters which permit diversity of interest are specified in the state list. The matters on which uniformity of legislation throughout the country is desirable but not essential are enumerated in the concurrent list. Thus, it permits diversity along with uniformity. In US, only the powers of the federal government are enumerated in the Constitution and the residuary powers are left to the states. The Australian Constitution followed the American pattern of single enumeration of powers. In Canada, on the other hand, there is a double enumeration, federal and provincial, and the residuary powers are vested in the centre. The Government of India, GOI, Act of 1935 provided for a threefold enumeration, viz. Federal, provincial and concurrent. The present constitution follows the scheme of this act but with one difference, that is, under this act, the residuary powers were given neither to the federal legislature nor to the provincial legislature but to the Governor-General of India. In this respect, India follows the Canadian precedent. The Constitution expressly secures the predominance of the Union List over the State List and the concurrent list and that of the concurrent list over the State List. Thus, in case of overlapping between the Union List and the State List, the former should prevail. In case of overlapping between the Union List and the concurrent list, it is again the former which should prevail. Where there is a conflict between the concurrent list and the State List, it is the former that should prevail.
In case of a conflict between the central law and the state law on a subject enumerated in the concurrent list, the central law prevails over the state law. But there is an exception. If the state law has been reserved for the consideration of the President and has received his assent, then the state law prevails in that state. But it would still be competent for the Parliament to override such a law by subsequently making a law on the same matter. 3. Parliamentary legislation in the state field. The above scheme of distribution of legislative powers between the centre and the states is to be maintained in normal times. But in abnormal times, the scheme of distribution is either modified or suspended. In other words, the Constitution empowers the Parliament to make laws on any matter enumerated in the state list under the following 5 extraordinary circumstances: when Rajya Sabha passes a resolution, if the Rajya Sabha declares that it is necessary in the national interest that Parliament should make laws on a matter in the state list, then the Parliament becomes competent to make laws on that matter. Such a resolution must be supported by 2/3 of the members present and voting. The resolution remains in force for 1 year. It can be renewed any number of times but not exceeding 1 year at a time. The laws cease to have effect on the expiration of 6 months after the resolution has ceased to be in force. This provision does not restrict the power of a state legislature to make laws on the same matter. But in case of inconsistency between a state law and a parliamentary law, the latter is to prevail. During a national emergency, the Parliament acquires the power to legislate with respect to matters in the state list, while a proclamation of national emergency is in operation. The laws become inoperative on the expiration of 6 months after the emergency has ceased to operate. Here also, the power of a state legislature to make laws on the same matter is not restricted. But in case of repugnancy between a state law and a parliamentary law, the latter is to prevail. When states make a request, when the legislatures of 2 or more states pass resolutions requesting the Parliament to enact laws on a matter in the state list, then the Parliament can make laws for regulating that matter. A law so enacted applies only to those states which have passed the resolutions. However, any other state may adopt it afterwards by passing a resolution to that effect in its legislature. Such a law can be amended or repealed only by the Parliament and not by the legislatures of the concerned states. The effect of passing a resolution under the above provision is that the Parliament becomes entitled to legislate with respect to a matter for which it has no power to make a law. On the other hand, the state legislature ceases to have the power to make a law with respect to that matter. The resolution operates as abdication or surrender of the power of the state legislature with respect to that matter, and it is placed entirely in the hands of Parliament, which alone can then legislate with respect to it. Some examples of laws passed under the above provision are Prize Competition Act, 1955, Wildlife Protection Act, 1972, Water Prevention and Control of Pollution Act, 1974, Urban Land Sealing and Regulation Act, 1976, and Transplantation of Human Organs Act, 1994. To implement international agreements, the Parliament can make laws on any matter in the state list for implementing the international treaties, agreements or conventions. This provision enables the central government to fulfill its international obligations and commitments. Some examples of laws enacted under the above provision are United Nations Privileges and Immunities Act, 1947, Geneva Convention Act, 1960, Anti-Hijacking Act, 1982, and legislations relating to environment and TRIPS. During President's rule, when the President's rule is imposed in a state, the Parliament becomes empowered to make laws with respect to any matter in the state list in relation to that state. A law made so by the Parliament continues to be operative even after the President's rule. This means that the period for which such a law remains in force is not coterminous with the duration of the President's rule. But such a law can be repealed or altered or reenacted by the state legislature. 4. Centers control over the state legislation. Besides the Parliament's power to legislate directly on the state subjects under the exceptional situations, The Constitution empowers the center to exercise control over the state's legislative matters in the following ways. I. The governor can reserve certain types of bills passed by the state legislature for the consideration of the president. The president enjoys absolute veto over them.
2. Bills
On certain matters enumerated in the state list can be introduced in the state legislature only with the previous sanction of the president. For example, the bills imposing restrictions on the freedom of trade and commerce. 3. The president can direct the states to reserve money bills and other financial bills passed by the state legislature for his consideration during a financial emergency. From the above, it is clear that the Constitution has assigned a position of superiority to the center in the legislative sphere. In this context, the Sarkaria Commission on Center-State Relations, 1983-87, observed, the rule of federal supremacy is a technique to avoid absurdity, resolve conflict and ensure harmony between the union and state laws. If this principle of union supremacy is excluded, it is not difficult to imagine its deleterious results. There will be every possibility of our two-tier political system being stultified by interference, strife, legal chaos and confusion caused by a host of conflicting laws, much to the bewilderment of the common citizen. Integrated legislative policy and uniformity on basic issues of common union-state concern will be stymied. The federal principle of unity in diversity will be very much a casualty. This rule of federal supremacy, therefore, is indispensable for the successful functioning of the federal system. 4 Administrative Relations Articles 256 to 263 in Part 11 of the Constitution deal with the administrative relations between the center and the states. In addition, there are various other articles pertaining to the same matter. Distribution of executive powers. The executive power has been divided between the center and the states on the lines of the distribution of legislative powers, except in few cases. Thus, the executive power of the center extends to the whole of India, i.e., to the matters on which the Parliament has exclusive power of legislation, i.e., the subjects enumerated in the Union list, and 2. To the exercise of rights, authority and jurisdiction conferred on it by any treaty or agreement. Similarly, the executive power of a state extends to its territory in respect of matters on which the state legislature has exclusive power of legislation, i.e., the subjects enumerated in the state list. In respect of matters on which both the Parliament and the state legislatures have power of legislation, i.e., the subjects enumerated in the concurrent list, the executive power rests with the states except when a constitutional provision or a parliamentary law specifically confers it on the center. Therefore, a law on a concurrent subject, though enacted by the Parliament, is to be executed by the states except when the Constitution or the Parliament has directed otherwise. 5 Obligation of states and the center. The Constitution has placed 2 restrictions on the executive power of the states in order to give ample scope to the center for exercising its executive power in an unrestricted manner. Thus, the executive power of every state is to be exercised in such a way, a. as to ensure compliance with the laws made by the Parliament and any existing law which apply in the state, and b. as not to impede or prejudice the exercise of executive power of the center in the state. While the former lays down a general obligation upon the state, the latter imposes a specific obligation on the state not to hamper the executive power of the center. In both the cases, the executive power of the center extends to giving of such directions to the state as are necessary for the purpose. The sanction behind these directions of the center is coercive in nature. Thus, Article 365 says that where any state has failed to comply with, or to give effect to, any directions given by the center, it will be lawful for the President to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. It means that, in such a situation, the President's rule can be imposed in the state under Article 356. Center's directions to the states. In addition to the above 2 cases, the center is empowered to give directions to the states with regard to the exercise of their executive power in
the following matters:
I. The construction and maintenance of means
of communication
declared to be of national or military importance by the state. 2. The measures to be taken for the protection of the railways within the state. 3. The provision of adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups in the state. And 4. The drawing up and execution of the specified schemes for the welfare of the scheduled tribes in the state. The coercive sanction behind the central directions under Article 365, mentioned above, is also applicable in these cases. Mutual delegation of functions. The distribution of legislative powers between the center and the states is rigid. Consequently, the center cannot delegate its legislative powers to the states, and a single state cannot request the parliament to make a law on a state subject. The distribution of executive power in general follows the distribution of legislative powers. But such a rigid division in the executive sphere may lead to occasional conflicts between the two. Hence, the Constitution provides for intergovernment delegation of executive functions in order to mitigate rigidity and avoid a situation of deadlock. Accordingly, the President may, with the consent of the state government, entrust to that government any of the executive functions of the center. Conversely, the governor of a state may, with the consent of the central government, entrust to that government any of the executive functions of the state. 6. This mutual delegation of administrative functions may be conditional or unconditional. The Constitution also makes a provision for the entrustment of the executive functions of the center to a state without the consent of that state. But, in this case, the delegation is by the parliament and not by the president. Thus, a law made by the parliament on a subject of the union list can confer powers and impose duties on a state, or authorize the conferring of powers and imposition of duties by the center upon a state, irrespective of the consent of the state concerned. Notably, the same thing cannot be done by the state legislature. From the above, it is clear that the mutual delegation of functions between the center and the state can take place either under an agreement or by a legislation. While the center can use both the methods, a state can use only the first method. Cooperation between the center and states. The Constitution contains the following provisions to secure cooperation and coordination between the center and the states. I. The Parliament can provide for the adjudication of any dispute or complaint with respect to the use, distribution and control of waters of any interstate river and river valley. 2. The President can establish, under Article 263, an interstate council to investigate and discuss subject of common interest between the center and the states. Such a council was set up in 1990.7. 3. Full faith and credit is to be given throughout the territory of India to public acts, records and judicial proceedings of the center and every state. 4. The Parliament can appoint an appropriate authority to carry out the purposes of the constitutional provisions relating to the interstate freedom of trade, commerce and intercourse. But no such authority has been appointed so far. All India services, like in any other federation, the center and the states also have their separate public services called as the central services and the state services respectively. In addition, there are All India services, IAS, IPS and IFS. The members of these services occupy top positions, or key posts, under both the center and the states and serve them by turns. But they are recruited and trained by the center. These services are controlled jointly by the center and the states. The ultimate control lies with the central government while the immediate control rests with the state governments.
In 1947,
Indian Civil Service, ICS, was replaced by IAS and the Indian Police, IP, was replaced by IPS and were recognized by the Constitution as All India Services. In 1966, the Indian Forest Service, IFS, was created as the third All India Service. Article 312 of the Constitution authorizes the Parliament to create new All India services on the basis of a Rajya Sabha resolution to that effect. Each of these three All India services, irrespective of their division among different states, form a single service with common rights and status and uniform scales of pay throughout the country. Though the All India services violate the principle of federalism under the constitution by restricting the autonomy and patronage of the states, they are supported on the ground that they help in maintaining high standard of administration in the center as well as in the states. 2. They help to ensure uniformity of the administrative system throughout the country. And 3. They facilitate liaison, cooperation, coordination and joint action on the issues of common interest between the center and the states. While justifying the institution of All India services in the Constituent Assembly, Dr. B.R. Ambedkar observed that the dual polity which is inherent in a federal system is followed in all federations by a dual service. In all federations, there is a federal civil service and a state civil service. The Indian Federation, though a dual polity, will have a dual service, but with one exception. It is recognized that in every country there are certain posts in its administrative setup which might be called strategic from the point of view of maintaining the standard of administration. There can be no doubt that the standard of administration depends upon the caliber of the civil servants who are appointed to the strategic posts. The Constitution provides that without depriving the states of their rights to form their own civil services, there shall be an All India service, recruited on an All India basis with common qualifications, with uniform scale of pay and members of which alone could be appointed to those strategic posts throughout the Union. 8 Public Service Commissions. In the field of public service commissions, the center-state relations are as follows. The chairman and members of a state public service commission, though appointed by the governor of the state, can be removed only by the president. 2. The parliament can establish a joint state public service commission, JSPSC, for 2 or more states on the request of the state legislatures concerned. The chairman and members of the JSPSC are appointed by the president. 3. The Union Public Service Commission, UPSC, can serve the needs of a state on the request of the state governor and with the approval of the president. 4. The UPSC assists the states, when requested by 2 or more states, in framing and operating schemes of joint recruitment for any services for which candidates possessing special qualifications are required. Integrated judicial system. Though India has a dual polity, there is no dual system of administration of justice. The Constitution, on the other hand, established an integrated judicial system with the Supreme Court at the top and the state high courts below it. This single system of courts enforces both the central laws as well as the state laws. This is done to eliminate diversities in the remedial procedure. The judges of a state high court are appointed by the president in consultation with the Chief Justice of India and the governor of the state. They can also be transferred and removed by the president. The parliament can establish a common high court for 2 or more states. For example, Maharashtra and Goa or Punjab and Haryana have a common high court. Relations during emergencies. During the operation of a national emergency, under Article 352, the center becomes entitled to give executive directions to a state on any matter. Thus, the state governments are brought under the complete control of the center, though they are not suspended. 2. When the president's rule is imposed in a state, under Article 356, the President can assume to himself the functions of the state government and powers vested in the governor or any other executive authority in the state. 3. During the operation of a financial emergency, under Article 360, the center can direct the states to observe canons of financial propriety and the president can give other necessary directions including the reduction of salaries of persons serving in the state and the high court judges. Other provisions. The Constitution contains the following other provisions which enable the center to exercise control over the state administration. Article 355 imposes 2 duties on the center. A. To protect every state against external aggression and internal disturbance, and B. To ensure that the government of every state is carried on in accordance with the provisions of the Constitution. 2. The governor of a state is appointed by the president. He holds office during the pleasure of the President. In addition to the constitutional head of the state, the governor acts as an agent of the center in the state. He submits periodical reports to the center about the administrative affairs of the state. 3. The State Election Commissioner, though appointed by the governor of the state, can be removed only by the President. Extra-constitutional devices. In addition to the above-mentioned constitutional devices, there are extra-constitutional devices to promote cooperation and coordination between the center and the states. These include a number of advisory bodies and conferences held at the central level. The non-constitutional advisory bodies include the Planning Commission, now Niti Aayog; 9. The National Development Council, the National Integration Council; 10. The Central Council of Health, the Central Council of Local Government and Urban Development, the Zonal Councils; 11. The North Eastern Council, the Central Council of Indian Medicine, Central Council of Homeopathy, the Central Family Welfare Council, the Transport Development Council, the University Grants Commission, and so on. The important conferences held either annually or otherwise to facilitate center-state consultation on a wide range of matters are as follows. I. The Governors' Conference, presided over by the President. 2. The Chief Ministers' Conference, presided over by the Prime Minister. 3. The Chief Secretaries' Conference, presided over by the Cabinet Secretary. 4. The Conference of Inspector General of Police. The Chief Justice's Conference, presided over by the Chief Justice of India. 6. The Conference of Vice Chancellors. 7. The Home Ministers' Conference, presided over by the Central Home Minister. 8. The Law Ministers' Conference, presided over by the Central Law Minister. Financial Relations. Articles 268 to 293 in Part 12 of the Constitution deal with center-state financial relations. Besides these, there are other provisions dealing with the same subject. These together can be studied under the following heads. Allocation of taxing powers. The Constitution divides the taxing powers between the center and the states in the following way. Times the Parliament has exclusive power to levy taxes on subjects enumerated in the Union list, which are 15 in number 12. Times the state legislature has exclusive power to levy taxes on subjects enumerated in the state list, which are 20 in number 13. Times both the Parliament and the state legislature can levy taxes on subjects enumerated in the concurrent list, which are 3 in number 14. Times the residuary power of taxation, that is, the power to impose taxes not enumerated in any of the 3 lists, is vested in the Parliament. Under this provision, the Parliament has imposed gift tax, wealth tax and expenditure tax. The Constitution also draws a distinction between the power to levy and collect a tax and the power to appropriate the proceeds of the tax so levied
and collected.
For example, the income tax is levied and collected by the center, but its proceeds are distributed between the center and the states. Further, the Constitution has placed the following restrictions on the taxing powers of the states. A state legislature can impose taxes on professions, trades, callings and employments. But the total amount of such taxes payable by any person should not exceed 2,500 rupees per annum. 15. 2. A state legislature can impose taxes on the sale or purchase of goods, other than newspapers. But this power of the states to impose sales tax is subjected to the 4 restrictions. A. No tax can be imposed on the sale or purchase taking place outside the states. B. No tax can be imposed on the sale or purchase taking place in the course of import or export. C. No tax can be imposed on the sale or purchase taking place in the course of interstate trade and commerce. And D. A tax imposed on the sale or purchase of goods declared by Parliament to be of special importance in inter-state trade and commerce is subject to the restrictions and conditions specified by the Parliament. 16. 3. A state legislature can impose tax on the consumption or sale of electricity. But no tax can be imposed on the consumption or sale of electricity which is A. Consumed by the center or sold to the center, or B. consumed in the construction, maintenance or operation of any railway by the centre or by the concerned railway company or sold to the centre or the railway company for the same purpose. 4. A state legislature can impose a tax in respect of any water or electricity stored, generated, consumed, distributed or sold by any authority established by Parliament for regulating or developing any interstate river or river valley. But such a law, to be effective, should be reserved for the President's consideration and receive his assent. Distribution of tax revenues. The 80th Amendment of 2000 and the 88th Amendment of 2003 have introduced major changes in the scheme of the distribution of tax revenues between the centre and the states. The 80th Amendment was enacted to give effect to the recommendations of the 10th Finance Commission. The Commission recommended that out of the total income obtained from certain central taxes and duties, 29% should go to the states. This is known as the alternative scheme of devolution, and came into effect retrospectively from 1 April 1996. This amendment has brought several central taxes and duties like corporation tax and customs duties at par with income tax, taxes on income other than agricultural income, as far as their constitutionally mandated sharing with the states is concerned. 17. The 88th Amendment has added a new Article 268 dealing with service tax. It also added a new subject in the Union List Entry 92-C, taxes on services. Service tax is levied by the centre but collected and appropriated by both the centre and the states. After these two amendments, the present position in this regard is as follows. A taxes levied by the centre but collected and appropriated by the states. Article 268. This category includes the following taxes and duties. I. Stamp duties on bills of exchange, checks, promissory notes, policies of insurance, transfer of shares and others. 2. Excise duties on medicinal and toilet preparations containing alcohol and narcotics. The proceeds of these duties levied within any state do not form a part of the Consolidated Fund of India, but are assigned to that state. B. Service tax levied by the centre but collected and appropriated by the centre and the states. Article 268-A. Taxes on services are levied by the centre, but their proceeds are collected as well as appropriated by both the centre and the states. The principles of their collection and appropriation are formulated by the Parliament. C. Taxes levied and collected by the centre but assigned to the states. Article 269. The following taxes fall under this category. I. Taxes on the sale or purchase of goods, other than newspapers, in the course of interstate trade or commerce. 2. Taxes on the consignment of goods in the course of interstate trade or commerce. The net proceeds of these taxes do not form a part of the Consolidated Fund of India. They are assigned to the concerned states in accordance with the principles laid down by the Parliament. D. Taxes levied and collected by the centre but distributed between the centre and the states. Article 270. This category includes all taxes and duties referred to in the Union List except the following. I. Duties and taxes referred to in Articles 268, 268-A and 269, mentioned above. 2. Surcharge on taxes and duties referred to in Article 271, mentioned below, and 3. Any cess levied for specific purposes. The manner of distribution of the net proceeds of these taxes and duties is prescribed by the President on the recommendation of the Finance Commission. E. Surcharge on certain taxes and duties for purposes of the centre. Article 271. The Parliament can at any time levy the surcharges on taxes and duties referred to in Articles 269 and 270, mentioned above. The proceeds of such surcharges go to the centre exclusively. In other words, the states have no share in these surcharges. F. Taxes levied and collected and retained by the states. These are the taxes belonging to the states exclusively. They are enumerated in the state list and are 20 in number. These are 18. I. Land revenue. 2. Taxes on agricultural income. Succession and estate duties in respect of agricultural land. 3. Taxes on lands and buildings, on mineral rights, on animals and boats, on road vehicles, on luxuries, on entertainments, and on gambling. 4. Excise duties on alcoholic liquors for human consumption and narcotics. Taxes on the entry of goods into a local area, on advertisements, except newspapers, on consumption or sale of electricity, and on goods and passengers carried by road or on inland waterways. 6. Taxes on professions, trades, callings and employments not exceeding 2,500 rupees per annum. 7. Capitation taxes. 8. Tolls. 9. Stamp duty on documents, except those specified in the Union list. Kissed smiley sales tax, other than newspaper. And 11. Fees on the matters enumerated in the state list, except court fees. Distribution of non-tax revenues. A. The center. The receipts from the following form the major sources of non-tax revenues of the center. I. Posts and telegraphs. 2. Railways. 3. Banking. 4. Broadcasting. Coinage and currency. 6. Central public sector enterprises. And 7. Escheat and lapse. 19b. The states. The receipts from the following form the major sources of non-tax revenues of the states. I. Irrigation. 2. Forests. 3. Fisheries. 4. State public sector enterprise. And escheat and lapse. 20 Grants in aid to the states. Besides sharing of taxes between the center and the states, the Constitution provides for grants in aid to the states from the central resources. There are two types of grants in aid, viz. Statutory grants and discretionary grants. Statutory grants. Article 275 empowers the Parliament to make grants to the states which are in need of financial assistance and not to every state. Also, different sums may be fixed for different states. These sums are charged on the Consolidated Fund of India every year. Apart from this general provision, the Constitution also provides for specific grants for promoting the welfare of the scheduled tribes in a state or for raising the level of administration of the scheduled areas in a state, including the state of Assam. The statutory grants under Article 275, both general and specific, are given to the states on the recommendation of the Finance Commission. Discretionary grants. Article 282 empowers both the center and the states to make any grants for any public purpose, even if it is not within their respective legislative competence. Under this provision, the center makes grants to the states. These grants are also known as discretionary grants, the reason being that the center is under no obligation to give these grants and the matter lies within its discretion. These grants have a twofold purpose: to help the state financially to fulfill plan targets, and to give some leverage to the center to influence and coordinate state action to effectuate the national plan. 21 Notably, the discretionary grants form the larger part of the central grants to the states, when compared with that of the statutory grants. Other grants. The Constitution also provided for a third type of grants in aid, but for a temporary period. Thus, a provision was made for grants in lieu of export duties on jute and jute products to the states of Assam, Bihar, Orissa and West Bengal. These grants were to be given for a period of 10 years from the commencement of the Constitution. These sums were charged on the Consolidated Fund of India and were made to the states on the recommendation of the Finance Commission. Finance Commission. Article 280 provides for a Finance Commission as a quasi-judicial body. It is constituted by the President every 5th year or even earlier. It is required to make recommendations to the President on the following matters: times the distribution of the net proceeds of taxes to be shared between the center and the states, and the allocation between the states, the respective shares of such proceeds; times the principles which should govern the grants in aid to the states by the center, i.e., out of the Consolidated Fund of India; times the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats and the municipalities in the state on the basis of the recommendations made by the State Finance Commission. 23 times any other matter referred to it by the President in the interests of sound finance. Till 1960, the Commission also suggested the amounts paid to the states of Assam, Bihar, Orissa and West Bengal in lieu of assignment of any share of the net proceeds in each year of export duty on jute and jute products. The Constitution envisages the Finance Commission as the balancing wheel of fiscal federalism in India. However, its role in the center-state fiscal relations has been undermined by the emergence of the Planning Commission, a non-constitutional and non-statutory body. Protection of the state's interest. To protect the interest of states in the financial matters, the Constitution lays down that the following bills can be introduced in the Parliament only on the recommendation of the President. Times a bill which imposes or varies any tax or duty in which states are interested. Times a bill which varies the meaning of the expression, agricultural income, as defined for the purposes of the enactments relating to Indian income tax. Times a bill which affects the principles on which monies are or may be distributable to states, and times a bill which imposes any surcharge on any specified tax or duty for the purpose of the center. The expression, tax or duty in which states are interested, means a tax or duty the whole or part of the net proceeds whereof are assigned to any state, or b. a tax or duty by reference to the net proceeds whereof sums are for the time being payable, out of the consolidated fund of India to any state. The phrase, net proceeds means the proceeds of a tax or a duty minus the cost of collection. The net proceeds of a tax or a duty in any area is to be ascertained and certified by the Controller and Auditor General of India. His certificate is final. Borrowing by the center and the states. The Constitution makes the following provisions with regard to the borrowing powers of the center and the states. Times the central government can borrow either within India or outside upon the security of the consolidated fund of India or can give guarantees, but both within the limits fixed by the Parliament. So far, no such law has been enacted by the Parliament. Times similarly, a state government can borrow within India, and not abroad, upon the security of the consolidated fund of the state or can give guarantees, but both within the limits fixed by the legislature of that state. Times the central government can make loans to any state or give guarantees in respect of loans raised by any state. Any sums required for the purpose of making such loans are to be charged on the consolidated fund of India. Times a state cannot raise any loan without the consent of the center, if there is still outstanding any part of a loan made to the state by the center or in respect of which a guarantee has been given by the center. Intergovernmental tax immunities. Like any other federal constitution, the Indian Constitution also contained the rule of immunity from mutual taxation, and makes the following provisions in this regard. Exemption of central property from state taxation. The property of center is exempted from all taxes imposed by a state or any authority within a state like municipalities, district boards, panchayats and so on. But the Parliament is empowered to remove this ban. The word property includes lands, buildings, chattels, shares, debts, everything that has a money value, and every kind of property, movable or immovable and tangible or intangible. Further, the property may be used for sovereign, like armed forces, or commercial purposes. The corporations or the companies created by the central government are not immune from state taxation or local taxation. The reason is that a corporation or a company is a separate legal entity. Exemption of state property or income from central taxation. The property and income of a state is exempted from central taxation. Such income may be derived from sovereign functions or commercial functions. But the center can tax the commercial operations of a state if Parliament so provides. However, the Parliament can declare any particular trade or business as incidental to the ordinary functions of the government, and it would then not be taxable. Notably, the property and income of local authorities situated within a state are not exempted from the central taxation. Similarly, the property or income of corporations and companies owned by a state can be taxed by the center. The Supreme Court, in an advisory opinion 24, 1963, held that the immunity granted to a state in respect of central taxation does not extend to the duties of customs or duties of excise. In other words, the center can impose customs duty on goods imported or exported by a state, or an excise duty on goods produced or manufactured by a state. Effects of emergencies. The center-state financial relations in normal times, described above, undergo changes during emergencies. These are as follows: national emergency. While the proclamation of national emergency, under Article 352, is in operation, the President can modify the constitutional distribution of revenues between the center and the states. This means that the President can either reduce or cancel the transfer of finances, both tax sharing and grants in aid, from the center to the states. Such modification continues till the end of the financial year in which the emergency ceases to operate. Financial emergency. While the proclamation of financial emergency, under Article 360, is in operation, the center can give directions to the states, I. to observe the specified canons of financial propriety, 2. to reduce the salaries and allowances of all class of persons serving in the state, including the High Court judges, and 3. to reserve all money bills and other financial bills for the consideration of the President. Trends in center-state relations till 1967. The center-state relations by and large were smooth due to one-party rule at the center and in most of the states. In 1967 elections, the Congress Party was defeated in 9 states and its position at the center became weak. This changed political scenario heralded a new era in the center-state relations. The non-Congress governments in the states opposed the increasing centralization and intervention of the central government. They raised the issue of state autonomy and demanded more powers and financial resources to the states. This caused tensions and conflicts in center-state relations. Tension areas in center-state relations. The issues which created tensions and conflicts between the center and states are: 1. Mode of appointment and dismissal of governor. 2. Discriminatory and partisan role of governors. 3. Imposition of president's rule for partisan interests. 4. Deployment of central forces in the states to maintain law and order. 5. Reservation of state bills for the consideration of the president. 6. Discrimination in financial allocations to the states. 7. Role of Planning Commission in approving state projects. 8. Management of All India Services, IAS, IPS, and IFS. 9. Use of electronic media for political purposes. 10. Appointment of enquiry commissions against the chief ministers. 11. Sharing of finances between center and states. And 12. Encroachment by the center on the state list. The issues in center-state relations have been under consideration since the mid-1960s. In this direction, the following developments have taken place. Administrative Reforms Commission. The central government appointed a 6-member Administrative Reforms Commission, ARC, in 1966 under the chairmanship of Morarji Desai, followed by K. Hanumantarya. Its terms of references included, among others, the examination of center-state relations. In order to examine thoroughly the various issues in center-state relations, the ARC constituted a study team under M.C. Setalvad. On the basis of the report of this study team, the ARC finalized its own report and submitted it to the central government in 1969. It made 22 recommendations for improving the center-state relations. The important recommendations are: times establishment of an interstate council under Article 263 of the Constitution. Times appointment of persons having long experience in public life and administration and non-partisan attitude as governors. Times delegation of powers to the maximum extent to the states. Times transferring of more financial resources to the states to reduce their dependency upon the center. Times deployment of central armed forces in the states either on their request or otherwise. No action was taken by the central government on the recommendations of the ARC. Rajmannar Committee in 1969, the Tamil Nadu government, DMK, appointed a three-member committee under the chairmanship of Dr. P.V. Rajmannar to examine the entire question of center-state relations and to suggest amendments to the constitution so as to secure utmost autonomy to the states. 25 The committee submitted its report to the Tamil Nadu government in 1971. The committee identified the reasons for the prevailing unitary trends, tendencies of centralization, in the country. They include, I. Certain provisions in the constitution which confer special powers on the center. 2. One-party rule both at the center and in the states. 3. Inadequacy of states' fiscal resources and consequent dependence on the center for financial assistance. And 4. The institution of central planning and the role of the Planning Commission. The important recommendations of the committee are as follows. I. An interstate council should be set up immediately. 2. Finance Commission should be made a permanent body. 3. Planning Commission should be disbanded and its place should be taken by a statutory body. 4. Articles 356, 357 and 365, dealing with President's rule, should be totally omitted. The provision that the state ministry holds office during the pleasure of the governor should be omitted. 6. Certain subjects of the union list and the concurrent list should be transferred to the state list. 7. The residuary powers should be allocated to the states. And 8. All India services, IAS, IPS and IFs, should be abolished. The central government completely ignored the recommendations of the
Rajmannar Committee.
Anandpur Sahib Resolution in 1973. The Akali Dal adopted a resolution containing both political and religious demands in a meeting held at Anandpur Sahib in Punjab. The resolution, generally known as Anandpur Sahib Resolution, demanded that the centre's jurisdiction should be restricted only to defence, foreign affairs, communications, and currency, and the entire residuary powers should be vested in the states. It stated that the constitution should be made federal in the real sense and should ensure equal authority and representation to all the states at the center. West Bengal Memorandum in 1977, the West Bengal government, led by the Communists, published a memorandum on center-state relations and sent to the central government. The memorandum inter alia suggested the following. I. The word union in the constitution should be replaced by the word federal. 2. The jurisdiction of the center should be confined to defense, foreign affairs, currency, communications and economic coordination. 3. All other subjects including the residuary should be vested in the states. 4. Articles 356 and 357, President's Rule, and 360, Financial Emergency, should be repealed. States' consent should be made obligatory for formation of new states or reorganization of existing states. 6. Of the total revenue raised by the center from all sources, 75% should be allocated to the states. 7. Rajya Sabha should have equal powers with that of the Lok Sabha. And 8. There should be only central and state services and the All India services should be abolished. The central government did not accept the demands made in the memorandum. Sarkaria Commission in 1983, the central government appointed a three-member commission on center-state relations under the chairmanship of R.S. Sarkaria, a retired judge
Of the Supreme Court.
26. The commission was asked to examine and review the working of existing arrangements between the center and states in all spheres and recommend appropriate changes and measures. It was initially given 1 year to complete its work, but its term was extended 4 times. The final report was submitted in October 1987, and the summary was later officially released in January 1988. The Commission did not favor structural changes and regarded the existing constitutional arrangements and principles relating to the institutions basically sound. But it emphasized on the need for changes in the functional or operational aspects. It observed that federalism is more a functional arrangement for cooperative action than a static institutional concept. It outrightly rejected the demand for curtailing the powers of the center and stated that a strong center is essential to safeguard the national unity and integrity which is being threatened by the vociferous tendencies in the body politic. However, it did not equate strong center with centralization of powers. It observed that over-centralization leads to blood pressure at the center and anemia at the periphery. The Commission made 247 recommendations to improve center-state relations. The important recommendations are mentioned below. 1. A permanent interstate council called the Intergovernmental Council should be set up under Article 263. 2. Article 356. President's rule should be used very sparingly, in extreme cases as a last resort when all the available alternatives fail. 3. The institution of All India services should be further strengthened and some more such services should be created. 4. The residuary powers of taxation should continue to remain with the Parliament, while the other residuary powers should be placed in the concurrent list. 5. When the President withholds his assent to the state bills, the reasons should be communicated to the state government. 6. The National Development Council, NDC, should be renamed and reconstituted as the National Economic and Development Council, NEDC. 7. The zonal councils should be constituted afresh and reactivated to promote the spirit of federalism.
8. The center should have powers to deploy its armed forces, even without the consent of states.
However, it is desirable that the states should be consulted. 9. The center should consult the states before making a law on a subject of the concurrent list. 10. The procedure of consulting the chief minister in the appointment of the state governor should be prescribed in the constitution itself. 11. The net proceeds of the corporation tax may be made permissibly shareable with the states. 12. The governor cannot dismiss the council of ministers so long as it commands a majority in the assembly. 13. The governor's term of 5 years in a state should not be disturbed except for some extremely compelling reasons. 14. No commission of enquiry should be set up against a state minister unless a demand is made by the Parliament. 15. The surcharge on income tax should not be levied by the centre except for a specific purpose and for a strictly limited period. 16. The present division of functions between the Finance Commission and the Planning Commission is reasonable and should continue. 17. Steps should be taken to uniformly implement the three-language formula in its true spirit. 18. No autonomy for radio and television but decentralization in their operations. 19. No change in the role of Rajya Sabha and centre's power to reorganize the states. 20. The Commissioner for Linguistic Minorities should be activated. The central government has implemented 180 out of 247 recommendations of the Sarkaria Commission. 27. The most important is the establishment of the Interstate Council in 1990. Panchchi Commission. The second commission on center-state relations was set up by the Government of India in April 2007 under the chairmanship of Madan Mohan Panchchi, former Chief Justice of India. 28. It was required to look into the issues of center-state relations keeping in view the sea changes that have taken place in the polity and economy of India since the Sarkaria Commission had last looked at the issue of center-state relations over 2 decades ago. The terms of reference of the Commission were as follows. I. The Commission was required to examine and review the working of the existing arrangements between the Union and states as per the Constitution of India, the healthy precedents being followed, various pronouncements of the courts in regard to powers, functions and responsibilities in all spheres including legislative relations, administrative relations, role of governors, emergency provisions, financial relations, economic and social planning, Panchayati Raj institutions, sharing of resources including interstate river water, and recommend such changes or other measures as may be appropriate keeping in view the practical difficulties. 2. In examining and reviewing the working of the existing arrangements between the Union and states and making recommendations as to the changes and measures needed, the Commission was required to keep in view the social and economic developments that have taken place over the years, particularly over the last 2 decades, and have due regard to the scheme and framework of the Constitution. Such recommendations were also needed to address the growing challenges of ensuring good governance for promoting the welfare of the people whilst strengthening the unity and integrity of the country, and of availing emerging opportunities for sustained and rapid economic growth for alleviating poverty and illiteracy in the early decades of the new millennium. 3. While examining and making its recommendations on the above, the Commission was required to have particular regard, but not limit its mandate to the following: the role, responsibility and jurisdiction of the Centre vis-à-vis states during major and prolonged outbreaks of communal violence, caste violence or any other social conflict leading to prolonged and escalated violence. B. The role, responsibility and jurisdiction of the Centre vis-à-vis states in the planning and implementation of the mega projects like the interlinking of rivers, that would normally take 15-20 years for completion and hinged vitally on the support of the states. C. The role, responsibility and jurisdiction of the Centre vis-à-vis states in promoting effective devolution of powers and autonomy to Panchayati Raj institutions and local bodies including the autonomous bodies under the 6th schedule of the Constitution within a specified period of time. D. The role, responsibility and jurisdiction of the Centre vis-à-vis states in promoting the concept and practice of independent planning and budgeting at the district level. E. The role, responsibility and jurisdiction of the Centre vis-à-vis states in linking central assistance of various kinds with the performance of the states. F. The role, responsibility and jurisdiction of the Centre in adopting approaches and policies based on positive discrimination in favor of backward states. G. The impact of the recommendations made by the 8th to 12th Finance Commissions on the fiscal relations between the Centre and the states, especially the greater dependence of the states on devolution of funds from the Centre. H. The need and relevance of separate taxes on the production and on the sales of goods and services subsequent to the introduction of value-added tax regime. I. The need for freeing interstate trade in order to establish a unified and integrated domestic market, as also in the context of the reluctance of state governments to adopt the relevant Circular Commission's recommendation in Chapter 18 of its report. J. The need for setting up a central law enforcement agency empowered to take up suo motu investigation of crimes having interstate and/or international ramifications with serious implications on national security. K. The feasibility of a supporting legislation under Article 355 for the purpose of suo motu deployment of central forces in the states if and when the situation so demands. The Commission submitted its report to the government in April 2010. In finalizing the 1,456-page report, in 7 volumes, the Commission took extensive help from the Circular Commission report, the National Commission to Review the Working of the Constitution, NCRWC, report and the Second Administrative Reforms Commission report. However, in a number of areas, the Commission's report differed from the Circular Commission's recommendations. After examining at length the issues raised in its terms of reference and the related aspects in all their hues and shades, the Commission came to the conclusion that cooperative federalism will be the key for sustaining India's unity, integrity and social and economic development in future. The principles of cooperative federalism thus may have to act as a practical guide for Indian polity and governance. In all, the Commission made over 310 recommendations, touching upon several significant areas in the working of Centre-State relations. The important recommendations are mentioned below. 1. To facilitate effective implementation of the laws on List 3 subjects, it is necessary that some broad agreement is reached between the Union and states before introducing legislation in Parliament on matters in the concurrent list. 2. The Union should be extremely restrained in asserting parliamentary supremacy in matters assigned to the states. Greater flexibility to states in relation to subjects in the state list and transferred items in the concurrent list is the key for better Centre-State relations. 3. The Union should occupy only that many of subjects in concurrent or overlapping jurisdiction which are absolutely necessary to achieve uniformity of policy in demonstrable national interest. 4. There should be a continuing auditing role for the Interstate Council in the management of matters in concurrent or overlapping jurisdiction. 5. The period of 6 months prescribed in Article 201 for state legislature to act when the bill is returned by the President can be made applicable for the President also to decide on assenting or withholding assent to a state bill reserved for consideration of the President. 6. Parliament should make a law on the subject of entry 14 of List I, treaty making and implementing it through parliamentary legislation, to streamline the procedures involved. The exercise of the power obviously cannot be absolute or unchartered in view of the federal structure of legislative and executive powers. 7. Financial obligations and its implications on state finances arising out of treaties and agreements should be a permanent term of reference to the finance commissions constituted from time to time. 8. While selecting governors, the central government should adopt the following strict guidelines as recommended in the Circular Commission report and follow its mandate in letter and spirit. I. He should be eminent in some walk of life. 2. He should be a person from outside the state. 3. He should be a detached figure and not too intimately connected with the local politics of the states. 4. He should be a person who has not taken too great a part in politics generally and particularly. In the recent past 9. Governors should be given a fixed tenure of 5 years and their removal should not be at the sweet will of the government at the center. 10. The procedure laid down for impeachment of President, mutatis mutandis, can be made applicable for impeachment of governors as well. 11. Article 163 does not give the governor a general discretionary power to act against or without the advice of his council of ministers. In fact, the area for the exercise of discretion is limited, and even in this limited area, his choice of action should not be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith and tempered by caution. 12. In respect of bills passed by the Legislative Assembly of a state, the governor should take the decision within 6 months whether to grant assent or to reserve it for consideration of the President. 13. On the question of governor's role in appointment of chief minister in the case of an hung assembly, it is necessary to lay down certain clear guidelines to be followed as constitutional conventions. These guidelines may be as follows. I. The party or combination of parties which commands the widest support in the Legislative Assembly should be called upon to form the government. 2. If there is a pre-poll alliance or coalition, it should be treated as one political party, and if such coalition obtains a majority, the leader of such coalition shall be called by the governor to form the government.
3. In case no party or
pre-poll coalition has a clear majority, the governor should select the chief minister in the order of preference indicated here. A. The group of parties which had pre-poll alliance commanding the largest number. B. The largest single party staking a claim to form the government with the support of others. C. A post-electoral coalition with all partners joining the government. D. A post-electoral alliance with some parties joining the government and the remaining including independents supporting the government from outside. 14. On the question of dismissal of a chief minister, the governor should invariably insist on the chief minister proving his majority on the floor of the House, for which he should prescribe a time limit. 15. The governor should have the right to sanction for prosecution of a state minister against the advice of the Council of Ministers, if the cabinet decision appears to the governor to be motivated by bias in the face of overwhelming material. 16. The Convention of Governors acting as chancellors of universities and holding other statutory positions should be done away with. His role should be confined to the constitutional provisions only. 17. When an external aggression or internal disturbance paralyzes the state administration, creating a situation of a potential breakdown of the constitutional machinery of the state, all alternative courses available to the Union for discharging its paramount responsibility under Article 355 should be exhausted to contain the situation, and the exercise of the power under Article 356 should be limited strictly to rectifying a failure of the constitutional machinery in the state. 18. On the question of invoking Article 356 in case of failure of constitutional machinery in states, suitable amendments are required to incorporate the guidelines set forth in the landmark judgment of the Supreme Court in S. R. Bommai v. Union of India, 1994. This would remove possible misgivings in this regard on the part of states and help in smoothing center-state relations. 19. Given the strict parameters now set for invoking the emergency, provisions under Articles 352 and 356 to be used only as a measure of last resort, and the duty of the Union to protect states under Article 355, it is necessary to provide a constitutional or legal framework to deal with situations which require central intervention but do not warrant invoking the extreme steps under Articles 352 and 356. Providing the framework for localized emergency would ensure that the state government can continue to function and the assembly would not have to be dissolved, while providing a mechanism to let the central government respond to the issue specifically and locally. The imposition of local emergency is fully justified under the mandate of Article 355 read with Entry 2 of List I and Entry 1 of List 2 of the 7th Schedule. 20. Suitable amendments to Article 263 are required to make the Interstate Council a credible, powerful and fair mechanism for management of interstate and center-state differences. 21. The zonal councils should meet at least twice a year with an agenda proposed by states concerned to maximize coordination and promote harmonization of policies and action having interstate ramification. The Secretariat of a strengthened interstate council can function as the Secretariat of the zonal councils as well. 22. The Empowered Committee of Finance Ministers of States proved to be a successful experiment in interstate coordination on fiscal matters. There is need to institutionalize similar models in other sectors as well. A forum of chief ministers, chaired by one of the chief minister by rotation, can be similarly thought about, particularly to coordinate policies of sectors like energy, food, education, environment and health. 23. New All India services in sectors like health, education, engineering and judiciary should be created. 24. Factors inhibiting the composition and functioning of the second chamber as a representative forum of states should be removed or modified, even if it requires amendment of the constitutional provisions. In fact, Rajya Sabha offers immense potential to negotiate acceptable solutions to the friction points which emerge between centre and states in fiscal, legislative and administrative relations. 25. A balance of power between states inter se is desirable, and this is possible by equality of representation in the Rajya Sabha. This requires amendment of the relevant provisions to give equality of seats to states in the Rajya Sabha, irrespective of their population size. 26. The scope of devolution of powers to local bodies to act as institutions of self-government should be constitutionally defined through appropriate amendments. 27. All future central legislations involving states' involvement should provide for cost sharing as in the case of the RTE Act. Existing central legislations where the states are entrusted with the responsibility of implementation should be suitably amended, providing for sharing of costs by the central government. 28. The royalty rates on major minerals should be revised at least every 3 years without any delay. States should be properly compensated for any delay in the revision of royalty beyond 3 years. 29. The current ceiling on profession tax should be completely done away with by a constitutional amendment. 30. The scope for raising more revenue from the taxes mentioned in Article 268 should be examined afresh. This issue may be either referred to the next Finance Commission or an expert committee be appointed to look into the matter. 31. To bring greater accountability, all fiscal legislations should provide for an annual assessment by an independent body, and the reports of these bodies should be laid in both houses of Parliament state legislature. 32. Considerations specified in the terms of reference, TOR, of the Finance Commission should be even-handed as between the centre and the states. There should be an effective mechanism to involve the states in the finalization of the TOR of the Finance Commissions. 33. The central government should review all the existing cesses and surcharges with a view to bringing down their share in the gross tax revenue. 34. Because of the close linkages between the plan and non-plan expenditure, an expert committee may be appointed to look into the issue of distinction between the plan and non-plan expenditure. 35. There should be much better coordination between the Finance Commission and the Planning Commission. The synchronization of the periods covered by the Finance Commission and the 5-year plan will considerably improve such coordination. 36. The Finance Commission division in the Ministry of Finance should be converted into a full-fledged department, serving as the permanent secretariat for the Finance Commissions. 37. The Planning Commission has a crucial role in the current situation, but its role should be that of coordination rather than that of micromanaging sectoral plans of the central ministries and the states. 38. Steps should be taken for the setting up of an Interstate Trade and Commerce Commission under Article 307 read with entry 42 of List I. This commission should be vested with both advisory and executive roles with decision-making powers. As a constitutional body, the decisions of the Commission should be final and binding on all states as well as the Union of India. Any party aggrieved with the decision of the Commission may prefer an appeal to the Supreme Court. The report of the Commission was circulated to all stakeholders including state governments, duty administrations and union ministries departments concerned for their considered views on the recommendations of the Commission. The comments received from the union ministries departments and the state governments' duty administrations are being examined by ISC, Interstate Council, Secretariat and would be put up to the ISC for its consideration. 22 Table 14.1 Articles related to Centre-State legislative relations at a glance. Article No. Subject Matter 245. Extent of laws made by Parliament and by the legislatures of states. 246. Subject matter of laws made by Parliament and by the legislatures of states. 247. Power of Parliament to provide for the establishment of certain additional courts. 248. Residuary powers of legislation. 249. Power of Parliament to legislate with respect to a matter in the state list in the national interest. Power of Parliament to legislate with respect to any matter in the 250 state list if a proclamation of emergency is in operation. 251. Inconsistency between laws made by Parliament under Articles 249 and 250 and laws made by the legislatures of states. 252. Power of Parliament to legislate for two or more states by consent and adoption of such legislation by any other state. 253. Legislation for giving effect to international agreements. 254. Inconsistency between laws made by Parliament and laws made by the legislatures of states. 255. Requirements as to recommendations and previous sanctions to be regarded as matters of procedure only. Table 14.2 Articles related to Centre-State administrative relations at a glance. Article No. Subject Matter 256. Obligation of states and the Union. 257. Control of the Union over states in certain cases. 257a. Assistance to states by deployment of armed forces or other forces of the Union. Repealed. 258. Power of the Union to confer powers, etc., on states in certain cases. 258a. Power of the states to entrust functions to the Union. 259. Armed forces in states in Part B of the first schedule. Repealed. 260. Jurisdiction of the Union in relation to territories outside India. 261. Public acts, records and judicial proceedings. Adjudication of disputes relating to waters of interstate rivers or. 262. River valleys. 263 Provisions with respect to an interstate council. Table 14.3 Articles related to centre-state financial relations at a glance. Article No. Subject matter distribution of revenues between the Union and the states. 268. Duties levied by the Union but collected and appropriated by the states. 268a. Service tax levied by Union and collected and appropriated by the Union and the states. 269. Taxes levied and collected by the Union but assigned to the states. 270. Taxes levied and distributed between the Union and the states. 271. Surcharge on certain duties and taxes for purposes of the Union. 272. Taxes which are levied and collected by the Union and may be distributed between the Union and the states. Repealed. 273. Grants in lieu of export duty on jute and jute products. 274. Prior recommendation of President required to bills affecting taxation in which states are interested. 275. Grants from the Union to certain states. 276. Taxes on professions, trades, callings and employments. 277. Savings. 278. Agreement with states in Part B of the first schedule with regard to certain financial matters. Repealed. 279. Calculation of net proceeds, etc. 280. Finance Commission. 281. Recommendations of the Finance Commission. Miscellaneous financial provisions. 282. Expenditure defrayable by the Union or a state out of its revenues. 283. Custody, etc., of consolidated funds, contingency funds and monies credited to the public accounts. 284. Custody of suitors' deposits and other monies received by public servants and courts. 285. Exemption of property of the Union from state taxation. 286. Restrictions as to imposition of tax on the sale or purchase of goods. 287. Exemption from taxes on electricity. 288. Exemption from taxation by states in respect of water or electricity in certain cases. 289. Exemption of property and income of a state from union taxation. 290. Adjustment in respect of certain expenses and pensions. 298. Annual payment to certain devaswum funds. 291. Privy purse sums of rulers. Repealed. Borrowing. 292. Borrowing by the Government of India. 293. Borrowing by states notes and references. 1. Even now, the last entry is numbered as 97 but the total number of entries is 100. The entries numbered as 2A9, 2A9, 2B and 92C have been added and entry 33 has been omitted. See Appendix 2. 2. Even now, the last entry is numbered as 66 but the total number of entries is 61. The entries numbered as 11, 19, 20, 29 and 36 have been omitted. See Appendix 2. 3. Even now, the last entry is numbered as 47 but the total number of entries
is 52.
The entries numbered as 11, A 17, A 17B, 20A and 33 have been added. See Appendix 2. 4. Report of the Commission on Centre-State Relations, Part I, Government of India, 1988, pp. 28-29. 5. For example, under the Essential Commodities Act, made by the Parliament on a concurrent subject, the executive power is vested in the centre. 6. This provision, the power of the states to entrust functions to the centre, was added by the 7th Constitutional Amendment Act of 1956. Before that, only the centre had the power. 7. For details in this regard, see Chapter 15. 8. Constituent Assembly Debates, Volume 7, pp. 41 to 42. 9. For details, see Chapter 52. 10. For details, see Chapter 74. 11. For details, see Chapter 15. 12. Entries, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 92A, 92B, 92C and 96. See Appendix 2. 13. Entries, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, and 66. See Appendix 2. 14. Entries, 35, 44 and 47. See Appendix 2. 15. Originally, this limit was only 250 rupees per annum. The 60th Amendment Act of 1988 raised it to 2,500 rupees per annum. 16. The Additional Duties of Excise, Goods of Special Importance, Act of 1957, enacted by the Parliament, has declared tobacco, sugar, silk, cotton and woolen fabrics to be goods of special importance in interstate trade and commerce. 17. This amendment deleted Article 272, taxes which are levied and collected by the centre and may be distributed between the centre and the states. 18. Mentioned group-wise. Hence, reduced to 11, from 20. See Appendix 2. 19c, Property of the Union, in Chapter 64. 20c, Property of the States in Chapter 64. 21. MP Jain, Indian Constitutional Law, Wadhwa, 4th edition, pp. 342-43. 22. Annual Report 2015-16, Ministry of Home Affairs, Government of India, p.58. 23. This function was added by the 73rd and 74th Amendment Acts of 1992, which have granted constitutional status on the panchayats and the municipalities respectively. 24. In re. See Customs Act, 1963. 25. The other two members of the committee were Dr. Lakshmanswamy Mudaliar and P.C. Chandra Reddy. 26. V. Sivaraman and S.R. Sain were two other members of the commission. 27. Annual Report 2011-12, Ministry of Home Affairs, Government of India, p.79. 28. The other four members of the commission were Dhirendra Singh, former Secretary to the Government of India, Vinod Kumar Dugal, former Secretary to the Government of India, Professor N.R. Madhava Menon, former Director, National Judicial Academy, Bhopal and National Law School of India, Bangalore, and Dr. Amresh Bagachi, Emeritus Professor, National Institute of Public Finance and Policy, New Delhi. With the passing away of Dr. Bagachi in February 2008, Vijay Shankar, former Director, Central Bureau of Investigation, Government of India, was appointed in his place as a member of the Commission in October 2008. Interstate relations. The successful functioning of the Indian federal system depends not only on the harmonious relations and close cooperation between the centre and the states but also between the states inter se. Hence, the Constitution makes the following provisions with regard to interstate comity: 1. Adjudication of interstate water disputes. 2. Coordination through interstate councils. 3. Mutual recognition of public acts, records and judicial proceedings. 4. Freedom of interstate trade, commerce and intercourse. In addition, the zonal councils have been established by the Parliament to promote interstate cooperation and coordination. Interstate water disputes. Article 262 of the Constitution provides for the adjudication of interstate water disputes. It makes two provisions. I. Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution and control of waters of any interstate river and river valley. 2. Parliament may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect of any such dispute or complaint. Under this provision, the Parliament has enacted two laws: the River Boards Act, 1956, and the Interstate Water Disputes Act, 1956. The River Boards Act provides for the establishment of river boards for the regulation and development of interstate river and river valleys. A river board is established by the central government on the request of the state governments concerned to advise them. The Interstate Water Disputes Act empowers the central government to set up an ad hoc tribunal for the adjudication of a dispute between two or more states in relation to the waters of an interstate river or river valley. The decision of the tribunal would be final and binding on the parties to the dispute. Neither the Supreme Court nor any other court is to have jurisdiction in respect of any water dispute which may be referred to such a tribunal under this Act. The need for an extrajudicial machinery to settle interstate water disputes is as follows. The Supreme Court would indeed have jurisdiction to decide any dispute between states in connection with water supplies, if legal rights or interests are concerned, but the experience of most countries has shown that rules of law based upon the analogy of private proprietary interests in water do not afford a satisfactory basis for settling disputes between the states where the interests of the public at large in the proper use of water supplies are involved. 1 So far, 2016, the central government has set up 8 interstate water dispute tribunals. The name of the tribunals, the years in which they were constituted and the states involved in the dispute are mentioned in Table 15.1. Table 15.1 Interstate Water Dispute Tribunals set up so far Sai. No. Name set up in states involved 1. Krishna Water Disputes Tribunal 1969 Maharashtra, Karnataka and Andhra Pradesh 2. Godavari Water Disputes Tribunal 1969 Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh and Odisha Narmada Water Rajasthan, Gujarat, Madhya Pradesh. 3 Disputes Tribunal 1969 and Maharashtra 4. Ravi and Bees Water Disputes Tribunal 1986 Punjab, Haryana and Rajasthan 5. Koveri Water Disputes Tribunal 1990 Karnataka, Kerala, Tamil Nadu and Puducherry 6. 2nd Krishna Water Disputes Tribunal 2004 Maharashtra, Karnataka and Andhra Pradesh 7. 1 Sadra Water Disputes Tribunal 2010 Odisha and Andhra Pradesh 8. Mahadayi Water Disputes Tribunal 2010 Goa, Karnataka and Maharashtra Interstate Councils Article 263 contemplates the establishment of an interstate council to effect coordination between the states and between centre and states. Thus, the President can establish such a council if at any time it appears to him that the public interest would be served by its establishment. He can define the nature of duties to be performed by such a council and its organization and procedure. Even though the President is empowered to define the duties of an interstate council, Article 263 specifies the duties that can be assigned to it in the following manner. A. Enquiring into and advising upon disputes which may arise between states. B. Investigating and discussing subjects in which the states or the centre and the states have a common interest. And C. Making recommendations upon any such subject, and particularly for the better coordination of policy and action on it. The Council's function to enquire and advise upon interstate disputes is complementary to the Supreme Court's jurisdiction under Article 131 to decide a legal controversy between the governments. The Council can deal with any controversy, whether legal or non-legal, but its function is advisory, unlike that of the court, which gives a binding decision. 2. Under the above provisions of Article 263, the President has established the following councils to make recommendations for the better coordination of policy and action in the related subjects. Times Central Council of Health. Times Central Council of Local Government and Urban Development. 3 times 4 Regional Councils for Sales Tax for the Northern, Eastern, Western and Southern zones. The Central Council of Indian Medicine and the Central Council of Homeopathy were set up under the Acts of Parliament. 4 Establishment of Interstate Council. The Sarkaria Commission on Centre-State Relations, 1983-87, made a strong case for the establishment of a permanent interstate council under Article 263 of the Constitution. It recommended that in order to differentiate the interstate council from other bodies established under the same Article 263, it must be called as the Intergovernmental Council. The Commission recommended that the Council should be charged with the duties laid down in clauses B and C of Article 263, see above. In pursuance of the above recommendations of the Sarkaria Commission, the Janata Dal government headed by VP Singh established the Interstate Council in 1990.5. It consists of the following members: I. Prime Minister as the chairman. 2. Chief Ministers of all the states. 3. Chief Ministers of Union Territories having legislative assemblies. 4. Administrators of Union Territories not having legislative assemblies. We. Governors of states under President's rule. 6. Central Cabinet. Ministers, including the Home Minister, to be nominated by the Prime Minister. 5 Ministers of Cabinet rank Minister of State, independent charge, nominated by the Chairman of the Council, i.e., Prime Minister, are permanent invitees to the Council. The Council is a recommendatory body on issues relating to interstate, center-state and center-union territories relations. It aims at promoting coordination between them by examining, discussing and deliberating on such issues. Its duties, in detail, are as follows: times investigating and discussing such subjects in which the states or the center have a common interest, times making recommendations upon any such subject for the better coordination of policy and action on it, and times deliberating upon such other matters of general interest to the states as may be referred to it by the chairman. The council may meet at least thrice in a year. Its meetings are held in camera and all questions are decided by consensus. There is also a standing committee of the council. It was set up in 1996 for continuous consultation and processing of matters for the consideration of the council. It consists of the following members: I. Union Home Minister as the chairman. 2. 5 Union Cabinet Ministers. 3. 9 Chief Ministers. The council is assisted by a secretariat called the Interstate Council Secretariat. This secretariat was set up in 1991 and is headed by a secretary to the Government of India. Since 2011, it is also functioning as the secretariat of the zonal councils. Public acts, records and judicial proceedings under the Constitution, the jurisdiction of each state is confined to its own territory. Hence, it is possible that the acts and records of one state may not be recognized in another state. To remove any such difficulty, the Constitution contains the full faith and credit clause, which lays down the following: I. Full faith and credit is to be given throughout the territory of India to public acts, records and judicial proceedings of the centre and every state. The expression public acts includes both legislative and executive acts of the government. The expression public record includes any official book, register or record made by a public servant in the discharge of his official
duties.
2. The manner in which and the conditions under which such acts, records and proceedings are to be proved and their effect determined would be as provided by the laws of Parliament. This means that the general rule mentioned above is subject to the power of Parliament to lay down the mode of proof as well as the effect of such acts, records and proceedings of one state in another state. 3. Final judgments and orders of civil courts in any part of India are capable of execution anywhere within India, without the necessity of a fresh suit upon the judgment. The rule applies only to civil judgments and not to criminal judgments. In other words, it does not require the courts of a state to enforce the penal laws of another state. Interstate Trade and Commerce Articles 301 to 307 in Part 13 of the Constitution deal with the trade, commerce and intercourse within the territory of India. Article 301 declares that trade, commerce and intercourse throughout the territory of India shall be free. The object of this provision is to break down the border barriers between the states and to create one unit with a view to encourage the free flow of trade, commerce and intercourse in the country. The freedom under this provision is not confined to interstate trade, commerce and intercourse but also extends to intrastate trade, commerce and intercourse. Thus, Article 301 will be violated whether restrictions are imposed at the frontier of any state or at any prior or subsequent stage. The freedom guaranteed by Article 301 is a freedom from all restrictions, except those which are provided for in the other provisions, Articles 302 to 305, of Part 13 of the Constitution itself. These are explained below. I. Parliament can impose restrictions on the freedom of trade, commerce and intercourse between the states or within a state in public interest. 6 But the Parliament cannot give preference to one state over another or discriminate between the states except in the case of scarcity of goods in any part of India. 2. The legislature of a state can impose reasonable restrictions on the freedom of trade, commerce and intercourse with that state or within that
state in public interest. But
a bill for this purpose can be introduced in the legislature only with the previous sanction of the President. Further, the state legislature cannot give preference to one state over another or discriminate between the states. 3. The legislature of a state can impose on goods imported from other states or the union territories any tax to which similar goods manufactured in that state are subject. This provision prohibits the imposition of discriminatory taxes by the state. 4. The freedom, under Article 301, is subject to the nationalization laws, i.e., laws providing for monopolies in favor of the center or the states. Thus, the Parliament or the state legislature can make laws for the carrying on by the respective government of any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. The Parliament can appoint an appropriate authority for carrying out the purposes of the above provisions relating to the freedom of trade, commerce and intercourse and restrictions on it. The Parliament can also confer on that authority the necessary powers and duties. But no such authority has been appointed so far. 7 Zonal councils. The zonal councils are the statutory, and not the constitutional, bodies. They are established by an act of the Parliament, that is, States Reorganization Act of 1956. The act divided the country into 5 zones: northern, central, eastern, western and southern, and provided a zonal council for each zone. While forming these zones, several factors have been taken into account which include the natural divisions of the country, the river systems and means of communication, the cultural and linguistic affinity and the requirements of economic development, security and law and order. Each zonal council consists of the following members: A. Home Minister of Central Government. B. Chief Ministers of all the states in the zone. C. 2 other ministers from each state in the zone. D. Administrator of each union territory in the zone. Besides, the following persons can be associated with the zonal council as advisors, i.e., without the right to vote in the meetings, I. A person nominated by the Planning Commission. 2. Chief Secretary of the government of each state in the zone, and 3. Development Commissioner of each state in the zone. The Home Minister of Central Government is the common chairman of the 5 zonal councils. Each Chief Minister acts as a Vice Chairman of the Council by rotation, holding office for a period of 1 year at a time. The zonal councils aim at promoting cooperation and coordination between states, union territories and the center. They discuss and make recommendations regarding matters like economic and social planning, linguistic minorities, border disputes, interstate transport, and so on. They are only deliberative and advisory bodies. The objectives, or the functions, of the zonal councils, in detail, are as follows: times to achieve an emotional integration of the country, times to help in arresting the growth of acute state consciousness, regionalism, linguism and particularistic trends, times to help in removing the after effects of separation in some cases so that the process of reorganization, integration and economic advancement may synchronize, times to enable the center and states to cooperate with each other in social and economic matters and exchange ideas and experience in order to evolve uniform policies, times to cooperate with each other in the successful and speedy execution of major development projects, times to secure some kind of political equilibrium between different regions of the country. Northeastern Council. In addition to the above zonal councils, a Northeastern Council was created by a separate Act of Parliament, the Northeastern Council Act of 1971.8. Its members include Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, Tripura and Sikkim. 9. Its functions are similar to those of the zonal councils, but with few additions. It has to formulate a unified and coordinated regional plan covering matters of common importance, It has to review from time to time the measures taken by the member states for the maintenance of security and public order in the region. Table 15.2 Zonal Councils at a glance. Name members. Headquarters 1. Northern Zonal Council Jammu and Kashmir, Himachal Pradesh, Haryana, Punjab, Rajasthan, Delhi, and Chandigarh. New Delhi 2. Central Zonal Council Uttar Pradesh, Uttarakhand, Chhattisgarh, and Madhya Pradesh. Allahabad 3. Eastern Zonal Council Bihar, Odisha, Jharkhand, West Bengal and Kolkata 4. Western Zonal Council Gujarat, Maharashtra, Goa, Dadra and Nagar Haveli and Daman and Diu. Mumbai 5. Southern Andhra Pradesh, Telangana, Karnataka, Zonal Tamil Nadu, Kerala and Puducherry Council. Chennai. Table 15.3 Articles related to interstate relations at a glance. Article No. Subject matter: mutual recognition of public acts, etc. 261. Public acts, records and judicial proceedings. Disputes relating to waters. 262. Adjudication of disputes relating to waters of interstate rivers or river valleys. Coordination between states. 263. Provisions with respect to an interstate council. Interstate trade and commerce. 301. Freedom of trade, commerce and intercourse. 302. Power of Parliament to impose restrictions on trade, commerce and intercourse. 303. Restrictions on the legislative powers of the Union and of the states with regard to trade and commerce. 304. Restrictions on trade, commerce and intercourse among states. 305. Saving of existing laws and laws providing for state monopolies. 306. Power of certain states in Part B of the first schedule to impose restrictions on trade and commerce, repealed. 307. Appointment of authority for carrying out the purposes of Articles 301 to 304. Notes and references. 1. Report of the Joint Parliamentary Committee. Select Committee of the House of Lords appointed to join with the Committee of the House of Commons to consider the future government of India. 2. MP Jain, Indian Constitutional Law, Wadhwa, 4th edition, p. 382. 3. It was originally known as the Central Council of Local Self-Government, 1954. 4. India 2003, p. 242. 5. The Interstate Council Order dated 28 May 1990. 6. For example, the Parliament has made the Essential Commodities Act, 1955. This act enables the central government to control the production, supply and distribution of certain essential commodities like petroleum, coal, iron and steel and so on. 7. In USA such authority is known as the Interstate Commerce Commission. 8. It came into existence on 8 August 1972. 9. In 2002, Sikkim was added as the 8th member of the Northeastern Council. Emergency provisions. The emergency provisions are contained in Part 18 of the Constitution, from Articles 352 to 360. These provisions enable the central government to meet any abnormal situation effectively. The rationality behind the incorporation of these provisions in the Constitution is to safeguard the sovereignty, unity, integrity and security of the country, the democratic political system, and the Constitution. During an emergency, the central government becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation of the political system from federal during normal times to unitary during emergency is a unique feature of the Indian Constitution. In this context, Dr. B.R. Ambedkar observed in the Constituent Assembly that 1. All federal systems including American are placed in a tight mold of federalism. No matter what the circumstances, it cannot change its form and shape. It can never be unitary. On the other hand, the Constitution of India can be both unitary as well as federal according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system. But in times of emergency, it is so designed as to make it work as though it was a unitary system. The Constitution stipulates three types of emergencies. 1. An emergency due to war, external aggression or armed rebellion. 2. Article 352. This is popularly known as national emergency. However, the Constitution employs the expression proclamation of emergency to denote an emergency of this type. 2. An emergency due to the failure of the constitutional machinery in the states. Article 356. This is popularly known as President's Rule. It is also known by two other names, state emergency or constitutional emergency. However, the Constitution does not use the word emergency for this situation. 3. Financial emergency due to a threat to the financial stability or credit of India. Article 360. National emergency grounds of declaration under Article 352. The President can declare a national emergency when the security of India or a part of it is threatened by war or external aggression or armed rebellion. It may be noted that the President can declare a national emergency even before the actual occurrence of war or external aggression or armed rebellion, if he is satisfied that there is an imminent danger. The President can also issue different proclamations on grounds of war, external aggression, armed rebellion, or imminent danger thereof, whether or not there is a proclamation already issued by him and such proclamation is in operation. This provision was added by the 38th Amendment Act of 1975. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. On the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. A proclamation of national emergency may be applicable to the entire country or only a part of it. The 42nd Amendment Act of 1976 enabled the President to limit the operation of a national emergency to a specified part of India. Originally, the Constitution mentioned internal disturbance as the third ground for the proclamation of a national emergency, but the expression was too vague and had a wider connotation. Hence, the 44th Amendment Act of 1978 substituted the words armed rebellion for internal disturbance. Thus, it is no longer possible to declare a national emergency on the ground of internal disturbance, as was done in 1975 by the Congress government headed by Indira Gandhi. The President, however, can proclaim a national emergency only after receiving a written recommendation from the Cabinet. 3. This means that the emergency can be declared only on the concurrence of the Cabinet and not merely on the advice of the Prime Minister. In 1975, the then Prime Minister, Indira Gandhi, advised the President to proclaim emergency without consulting her Cabinet. The Cabinet was informed of the proclamation after it was made, as a fait accompli. The 44th Amendment Act of 1978 introduced this safeguard to eliminate any possibility of the Prime Minister alone taking a decision in this regard. The 38th Amendment Act of 1975 made the declaration of a national emergency immune from the judicial review. But this provision was subsequently deleted by the 44th Amendment Act of 1978. Further, in the Minerva Mills case 4, 1980, the Supreme Court held that the proclamation of a national emergency can be challenged in a court on the ground of malafide or that the declaration was based on wholly extraneous and irrelevant facts or is absurd or perverse. Parliamentary approval and duration. The proclamation of emergency must be approved by both the Houses of Parliament within 1 month from the date of its issue. Originally, the period allowed for approval by the Parliament was 2 months, but was reduced by the 44th Amendment Act of 1978. However, if the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. If approved by both the Houses of Parliament, the emergency continues for 6 months, and can be extended to an indefinite period with the approval of the Parliament for every 6 months. This provision for periodical parliamentary approval was also added by the 44th Amendment Act of 1978. Before that, the emergency, once approved by the Parliament, could remain in operation as long as the executive, cabinet, desired. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuance of emergency, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuation. Every resolution approving the proclamation of emergency or its continuance must be passed by either House of Parliament by a special majority, that is, a majority of the total membership of that House, and b. a majority of not less than 2/3 of the members of that House present and voting. This special majority provision was introduced by the 44th Amendment Act of 1978. Previously, such resolution could be passed by a simple majority of the Parliament. Revocation of proclamation. A proclamation of emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Further, the President must revoke a proclamation if the Lok Sabha passes a resolution disapproving its continuation. Again, this safeguard was introduced by the 44th Amendment Act of 1978. Before the amendment, a proclamation could be revoked by the President on his own and the Lok Sabha had no control in this regard. The 44th Amendment Act of 1978 also provided that, where 1/10 of the total number of members of the Lok Sabha give a written notice to the Speaker, or to the President if the House is not in session, a special sitting of the House should be held within 14 days for the purpose of considering a resolution disapproving the continuation of the proclamation. A resolution of disapproval is different from a resolution approving the continuation of a proclamation in the following two respects. 1. The first one is required to be passed by the Lok Sabha only, while the second one needs to be passed by the both houses of Parliament. 2. The first one is to be adopted by a simple majority only, while the second one needs to be adopted by a special majority. Effects of national emergency. A proclamation of emergency has drastic and wide-ranging effects on the political system. These consequences can be grouped into three categories: 1. Effect on the center-state relations, 2. Effect on the life of the Lok Sabha and State Assembly, and 3. Effect on the fundamental rights. Effect on the center-state relations. While a proclamation of emergency is in force, the normal fabric of the center-state relations undergoes a basic change. This can be studied under three heads, namely, executive, legislative and financial. A. Executive. During a national emergency, the executive power of the center extends to directing any state regarding the manner in which its executive power is to be exercised. In normal times, the center can give executive directions to a state only on certain specified matters. However, during a national emergency, the center becomes entitled to give executive directions to a state on any matter. Thus, the state governments are brought under the complete control of the center, though they are not suspended. B. Legislative. During a national emergency, the Parliament becomes empowered to make laws on any subject mentioned in the state list. Although the legislative power of a state legislature is not suspended, it becomes subject to the overriding power of the Parliament. Thus, the normal distribution of the legislative powers between the center and states is suspended, though the state legislatures are not suspended. In brief, the constitution becomes unitary rather than federal. The laws made by Parliament on the state subjects during a national emergency become inoperative 6 months after the emergency has ceased to operate. Notably, while a proclamation of national emergency is in operation, the President can issue ordinances on the state subjects also, if the Parliament is not in session. Further, the Parliament can confer powers and impose duties upon the centre or its officers and authorities in respect of matters outside the Union list, in order to carry out the laws made by it under its extended jurisdiction as a result of the proclamation of a national emergency. The 42nd Amendment Act of 1976 provided that the two consequences mentioned above, executive and legislative, extends not only to a state where the emergency is in operation but also to any other state. C. Financial. While a proclamation of national emergency is in operation, the President can modify the constitutional distribution of revenues between the center and the states. This means that the President can either reduce or cancel the transfer of finances from center to the states. Such modification continues till the end of the financial year in which the emergency ceases to operate. Also, every such order of the President has to be laid before both the Houses of Parliament. Effect on the life of the Lok Sabha and State Assembly. While a proclamation of national emergency is in operation, the life of the Lok Sabha may be extended beyond its normal term, 5 years, by a law of Parliament for 1 year at a time, for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. For example, the term of the 5th Lok Sabha, 1977, was extended 2 times by 1 year at a time 5. Similarly, the Parliament may extend the normal tenure of a state legislative assembly, 5 years, by 1 year each time, for any length of time, during a national emergency, subject to a maximum period of 6 months after the emergency has ceased to operate. Effect on the Fundamental Rights. Articles 358 and 359 describe the effect of a national emergency on the fundamental rights. Article 358 deals with the suspension of the fundamental rights guaranteed by Article 19, while Article 359 deals with the suspension of other fundamental rights, except those guaranteed by Articles 20 and 21. These two provisions are explained below. A. Suspension of fundamental rights under Article 19. According to Article 358, when a proclamation of national emergency is made, the 6 fundamental rights under Article 19 are automatically suspended. No separate order for their suspension is required. While a proclamation of national emergency is in operation, the state is freed from the restrictions imposed by Article 19. In other words, the state can make any law or can take any executive action abridging or taking away the 6 fundamental rights guaranteed by Article 19. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the 6 fundamental rights guaranteed by Article 19. When the national emergency ceases to operate, Article 19 automatically revives and comes into force. Any law made during emergency, to the extent of inconsistency with Article 19, ceases to have effect. However, no remedy lies for anything done during the emergency even after the emergency expires. This means that the legislative and executive actions taken during the emergency cannot be challenged even after the emergency ceases to operate. The 44th Amendment Act of 1978 restricted the scope of Article 358 in 2 ways. Firstly, the 6 fundamental rights under Article 19 can be suspended only when the national emergency is declared on the ground of war or external aggression and not on the ground of armed rebellion. Secondly, only those laws which are related with the emergency are protected from being challenged and not other laws. Also, the executive action taken only under such a law is protected. B. Suspension of other fundamental rights. Article 359 authorizes the President to suspend the right to move any court for the enforcement of fundamental rights during a national emergency. This means that under Article 359, the fundamental rights as such are not suspended, but only their enforcement. The said rights are theoretically alive but the right to seek remedy is suspended. The suspension of enforcement relates to only those fundamental rights that are specified in the presidential order. Further, the suspension could be for the period during the operation of emergency or for a shorter period as mentioned in the order, and the suspension order may extend to the whole or any part of the country. It should be laid before each House of Parliament for approval. While a presidential order is in force, the state can make any law or can take any executive action abridging or taking away the specified fundamental rights. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the specified fundamental rights. When the order ceases to operate, any law so made, to the extent of inconsistency with the specified fundamental rights, ceases to have effect. But no remedy lies for anything done during the operation of the order even after the order ceases to operate. This means that the legislative and executive actions taken during the operation of the order cannot be challenged even after the order expires. The 44th Amendment Act of 1978 restricted the scope of Article 359 in two ways. Firstly, the President cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed by Articles 20 to 21. In other words, the right to protection in respect of conviction for offences, Article 20, and the right to life and personal liberty, Article 21, remain enforceable even during emergency. Secondly, only those laws which are related with the emergency are protected from being challenged and not other laws, and the executive action taken only under such a law is protected. Distinction between Articles 358 and 359. The differences between Articles 358 and 359 can be summarized as follows. 1. Article 358 is confined to fundamental rights under Article 19 only, whereas Article 359 extends to all those fundamental rights whose enforcement is suspended by the presidential order. 2. Article 358 automatically suspends the fundamental rights under Article 19 as soon as the emergency is declared. On the other hand, Article 359 does not automatically suspend any fundamental right. It only empowers the President to suspend the enforcement of the specified fundamental rights. 3. Article 358 operates only in case of external emergency, that is, when the emergency is declared on the grounds of war or external aggression, and not in the case of internal emergency, i.e., when the emergency is declared on the grounds of armed rebellion. Article 359, on the other hand, operates in case of both external emergency as well as internal emergency. 4. Article 358 suspends fundamental rights under Article 19 for the entire duration of emergency, while Article 359 suspends the enforcement of fundamental rights for a period specified by the President, which may either be the entire duration of emergency or a shorter period. 5. Article 358 extends to the entire country, whereas Article 359 may extend to the entire country or a part of it. 6. Article 358 suspends Article 19 completely, while Article 359 does not empower the suspension of the enforcement of Articles 20 and 21. 7. Article 358 enables the state to make any law or take any executive action inconsistent with fundamental rights under Article 19, while Article 359 enables the state to make any law or take any executive action inconsistent with those fundamental rights whose enforcement is suspended by the presidential order. There is also a similarity between Article 358 and Article 359. Both provide immunity from challenge to only those laws which are related with the emergency and not other laws. Also, the executive action taken only under such a law is protected by both. Declarations made so far. This type of emergency has been proclaimed 3 times so far, in 1962, 1971 and 1975. The first proclamation of national emergency was issued in October 1962 on account of Chinese aggression in the NEFA, Northeast Frontier Agency, now Arunachal Pradesh, and was enforced till January 1968. Hence, a fresh proclamation was not needed at the time of war against Pakistan in 1965. The second proclamation of national emergency was made in December 1971 in the wake of attack by Pakistan. Even when this emergency was in operation, a third proclamation of national emergency was made in June 1975. Both the second and third proclamations were revoked in March 1977. The first 2 proclamations, 1962 and 1971, were made on the ground of external aggression, while the third proclamation, 1975, was made on the
Ground
ground
of
of internal disturbance, that is, certain persons have been inciting the police and the armed forces against the discharge of their duties and their normal functioning. The emergency declared in 1975, internal emergency, proved to be the most controversial. There was widespread criticism of the misuse of emergency powers. In the elections held to the Lok Sabha in 1977 after the emergency, the Congress party led by Indira Gandhi lost and the Janata Party came to power. This government appointed the Shah Commission to investigate the circumstances that warranted the declaration of an emergency in 1975. The commission did not justify the declaration of the emergency. Hence, the 44th Amendment Act was enacted in 1978 to introduce a number of safeguards against the misuse of emergency provisions. President's Rule Grounds of Imposition Article 355 imposes a duty on the centre to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. It is this duty in the performance of which the centre takes over the government of a state under Article 356 in case of failure of constitutional machinery in state. This is popularly known as President's Rule. It is also known as State Emergency or Constitutional Emergency. The President's Rule can be proclaimed under Article 356 on two grounds. One mentioned in Article 356 itself and another in Article 365. 1. Article 356 empowers the President to issue a proclamation, if he is satisfied that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. Notably, the President can act either on a report of the governor of the state or otherwise too, i.e., even without the governor's report. 2. Article 365 says that whenever a state fails to comply with or to give effect to any direction from the centre, it will be lawful for the President to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. Parliamentary approval and duration. A proclamation imposing President's Rule must be approved by both the Houses of Parliament within 2 months from the date of its issue. However, if the proclamation of President's Rule is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha approves it in the meantime. If approved by both the Houses of Parliament, the President's Rule continues for 6 months. 6. It can be extended for a maximum period of 3 years. 7. With the approval of the Parliament, every 6 months. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuation of the President's Rule, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuance. Every resolution approving the proclamation of President's Rule or its continuation can be passed by either House of Parliament only by a simple majority, that is, a majority of the members of that House present and voting. The 44th Amendment Act of 1978 introduced a new provision to put restraint on the power of Parliament to extend a proclamation of President's Rule beyond 1 year. Thus, it provided that, beyond 1 year, the President's Rule can be extended by 6 months at a time only when the following 2 conditions are fulfilled. 1. A proclamation of national emergency should be in operation in the whole of India, or in the whole or any part of the state. And 2. The Election Commission must certify that the general elections to the Legislative Assembly of the concerned state cannot be held on account of difficulties. A proclamation of President's Rule may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Consequences of President's Rule. The President acquires the following extraordinary powers when the President's Rule is imposed in a state. 1. He can take up the functions of the state government and powers vested in the governor or any other executive authority in the state. 2. He can declare that the powers of the state legislature are to be exercised by the parliament. 3. He can take all other necessary steps including the suspension of the constitutional provisions relating to any body or authority in the state. Therefore, when the president's rule is imposed in a state, the president dismisses the state council of ministers headed by the chief minister. The state governor, on behalf of the president, carries on the state administration with the help of the chief secretary of the state or the advisors appointed by the president. This is the reason why a proclamation under Article 356 is popularly known as the imposition of president's rule in a state. Further, the president either suspends or dissolves the state legislative assembly. 8. The parliament passes the state legislative bills and the state budget. When the state legislature is thus suspended or dissolved, 1. The parliament can delegate the power to make laws for the state to the president or to any other authority specified by him in this regard. 2. The parliament, or in case of delegation, the president or any other specified authority can make laws conferring powers and imposing duties on the center or its officers and authorities. 3. The president can authorize, when the Lok Sabha is not in session, expenditure from the state consolidated fund pending its sanction by the parliament. And 4. The president can promulgate, when the parliament is not in session, ordinances for the governance of the state. Table 16.1 Comparing National Emergency and President's Rule. National Emergency, Article 352, President's Rule, Article 356, 1. It can be proclaimed only when the security of India or a part of it is threatened by war, external aggression or armed rebellion. 1. It can be proclaimed when the government of a state cannot be carried on in accordance with the provisions of the constitution due to reasons which may not have any connection with war, external aggression or armed rebellion. 2. During its operation, the state executive and legislature continue to function and exercise the powers assigned to them under the constitution. Its effect is that the center gets concurrent powers of administration and legislation in the state. 2. During its operation, the state executive is dismissed and the state legislature is either suspended or dissolved. The president administers the state through the governor and the parliament makes laws for the state. In brief, the executive and legislative powers of the state are assumed by the center. 3. Under this, the parliament can make laws on the subjects enumerated in the state list only by itself, that is, it cannot delegate the same to any other body or authority. 3. Under this, the parliament can delegate the power to make laws for the state to the president or to any other authority specified by him. So far, the practice has been for the president to make laws for the state in consultation with the members of parliament from that state. Such laws are known as President's Acts. 4. There is no maximum period prescribed for its operation. It can be continued indefinitely with the approval of Parliament for every 6 months. 4. There is a maximum period prescribed for its operation, that is, 3 years. Thereafter, it must come to an end and the normal constitutional machinery must be restored in the state. 5. Under this, the relationship 5. Under this, the relationship of only the center with all the states state under emergency with the center undergoes a modification. 6. Every resolution of Parliament approving its proclamation or its continuance must be passed by a special majority. 6. Every resolution of Parliament approving its proclamation or its continuance can be passed only by a simple majority. 7. It affects fundamental rights of the citizens. 7. It has no effect on fundamental rights of the citizens. 8. Lok Sabha can pass a resolution for its revocation. 8. There is no such provision. It can be revoked by the president only on his own. A law made by the parliament or president or any other specified authority continues to be operative even after the president's rule. This means that the period for which such a law remains in force is not coterminous with the duration of the proclamation. But it can be repealed or altered or reenacted by the state legislature. It should be noted here that the president cannot assume to himself the powers vested in the concerned state high court or suspend the provisions of the constitution relating to it. In other words, the constitutional position, status, powers and functions of the concerned state high court remain same even during the president's rule. Use of Article 356 since 1950, the president's rule has been imposed on more than 100 occasions, that is, on an average twice a year. Further, on a number of occasions, the president's rule has been imposed in an arbitrary manner for political or personal reasons. Hence, Article 356 has become one of the most controversial and most criticized provision of the Constitution. For the first time, the president's rule was imposed in Punjab in 1951. By now, almost all the states have been brought under the president's rule, once or twice or more. The details in this regard are given in Table 16.2 at the end of this chapter. When general elections were held to the Lok Sabha in 1977 after the internal emergency, the ruling Congress party lost and the Janata Party came to power. The new government headed by Morarji Desai imposed presidents rule in 9 states, where the Congress party was in power, on the ground that the assemblies in those states no longer represented the wishes of the electorate. When the Congress party returned to power in 1980, it did the same in 9 states, 10 on the same ground. In 1992, president's rule was imposed in 3 BJP-ruled states, Madhya Pradesh, Himachal Pradesh and Rajasthan, by the Congress party on the ground that they were not implementing sincerely the ban imposed by the centre on religious organizations. In a landmark judgment in Bommai Case 11, 1994, the Supreme Court upheld the validity of this proclamation on the ground that secularism is a basic feature of the Constitution. But the court did not uphold the validity of the imposition of the president's rule in Nagaland in 1988, Karnataka in 1989 and Meghalaya in 1991. Dr. B.R. Ambedkar, while replying to the critics of this provision in the Constituent Assembly, hoped that the drastic power conferred by Article 356 would remain a dead letter, and would be used only as a measure of last resort. He observed 12. The intervention of the centre must be deemed to be barred, because that would be an invasion on the sovereign authority of the province, state. That is a fundamental proposition which we must accept by reason of the fact that we have a federal constitution. That being so, if the centre is to interfere in the administration of provincial affairs, it must be under some obligation which the constitution imposes upon the centre. The proper thing we ought to expect is that such articles will never be called into operation and that they would remain a dead letter. If at all they are brought into operation, I hope the President who is endowed with this power will take proper precautions before actually suspending the administration of the province. However, the subsequent events show that what was hoped to be a dead letter of the Constitution has turned to be a deadly weapon against a number of state governments and legislative assemblies. In this context, H.B. Kamath, a member of the Constituent Assembly, commented a decade ago, Dr. Ambedkar is dead and the articles are very much alive. Scope of judicial review. The 38th Amendment Act of 1975 made the satisfaction of the President in invoking Article 356 final and conclusive, which could not be challenged in any court on any ground. But this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of the President is not beyond judicial review. In Bommai Case, 1994, the following propositions have been laid down by the Supreme Court on imposition of President's rule in a state under Article 356. 1. The presidential proclamation imposing President's rule is subject to judicial review. 2. The satisfaction of the President must be based on relevant material. The action of the President can be struck down by the court if it is based on irrelevant or extraneous grounds, or if it was found to be mollified or perverse. 3. Burden lies on the centre to prove that relevant material exists to justify the imposition of the President's rule. 4. The court cannot go into the correctness of the material or its adequacy, but it can see whether it is relevant to the action. 5. If the court holds the presidential proclamation to be unconstitutional and invalid, It has power to restore the dismissed state government and revive the state legislative assembly if it was suspended or dissolved. 6. The state legislative assembly should be dissolved only after the parliament has approved the presidential proclamation. Until such approval is given, the president can only suspend the assembly. In case the parliament fails to approve the proclamation, the assembly would get reactivated. 7. Secularism is one of the basic features of the constitution. Hence, a state government pursuing anti-secular politics is liable to action under Article 356. 8. The question of the state government losing the confidence of the Legislative Assembly should be decided on the floor of the House, and until that is done the ministry should not be unseated. 9. Where a new political party assumes power at the centre, it will not have the authority to dismiss ministries formed by other parties in the states. 10. The power under Article 356 is an exceptional power and should be used only occasionally to meet the requirements of special situations. Cases of proper and improper use based on the report of the Sarkaria Commission on Center-State Relations, 1988, the Supreme Court in Bommai case, 1994, enlisted the situations where the exercise of power under Article 356 could be proper or improper. 13. Imposition of President's rule in a state would be proper in the following situations. 1. Where after general elections to the Assembly, no party secures a majority, that is, hung Assembly. 2. Where the party having a majority in the Assembly declines to form a ministry and the governor cannot find a coalition ministry commanding a majority in the Assembly. 3. Where a ministry resigns after its defeat in the Assembly and no other party is willing or able to form a ministry commanding a majority in the Assembly. 4. Where a constitutional direction of the central government is disregarded by the state government. 5. Internal subversion where, for example, a government is deliberately acting against the constitution and the law or is fomenting a violent revolt. 6. Physical breakdown where the government willfully refuses to discharge its constitutional obligations endangering the security of the state. The imposition of president's rule in a state would be improper under the following situations. 1. Where a ministry resigns or is dismissed on losing majority support in the Assembly and the governor recommends imposition of president's rule without probing the possibility of forming an alternative ministry. 2. Where the governor makes his own assessment of the support of a ministry in the Assembly and recommends imposition of president's rule without allowing the ministry to prove its majority on the floor of the Assembly. 3. Where the ruling party enjoying majority support in the Assembly has suffered a massive defeat in the general elections to the Lok Sabha such as in 1977 and 1980. 4. Internal disturbances not amounting to internal subversion or physical breakdown. 5. Maladministration in the state or allegations of corruption against the ministry or stringent financial exigencies of the state. 6. Where the state government is not given prior warning to rectify itself except in case of extreme urgency leading to disastrous consequences. 7. Where the power is used to sort out intra-party problems of the ruling party, or for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution. Financial emergency grounds of declaration. Article 360 empowers the President to proclaim a financial emergency if he is satisfied that a situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened. The 38th Amendment Act of 1975 made the satisfaction of the President in declaring a financial emergency final and conclusive and not questionable in any court on any ground. But this provision was subsequently deleted by the 44th Amendment Act of 1978, implying that the satisfaction of the President is not beyond judicial review. Parliamentary approval and duration. A proclamation declaring financial emergency must be approved by both the Houses of Parliament within 2 months from the date of its issue. However, if the proclamation of financial emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. Once approved by both the Houses of Parliament, the financial emergency
continues indefinitely till it is revoked.
This implies two things. One, there is no maximum period prescribed for its operation, and two, repeated parliamentary approval is not required for its continuation. A resolution approving the proclamation of financial emergency can be passed by either House of Parliament only by a simple majority, that is, a majority of the members of that House present and voting. A proclamation of financial emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Effects of financial emergency. The consequences of the proclamation of a financial emergency are as follows. 1. The executive authority of the centre extends a. to directing any state to observe such canons of financial propriety as are specified by it, and b. to directions as the President may deem necessary and adequate for the purpose. 2. Any such direction may include a provision requiring a. the reduction of salaries and allowances of all or any class of persons serving in the state, and b. the reservation of all money bills or other financial bills for the consideration of the President after they are passed by the legislature of the state. 3. The President may issue directions for the reduction of salaries and allowances of a. all or any class of persons serving the Union, and b. the judges of the Supreme Court and the High Court. Thus, during the operation of a financial emergency, the centre acquires full control over the states in financial matters. H. N. Kunzru, a member of the Constituent Assembly, stated that the financial emergency provisions pose a serious threat to the financial autonomy of the states. Explaining the reasons for their inclusion in the Constitution, Dr. B. R. Ambedkar observed in the Constituent Assembly 14. This article more or less follows the pattern of what is called the National Recovery Act of the United States passed in 1933, which gave the President power to make similar provisions in order to remove the
difficulties,
both economical and financial, that had overtaken the American people as a result of the Great Depression. No financial emergency has been declared so far, though there was a financial crisis in 1991. Criticism of the emergency provisions. Some members of the Constituent Assembly criticized the incorporation of emergency provisions in the Constitution on the following grounds. 15. 1. The federal character of the Constitution will be destroyed and the Union will become all-powerful. 2. The powers of the state, both the Union and the units, will entirely be concentrated in the hands of the Union executive. 3. The President will become a dictator. 4. The financial autonomy of the state will be nullified. 5. Fundamental rights will become meaningless and, as a result, the democratic foundations of the Constitution will be destroyed. Thus, H. B. Kamath observed, I fear that by this single chapter we are seeking to lay the foundation of a totalitarian state, a police state, a state completely opposed to all the ideals and principles that we have held aloft during the last few decades, a state where the rights and liberties of millions of innocent men and women will be in continuous jeopardy, a state where if there be peace, it will be the peace of the grave and the void of the desert, it will be a day of shame and sorrow when the President makes use of these powers having no parallel in any constitution of the democratic countries of the world. 16. K. T. Shah described them as Table 16.2 Imposition of President's Rule, 1951 to 2016, SL.No. States Union Territories No of times imposed years of imposition I states. Andhra Pradesh 3,195,420, 1973, 2014 2. Arunachal Pradesh 2 1979, 2016 3. Assam 4 1979, 1981, 1982, 1994. Bihar 8 1968, 1969, 1972, 1977, 1980, 1995, 1999, 2005 5. Chhattisgarh 6. Goa 5 1966, 1979, 1990, 1999, 2005 7. Gujarat 5 1971, 1974, 1976, 1980, 1996 8. Haryana 3 1967, 1977, 1991 9. Himachal Pradesh 2 1977, 1992 10. Jammu and Kashmir 7 1977, 1986, 1990, 2002, 2008, 2015, 2016 11. Jharkhand 3 2009, 2010, 2013 12. Karnataka 6 1971, 1977, 1989, 1990, 2007, 2007 13. Kerala 5 1,95,621, 1959, 1964, 1970, 1979 14. Madhya Pradesh 22 3 1977, 1980, 1992 15. Maharashtra 2 1980, 2014 16. Manipur 10 1967, 1967, 1969, 1973, 1977, 1979, 1981, 1992, 1993, 2001 17. Meghalaya 2 1991, 2009 18. Mizoram 3 1977, 1978, 1988. 19 Nagaland 4 1975, 1988, 1992, 2008 20. Odisha 6 1961, 1971, 1973, 1976, 1977, 1980 21. Punjab 23 8 1951, 1966, 1968, 1971, 1977, 1980, 1983, 1987 22. Rajasthan 4 1967, 1977, 1980, 1992 23. Sikkim 2 1978, 1984 24. Tamil Nadu 4 1976, 1980, 1988, 1991 25. Telangana 26. Tripura 3 1971, 1977, 1993 27. Uttarakhand 2 2016, 2016 28. Uttar Pradesh 9 1968, 1970, 1973, 1975, 1977, 1980, 1992, 1995, 2002 29. West Bengal 4 1962, 1968, 1970, 1971 2. Union Territories 1 Delhi 1 2014 2. Puducherry 6 1968, 1974, 1974, 1978, 1983, 1991 Table 16.3 Articles related to emergency provisions at a glance. Article No. Subject Matter 352. Proclamation of Emergency 353. Effect of Proclamation of Emergency 354. Application of provisions relating to distribution of revenues while a proclamation of emergency is in operation. 355 Duty of the Union to protect states against external aggression and internal disturbance. 356. Provisions in case of failure of constitutional machinery in states. 357. Exercise of legislative powers under proclamation issued under Article 356-358. Suspension of provisions of Article 19 during emergencies. 359. Suspension of the enforcement of the rights conferred by Part 3 during emergencies. 359A. Application of this part to the state of Punjab. Repealed. 360. Provisions as to financial emergency, a chapter of reaction and retrogression. I find one cannot but notice two distinct currents of thought underlying and influencing throughout the provisions of this chapter. A. To arm the center with special powers against the units, and B. To arm the government against the people. Looking at all the provisions of this chapter particularly and scrutinizing the powers that have been given in almost every article, it seems to me, the name only of liberty or democracy will remain under the Constitution. T.T. Krishnamachari feared that, by means of these provisions, the President and the Executive would be exercising a form of constitutional dictatorship. 17. H.N. Kundru opined that, the emergency financial provisions pose a serious threat to the financial autonomy of the states. However, there were also protagonists of the emergency provisions in the Constituent Assembly. Thus, Sir Alladi Krishnaswamy Iyer labelled them as the very life breath of the Constitution. Mahabir Tyagi opined that they would work as a safety valve, and thereby help in the maintenance of the Constitution. 18. While defending the emergency provisions in the Constituent Assembly, Dr. B.R. Ambedkar also accepted the possibility of their misuse. He observed, "I do not altogether deny that there is a possibility of the articles being abused or employed for political purposes." 19. Notes and references. 1. Constituent Assembly Debates, Volume 7, p. 34. 2. The phrase, armed rebellion, was inserted by the 44th Amendment Act of 1978, replacing the original phrase, internal disturbance. 3. Article 352 defines the term, cabinet, as the council consisting of the Prime Minister and other ministers of the cabinet's rank. 4. Minerva Mills v. Union of India, 1980. 5. The term of the 5th Lok Sabha, which was to expire on 18 March 1976, was extended by 1 year up to 18 March 1977 by the House of the People, Extension of Duration, Act, 1976. It was extended for a further period of 1 year up to 18 March 1978 by the House of the People, Extension of Duration, Amendment Act, 1976. However, the House was dissolved on 18 January 1977, after having been in existence for a period of 5 years, 10 months and 6 days. 6. The 42nd Amendment Act of 1976 had raised the period of 6 months to 1 year. Thus, once approved by both the Houses of Parliament, the proclamation of President's rule could continue for 1 year. But the 44th Amendment Act of 1978 again reduced the period to 6 months. 7. The President's rule imposed in May 1987 in Punjab was allowed to continue for 5 years under the 68th Amendment Act of 1991. 8. In case of dissolution, fresh elections are held for constituting a new legislative assembly in the state. 9. Those 9 states include Rajasthan, Uttar Pradesh, Madhya Pradesh, Punjab, Bihar, Himachal Pradesh, Orissa, West Bengal and Haryana. 10. Those 9 states include Uttar Pradesh, Bihar, Rajasthan, Madhya Pradesh, Punjab, Orissa, Gujarat, Maharashtra and Tamil Nadu. 11. S.R. Bommai v. Union of India, 1994. 12. Constituent Assembly Debates, Volume 9, p. 133 and 177. 13. Report of the Commission on Center-State Relations, Part I, p. 165-180, 1988. 14. Constituent Assembly Debates, Volume X, p. 361372. 15. Quoted from M. V. Piley, India's Constitution, S. Chand, 5th edition, 1994, p. 280. 16. Constituent Assembly Debates, Volume 9, p. 105. 17. Ibid, p. 123. 18. Ibid, p. 547. 19. Ibid, p. 177. 20. This was imposed in Andhra State. 21. This was imposed in Travancore Cochin. 22. Vindhya Pradesh had President's rule from 1949 to 1952. This state was merged into that of Madhya Pradesh state in 1956. 23 in 1953, the President's rule was imposed in Patiala and East Punjab States Union, PEPSU, which was merged into that of Punjab State in 1956. Part 3 Central Government 17. President 18. Vice President 19. Prime Minister 20. Central Council of Ministers 21. Cabinet Committees 22. Parliament 23. Parliamentary Committees 24. Parliamentary Forums 25. Parliamentary Group 26. Supreme Court 27. Judicial Review 28. Judicial Activism 29. Public Interest Litigation. President Articles 52 to 78 in Part B of the Constitution deal with the Union Executive. The Union Executive consists of the President, the Vice President, the Prime Minister, the Council of Ministers and the Attorney General of India. The President is the head of the Indian state. He is the first citizen of India and acts as the symbol of unity, integrity and solidarity of the nation. Election of the President. The President is elected not directly by the people but by members of Electoral College consisting of 1. The elected members of both the Houses of Parliament, 2. The elected members of the Legislative Assemblies of the States, and 3. The elected members of the Legislative Assemblies of the Union Territories of Delhi and Puducherry 1. Thus, the nominated members of both of Houses of Parliament, the nominated members of the State Legislative Assemblies, the members, both elected and nominated, of the State Legislative Councils, in case of the bicameral legislature, and the nominated members of the Legislative Assemblies of Delhi and Puducherry do not participate in the election of the President. Where an assembly is dissolved, the members cease to be qualified. To vote in presidential election, even if fresh elections to the dissolved assembly are not held before the presidential election. The Constitution provides that there shall be uniformity in the scale of representation of different states as well as parity between the states as a whole and the Union at the election of the President. To achieve this, the number of votes which each elected member of the Legislative Assembly of each state and the Parliament is entitled to cast at such election shall be determined in the following manner. 1. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1,000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the Assembly. 2. This can be expressed as 2. Every elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to members of the Legislative Assemblies of the states by the total number of the elected members of both the Houses of Parliament. This can be expressed as the President's election is held in accordance with the system of proportional representation by means of the single transferable vote and the voting is by secret ballot. This system ensures that the successful candidate is returned by the absolute majority of votes. A candidate, in order to be declared elected to the office of President, must secure a fixed quota of votes. The quota of votes is determined by dividing the total number of valid votes polled by the number of candidates to be elected. Here only one candidate is to be elected as President, plus 1 and adding 1 to the quotient. The formula can be expressed as, each member of the Electoral College is given only one ballot paper. The voter, while casting his vote, is required to indicate his preferences by marking 1, 2, 3, 4, etc. against the names of candidates. This means that the voter can indicate as many preferences as there are candidates in the fray. In the first phase, the first preference votes are counted. In case a candidate secures the required quota in this phase, he is declared elected. Otherwise, the process of transfer of votes is set in motion. The ballots of the candidate securing the least number of first preference votes are cancelled and his second preference votes are transferred to the first preference votes of other candidates. This process continues till a candidate secures the required quota. All doubts and disputes in connection with election of the President are inquired into and decided by the Supreme Court whose decision is final. The election of a person as president cannot be challenged on the ground that the electoral college was incomplete, i.e., existence of any vacancy among the members of electoral college. If the election of a person as president is declared void by the Supreme Court, acts done by him before the date of such declaration of the Supreme Court are not invalidated and continue to remain in force. Some members of the Constituent Assembly criticized the system of indirect election for the president as undemocratic and proposed the idea of direct election. However, the constitution makers chose the indirect election due to the following reasons. 3. 1. The indirect election of the president is in harmony with the parliamentary system of government envisaged in the constitution. Under this system, the president is only a nominal executive and the real powers are vested in the Council of Ministers headed by the Prime Minister. It would have been anomalous to have the president elected directly by the people and not give him any real power. 2. The direct election of the president would have been very costly and time and energy consuming due to the vast size of the electorate. This is unwarranted, keeping in view that he is only a symbolic head. Some members of the Constituent Assembly suggested that the president should be elected by the members of the two houses of parliament alone. The makers of the constitution did not prefer this, as the parliament, dominated by one political party, would have invariably chosen a candidate from that party, and such a president could not represent the states of the Indian Union. The present system makes the president a representative of the Union and the states equally. Further, it was pointed out in the Constituent Assembly that the expression, proportional representation, in the case of presidential election is a misnomer. Proportional representation takes place where two or more seats are to be filled. In case of the president, the vacancy is only one. It could better be called a preferential or alternative vote system. Similarly, the expression, single transferable vote, was also objected on the ground that no voter has a single vote, every voter has plural votes. Qualifications, oath and conditions. Qualifications for election as president. A person to be eligible for election as president should fulfill the following qualifications. 1. He should be a citizen of India. 2. He should have completed 35 years of age. 3. He should be qualified for election as a member of the Lok Sabha. 4. He should not hold any office of profit under the union government or any state government or any local authority or any other public authority. A sitting president or vice president of the union, the governor of any state and a minister of the union or any state is not deemed to hold any office of profit and hence qualified as a presidential candidate. Table 17.1 Elections of the Presidents, 1952 to 2012, SL No. Election year. Victorious candidate no of votes secured, %. Main rival candidate no of votes secured, %. 1952 Dr. Rajendra 507400 KT Shah 92827, 15.3, Prasad, 83.81, 2. 1957 Dr. Rajendra Prasad 459698, 99.35, NN thus 2000, 0.4, 3. 1962 DRS Radhakrishnan 553067, 98.24, Ch. Hari Ram 6341, 1.1, 4. 1967 Dr. Zakir Hussain 471244, 56.23, K. Subba Rao 363971, 43.4, 5. 1969 VV Giri 420077, 50.22, N. Sanjeeva Reddy 405427, 48.5, 6. 1974 Fakhruddin Ali Ahmed 756587, 80.18, Kridev Chaudhary 189186, 19.8, 7. 1977 N. Sanjeeva Reddy, unopposed, 8. 1982 Gianni Zail Singh 754113, 72.73, H.R. Khanna 282685, 27.6, 9. 1987 R. Venkatraman 740148, 72.29, V. Krishna Iyer 281550, 27.1, 10. 1992 Dr. Shankar Dayal Sharma 675564, 65.86, George Swell 346485, 33.21, 11. 1997 KR Narayanan 956290, 94.97, TN Sheshan 50431, 5.07, 12. 2002 Dr. APJ Abdul Kalam 922844, 89.58, Lakshmi Sehgal 107366, 10.42, 13. 2007 Ms. Pratibha Patil 638116, 65.82, B.S. Shekhawat 331306, 34.17, 14. 2012 Pranab Mukherjee 713763, 68.12, P.A. Sangama 315987, 30.15. Further, the nomination of a candidate for election to the office of President must be subscribed by at least 50 electors as proposers and 50 electors as seconders. Every candidate has to make a security deposit of 15,000 rupees in the Reserve Bank of India. The security deposit is liable to be forfeited in case the candidate fails to secure 1/6 of the votes polled. Before 1997, number of proposers and seconders was 10 each and the amount of security deposit was 2,500 rupees. In 1997, they were increased to discourage the non-serious candidates for oath or affirmation by the President before entering upon his office. The President has to make and subscribe to an oath or affirmation. In his oath, the President swears, 1. To faithfully execute the office, 2. To preserve, protect and defend the Constitution and the law, and 3. To devote himself to the service and well-being of the people of India. The oath of office to the President is administered by the Chief Justice of India and in his absence, the senior-most judge of the Supreme Court available. Any other person acting as President or discharging the functions of the President also undertakes the similar oath or affirmation. Conditions of President's office. The Constitution lays down the following conditions of the President's office. 1. He should not be a member of either House of Parliament or a House of the State Legislature. If any such person is elected as President, he is deemed to have vacated his seat in that House on the date on which he enters upon his office as President. 2. He should not hold any other office of profit. 3. He is entitled, without payment of rent, to the use of his official residence, the Rashtrapati Bhavan. 4. He is entitled to such emoluments, allowances and privileges as may be determined by Parliament. 5. His emoluments and allowances cannot be diminished during his term of office. In 2008, the Parliament increased the salary of the President from 50,000 rupees to as 1.50 lakh per month and the pension to 50% of his salary per month. In addition, the former Presidents are entitled to furnished residence, phone facilities, car, medical treatment, travel facility, secretarial staff and office expenses up to 60,000 rupees per annum. The spouse of a deceased President is also entitled to a family pension at the rate of 50% of pension of a retired President, furnished residence, phone facility, car, medical treatment, travel facility, secretarial staff and office expenses up to 12,000 rupees per annum. 5. The President is entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official acts. During his term of office, he is immune from any criminal proceedings, even in respect of his personal acts. He cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him during his term of office in respect of his personal acts. Term, impeachment and vacancy. Term of President's office. The President holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the Vice President. Further, he can also be removed from the office before completion of his term by the process of impeachment. The President can hold office beyond his term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of terms 6. However, in USA, a person cannot be elected to the office of the president more than twice. Impeachment of president. The president can be removed from office by a process of impeachment for violation of the Constitution. However, the Constitution does not define the meaning of the phrase violation of the Constitution. The impeachment charges can be initiated by either House of Parliament. These charges should be signed by 1/4 members of the House that framed the charges, and a 14 days notice should be given to the President. After the impeachment resolution is passed by a majority of 2/3 of the total membership of that House, it is sent to the other House, which should investigate the charges. The President has the right to appear and to be represented at such investigation. If the other House also sustains the charges and passes the impeachment resolution by a majority of 2/3 of the total membership, then the President stands removed from his office from the date on which the resolution is so passed. Thus, an impeachment is a quasi-judicial procedure in the Parliament. In this context, two things should be noted. A. The nominated members of either House of Parliament can participate in the impeachment of the President though they do not participate in his election. B. The elected members of the legislative assemblies of states and the Union territories of Delhi and Puducherry do not participate in the impeachment of the President though they participate in his election. No President has so far been impeached. Vacancy in the President's office. A vacancy in the President's office can occur in any of the following ways. 1. On the expiry of his tenure of 5 years. 2. By his resignation. 3. On his removal by the process of impeachment. 4. By his death. 7. 5. Otherwise, for example, when he becomes disqualified to hold office or when his election is declared void. When the vacancy is going to be caused by the expiration of the term of the sitting President, an election to fill the vacancy must be held before the expiration of the term. In case of any delay in conducting the election of new President by any reason, the outgoing President continues to hold office beyond his term of 5 years, until his successor assumes charge. This is provided by the Constitution in order to prevent an interregnum. In this situation, the Vice President does not get the opportunity to act as President or to discharge the functions of the President. If the office falls vacant by resignation, removal, death or otherwise, then election to fill the vacancy should be held within 6 months from the date of the occurrence of such a vacancy. The newly elected President remains in office for a full term of 5 years from the date he assumes charge of his office. When a vacancy occurs in the office of the President due to his resignation, removal, death or otherwise, the Vice President acts as the President until a new President is elected. Further, when the sitting President is unable to discharge his functions due to absence, illness or any other cause, the Vice President discharges his functions until the President resumes his office. In case the office of Vice President is vacant, the Chief Justice of India, or if his office is also vacant, the senior-most judge of the Supreme Court available, acts as the President or discharges the functions of the President. 8. When any person, i.e., Vice President, Chief Justice of India, or the senior-most judge of the Supreme Court is acting as the President or discharging the functions of the President, he enjoys all the powers and immunities of the President and is entitled to such emoluments, allowances and privileges as are determined by the Parliament. Powers and functions of the President. The powers enjoyed and the functions performed by the President can be studied under the following heads. 1. Executive powers. 2. Legislative powers. 3. Financial powers. 4. Judicial powers. 5. Diplomatic powers. 6. Military powers. 7. Emergency powers. Executive powers. The executive powers and functions of the President are: A. All executive actions of the Government of India are formally taken in his name. B. He can make rules specifying the manner in which the orders and other instruments made and executed in his name shall be authenticated. C. He can make rules for more convenient transaction of business of the Union Government, and for allocation of the said business among the ministers. D. He appoints the Prime Minister and the other ministers. They hold office during his pleasure. E. He appoints the Attorney General of India and determines his remuneration. The Attorney General holds office during the pleasure of the President. F. He appoints the Controller and Auditor General of India, the Chief Election Commissioner and other election commissioners, the Chairman and members of the Union Public Service Commission, the Governors of States, the Chairman and members of Finance Commission, and so on. G. He can seek any information relating to the administration of affairs of the Union, and proposals for legislation from the Prime Minister. H. He can require the Prime Minister to submit, for consideration of the Council of Ministers, any matter on which a decision has been taken by a minister but which has not been considered by the Council. I. He can appoint a commission to investigate into the conditions of SCs, STs and other backward classes. J. He can appoint an interstate council to promote center-state and interstate cooperation. K. He directly administers the union territories through administrators appointed by him. L. He can declare any area as scheduled area and has powers with respect to the administration of scheduled areas and tribal areas. Legislative powers. The President is an integral part of the Parliament of India, and enjoys the following legislative powers. A. He can summon or prorogue the Parliament and dissolve the Lok Sabha. He can also summon a joint sitting of both the Houses of Parliament, which is presided over by the Speaker of the Lok Sabha. B. He can address the Parliament at the commencement of the first session after each general election and the first session of each year. C. He can send messages to the Houses of Parliament, whether with respect to a bill pending in the Parliament or otherwise. D. He can appoint any member of the Lok Sabha to preside over its proceedings when the offices of both the Speaker and the Deputy Speaker fall vacant. Similarly, he can also appoint any member of the Rajya Sabha to preside over its proceedings when the offices of both the Chairman and the Deputy Chairman fall vacant. E. He nominates 12 members of the Rajya Sabha from amongst persons having special knowledge or practical experience in literature, science, art and social service. F. He can nominate 2 members to the Lok Sabha from the Anglo-Indian community. G. He decides on questions as to disqualifications of members of the Parliament, in consultation with the Election Commission. H. His prior recommendation or permission is needed to introduce certain types of bills in the Parliament. For example, a bill involving expenditure from the Consolidated Fund of India, or a bill for the alteration of boundaries of states or creation of a new state. I. When a bill is sent to the President after it has been passed by the Parliament, he can, I. Give his assent to the bill, or 2. Withhold his assent to the bill, or 3. Return the bill, if it is not a money bill, for reconsideration of the Parliament. However, if the bill is passed again by the Parliament, with or without amendments, the President has to give his assent to the bill. J. When a bill passed by a state legislature is reserved by the Governor for consideration of the President can, I. Give his assent to the bill, or 2. Withhold his assent to the bill, or 3. Direct the Governor to return the bill, if it is not a money bill, for reconsideration of the state legislature. It should be noted here that it is not obligatory for the President to give his assent even if the bill is again passed by the state legislature and sent again to him for his consideration. K. He can promulgate ordinances when the Parliament is not in session. These ordinances must be approved by the Parliament within 6 weeks from its reassembly. He can also withdraw an ordinance at any time. L. He lays the reports of the Controller and Auditor General, Union Public Service Commission, Finance Commission, and others, before the Parliament. M. He can make regulations for the peace, progress and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli and Daman and Diu. In the case of Puducherry also, the President can legislate by making regulations but only when the Assembly is suspended or dissolved. Financial powers. The financial powers and functions of the President are: A. Money bills can be introduced in the Parliament only with his prior recommendation. B. He causes to be laid before the Parliament the annual financial statement, i.e., the Union budget. C. No demand for a grant can be made except on his recommendation. D. He can make advances out of the contingency fund of India to meet any unforeseen expenditure. E. He constitutes the Finance Commission after every 5 years to recommend the distribution of revenues between the centre and the states. Judicial powers. The judicial powers and functions of the President are: A. He appoints the Chief Justice and the judges of Supreme Court and High Courts. B. He can seek advice from the Supreme Court on any question of law or fact. However, the advice tendered by the Supreme Court is not binding on the President. C. He can grant pardon, reprieve, respite and remission of punishment, or suspend, remit or commute the sentence of any person convicted of any offence, I. In all cases where the punishment or sentence is by a court-martial. 2. In all cases where the punishment or sentence is for an offence against a union law, and 3. In all cases where the sentence is a sentence of death. Diplomatic powers. The international treaties and agreements are negotiated and concluded on behalf of the President. However, they are subject to the approval of the Parliament. He represents India in international forums and affairs and sends and receives diplomats like ambassadors, high commissioners, and so on. Military powers. He is the Supreme Commander of the Defence Forces of India. In that capacity, he appoints the chiefs of the Army, the Navy and the Air Force. He can declare war or conclude peace, subject to the approval of the Parliament. Emergency powers. In addition to the normal powers mentioned above, the Constitution confers extraordinary powers on the President to deal with the following 3 types of emergencies. 9. A. National emergency, Article 352. B. President's rule, Article 356 and 365. And C. Financial emergency, Article 360. Veto power of the President. A bill passed by the Parliament can become an act only if it receives the assent of the President. When such a bill is presented to the President for his assent, he has 3 alternatives. Under Article 111 of the Constitution: 1. He may give his assent to the bill, or 2. He may withhold his assent to the bill, or 3. He may return the bill, if it is not a money bill, for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President must give his assent to the bill. Thus, the President has the veto power over the bills passed by the Parliament. 10. That is, he can withhold his assent to the bills. The object of conferring this power on the President is twofold: A. To prevent hasty and ill-considered legislation by the Parliament, and B. To prevent a legislation which may be unconstitutional. The veto power enjoyed by the executive in modern states can be classified into the following 4 types. 1. Absolute veto, that is, withholding of assent to the bill passed by the legislature. 2. Qualified veto, which can be overridden by the legislature with a higher majority. 3. Suspensive veto, which can be overridden by the legislature with an ordinary majority. 4. Pocket veto, that is, taking no action on the bill passed by the legislature. Of the above 4, the President of India is vested with 3: absolute veto, suspensive veto and pocket veto. There is no qualified veto in the case of Indian President. It is possessed by the American President. The 3 vetoes of the President of India are explained below. Absolute veto. It refers to the power of the President to withhold his assent to a bill passed by the Parliament. The bill then ends and does not become an act. Usually, this veto is exercised in the following 2 cases: A. With respect to private members' bills, i.e., bills introduced by any member of Parliament who is not a minister, and B. With respect to the government bills when the cabinet resigns, after the passage of the bills but before the assent by the President, and the new Cabinet advises the President not to give his assent to such bills. In 1954, President Dr. Rajendra Prasad withheld his assent to the PEPSU Appropriation Bill. The bill was passed by the Parliament when the President's rule was in operation in the state of PEPSU. But, when the bill was presented to the President for his assent, the President's rule was revoked. Again in 1991, President R. Venkatraman withheld his assent to the Salary, Allowances and Pension of Members of Parliament Amendment Bill. The bill was passed by the Parliament on the last day before dissolution of Lok Sabha, without obtaining the previous recommendation of the President. Suspensive veto. The President exercises this veto when he returns a bill for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President, it is obligatory for the President to give his assent to the bill. This means that the presidential veto is overridden by a repassage of the bill by the same ordinary majority, and not a higher majority as required in USA. As mentioned earlier, the President does not possess this veto in the case of money bills. The President can either give his assent to a money bill or withhold his assent to a money bill but cannot return it for the reconsideration of the Parliament. Normally, the President gives his assent to money bill as it is introduced in the Parliament with his previous permission. Pocket veto. In this case, the President neither ratifies nor rejects nor returns the bill, but simply keeps the bill pending for an indefinite period. This power of the President not to take any action, either positive or negative, on the bill is known as the pocket veto. The President can exercise this veto power as the Constitution does not prescribe any time limit within which he has to take the decision with respect to a bill presented to him for his assent. In USA, on the other hand, the President has to return the bill for reconsideration within 10 days. Hence, it is remarked that the pocket of the Indian President is bigger than that of the American President. In 1986, President Zail Singh exercised the pocket veto with respect to the Indian Post Office Amendment Bill. The bill, passed by the Rajiv Gandhi government, imposed restrictions on the freedom of press and hence, was widely criticized. After 3 years, in 1989, the next President R. Venkatraman sent the bill back for reconsideration, but the new National Front government decided to drop the bill. It should be noted here that the President has no veto power in respect of a constitutional amendment bill. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to a constitutional amendment bill. Presidential veto over state legislation. The President has veto power with respect to state legislation also. A bill passed by a state legislature can become an act only if it receives the assent of the governor or the President, in case the bill is reserved for the consideration of the President. When a bill, passed by a state legislature, is presented to the governor for his assent, he has 4 alternatives, under Article 200 of the Constitution. 1. He may give his assent to the bill, or 2. He may withhold his assent to the bill, or 3. He may return the bill, if it is not a money bill, for reconsideration of the state legislature, or 4. He may reserve the bill for the consideration of the President. When a bill is reserved by the governor for the consideration of the President has 3 alternatives, under Article 201 of the Constitution. 1. He may give his assent to the bill, or 2. He may withhold his assent to the bill, or 3. He may direct the governor to return the bill, if it is not a money bill, for the reconsideration of the state legislature. If the bill is passed again by the state legislature with or without amendments and presented again to the President for his assent, the President is not bound to give his assent
to the bill.
This means that the state legislature cannot override the veto power of the President. Further, the Constitution has not prescribed any time limit within which the President has to take decision with regard to a bill reserved by the governor for his consideration. Hence, the President can exercise pocket veto in respect of state legislation also. Table 17.2 Veto power of the President at a glance. Central legislation. State legislation with regard to ordinary bills. 1. Can be ratified. 1. Can be ratified. 2. Can be rejected 2. Can be rejected 3. Can be returned 3. Can be returned with regard to money bills 1. Can be ratified 1. Can be ratified 2. Can be rejected, but cannot be returned 2. Can be rejected, but cannot be returned. With regard to constitutional amendment bills can only be ratified, that is, constitutional amendment bills cannot be rejected or returned, introduced in the state legislature. Table 17.2 summarizes the discussion on the veto power of the President with regard to central as well as state legislation. Ordinance-making power of the President. Article 123 of the Constitution empowers the President to promulgate ordinances during the recess of Parliament. These ordinances have the same force and effect as an Act of Parliament, but are in the nature of temporary. Laws. The ordinance-making power is the most important legislative power of the President. It has been vested in him to deal with unforeseen or urgent matters. But the exercises of this power is subject to the following 4 limitations. 1. He can promulgate an ordinance only when both the Houses of Parliament are not in session or when either of the 2 Houses of Parliament is not in session. An ordinance can also be issued when only one House is in session because a law can be passed by both the Houses and not by one House alone. An ordinance made when both the Houses are in session is void. Thus, the power of the President to legislate by ordinance is not a parallel power of legislation. 2. He can make an ordinance only when he is satisfied that the circumstances exist that render it necessary for him to take immediate action. In Cooper Case 11, 1970, the Supreme Court held that the President's satisfaction can be questioned in a court on the ground of nullified. This means that the decision of the President to issue an ordinance can be questioned in a court on the ground that the President has prorogued one House or both Houses of Parliament deliberately with a view to promulgate an ordinance on a controversial subject, so as to bypass the parliamentary decision and thereby circumventing the authority of the Parliament. The 38th Constitutional Amendment Act of 1975 made the President's satisfaction final and conclusive and beyond judicial review. But this provision was deleted by the 44th Constitutional Amendment Act of 1978. Thus, the President's satisfaction is justiciable on the ground of nullified. 3. His ordinance-making power is coextensive as regards all matters except duration, with the lawmaking powers of the Parliament. This has 2 implications. A. An ordinance can be issued only on those subjects on which the Parliament can make laws. B. An ordinance is subject to the same constitutional limitation as an Act of Parliament. Hence, an ordinance cannot abridge or take away any of the fundamental rights. 12. For every ordinance issued by the President during the recess of Parliament must be laid before both the Houses of Parliament when it reassembles. If the ordinance is approved by both the Houses, it becomes an act. If Parliament takes no action at all, the ordinance ceases to operate on the expiry of 6 weeks from the reassembly of Parliament. The ordinance may also cease to operate even earlier than the prescribed 6 weeks, if both the Houses of Parliament pass resolutions disapproving it. If the Houses of Parliament are summoned to reassemble on different dates, the period of 6 weeks is calculated from the later of those dates. This means that the maximum life of an ordinance can be 6 months and 6 weeks, in case of non-approval by the Parliament, 6 months being the maximum gap between the 2 sessions of Parliament. If an ordinance is allowed to lapse without being placed before Parliament, then the acts done and completed under it, before it ceases to operate, remain fully valid and effective. The President can also withdraw an ordinance at any time. However, his power of ordinance making is not a discretionary power, and he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Prime Minister. An ordinance, like any other legislation, can be retrospective, that is, it may come into force from a back date. It may modify or repeal any Act of Parliament or another ordinance. It can alter or amend a tax law also. However, it cannot be issued to amend the Constitution. The ordinance-making power of the President in India is rather unusual and not found in most of the democratic constitutions of the world, including that of USA and UK. In justification of the ordinance-making power of the President, Dr. B.R. Ambedkar said in the Constituent Assembly that the mechanism of issuing an ordinance has been devised in order to enable the executive to deal with a situation that may suddenly and immediately arise when the Parliament is not in session. 13. It must be clarified here that the ordinance-making power of the President has no necessary connection with the national emergency envisaged in Article 352. The President can issue an ordinance even when there is no war or external aggression or armed rebellion. The rules of Lok Sabha require that whenever a bill seeking to replace an ordinance is introduced in the House, a statement explaining the circumstances that had necessitated immediate legislation by ordinance should also be placed before the House. So far, no case has gone to the Supreme Court regarding repromulgation of ordinance by the President. But the judgment of the Supreme Court in the D.C. Wadhwa case 14, 1987, is highly relevant here. In that case, the court pointed out that between 1967-1981 the governor of Bihar promulgated 256 ordinances, and all these were kept in force for periods ranging from 1 to 14 years by repromulgation from time to time. The court ruled that successive repromulgation of ordinances with the same text without any attempt to get the bills passed by the Assembly would amount to violation of the Constitution, and the ordinance so repromulgated is liable to be struck down. It held that the exceptional power of lawmaking through ordinance cannot be used as a substitute for the legislative power of the state legislature. Pardoning power of the President. Article 72 of the Constitution empowers the President to grant pardons to persons who have been tried and convicted of any offense in all cases where the 1. Punishment or sentence is for an offense against a union law, 2. Punishment or sentence is by a court-martial, military court, and 3. Sentence is a sentence of death. The pardoning power of the President is independent of the judiciary. It is an executive power. But the President, while exercising this power, does not sit as a court of appeal. The object of conferring this power on the President is twofold: a. To keep the door open for correcting any judicial errors in the operation of law, and b. To afford relief from a sentence which the President regards as unduly harsh. The pardoning power of the President includes the following: 1. Pardon. It removes both the sentence and the conviction and completely absolves the convict from all sentences, punishments and disqualifications. 2. Commutation. It denotes the substitution of one form of punishment for a lighter form. For example, a death sentence may be commuted to rigorous imprisonment, which in turn may be commuted to a simple imprisonment. 3. Remission. It implies reducing the period of sentence without changing its character. For example, a sentence of rigorous imprisonment for 2 years may be remitted to rigorous imprisonment for 1 year. 4. Respite. It denotes awarding a lesser sentence in place of one originally awarded due to some special fact, such as the physical disability of a convict or the pregnancy of a woman offender. 5. Reprieve. It implies a stay of the execution of a sentence, especially that of death, for a temporary period. Its purpose is to enable the convict to have time to seek pardon or commutation from the President. Under Article 161 of the Constitution, the governor of a state also possesses the pardoning power. Hence, the governor can also grant pardons, reprieves, respites and remissions of punishment or suspend, remit and commute the sentence of any person convicted of any offense against a state law. But the pardoning power of the governor differs from that of the President in following 2 respects. 1. The President can pardon sentences inflicted by court-martial, military courts, while the governor cannot. 2. The President can pardon death sentence while governor cannot. Even if a state law prescribes death sentence, the power to grant pardon lies with the President and not the governor. However, the governor can suspend, remit or commute a death sentence. In other words, both the governor and the President have concurrent power in respect of suspension, remission and commutation of death sentence. The Supreme Court examined the pardoning power of the President under different cases and laid down the following principles. 1. The petitioner for mercy has no right to an oral hearing by the President. 2. The President can examine the evidence afresh and take a view different from the view taken by the court. 3. The power is to be exercised by the President on the advice of the Union Cabinet. 4. The President is not bound to give reasons for his order. 5. The President can afford relief not only from a sentence that he regards as unduly harsh but also from an evident mistake. 6. There is no need for the Supreme Court to lay down specific guidelines for the exercise of power by the President. 7. The exercise of power by the President is not subject to judicial review except where the presidential decision is arbitrary, irrational, mala fide discriminatory. 8. Where the earlier petition for mercy has been rejected by the President, stay cannot be obtained by filing another petition. Constitutional position of the President. The Constitution of India has provided for a parliamentary form of government. Consequently, the President has been made only a nominal executive, the real executive being the Council of Ministers headed by the Prime Minister. In other words, the President has to exercise his powers and functions with the aid and advice of the Council of Ministers headed by the Prime Minister. Dr. B.R. Ambedkar summed up the true position of the President in the following way. 15. In the Indian Constitution, there is placed at the head of the Indian Union a functionary who is called the President of the Union. The title of the functionary reminds of the President of the United States. But beyond the identity of names, there is nothing in common between the form of government prevalent in America and the form of government adopted under the Indian Constitution. The American form of government is called the presidential system of government, and what the Indian Constitution adopted is the parliamentary system. Under the presidential system of America, the President is the chief head of the executive and administration is vested in him. Under the Indian Constitution, the President occupies the same position as the King under the English Constitution. He is the head of the state but not of the executive. He represents the nation but does not rule the nation. He is the symbol of the nation. His place in administration is that of a ceremonial device or a seal by which the nation's decisions are made known. He is generally bound by the advice of his ministers. He can do nothing contrary to their advice, nor can he do anything without their advice. The President of the United States can dismiss any secretary at any time. The President of the Indian Union has no power to do so, so long as his ministers command a majority in Parliament. In estimating the constitutional position of the President, particular reference has to be made to the provisions of Articles 53, 74 and 75. These are: 1. The executive power of the Union shall be vested in President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution, Article 53. 2. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice, Article 74. 3. The Council of Ministers shall be collectively responsible to the Lok Sabha, Article 75. This provision is the foundation of the parliamentary system of government. The 42nd Constitutional Amendment Act of 1976, enacted by the Indira Gandhi government, made the President bound by the advice of the Council of Ministers headed by the Prime Minister. 16. The 44th Constitutional Amendment Act of 1978, enacted by the Janata Party government headed by Morarji Desai, authorized the President to require the Council of Ministers to reconsider such advice either generally or otherwise. However, he shall act in accordance with the advice tendered after such reconsideration. In other words, the President may return a matter once for reconsideration of his ministers, but the reconsidered advice shall be binding. In October 1997, the Cabinet recommended President K.R. Narayanan to impose President's rule, under Article 356, in Uttar Pradesh. The President returned the matter for the reconsideration of the Cabinet, which then decided not to move ahead in the matter. Hence, the BJP-led government under Kalyan Singh was saved. Again in September 1998, the President K.R. Narayanan returned the recommendation of the cabinet that sought the imposition of the President's rule in Bihar. After a couple of months, the cabinet re-advised the same. It was only then that the President's rule was imposed in Bihar, in February 1999. Though the President has no constitutional discretion, he has some situational discretion. In other words, the President can act on his discretion, that is, without the advice of the ministers, under the following situations: I. Appointment of Prime Minister when no party has a clear majority in the Lok Sabha or when the Prime Minister in office dies suddenly and there is no obvious successor. 2. Dismissal of the Council of Ministers when it cannot prove the confidence of the Lok Sabha. 3. Dissolution of the Lok Sabha if the Council of Ministers has lost its majority. Table 17.3 Articles related to President at a glance. Article No. Subject Matter 52. The President of India 53. Executive Power of the Union 54. Election of President 55. Manner of Election of President 56. Term of Office of President 57. Eligibility for re-election 58. Qualifications for election as President 59. Conditions of President's Office 60. Oath or affirmation by the President 61. Procedure for impeachment of the President 62. Time of holding election to fill vacancy in the office of President 65. Vice President to act as President or to discharge his functions 71. Matters relating to the election of President 72. Power of President to grant pardons etc., and to suspend, remit or commute sentences in certain cases. 74 Council of Ministers to aid and advise the President 75. Other provisions as to ministers like appointment, term, salaries, etc. 76. Attorney General of India 77. Conduct of business of the Government of India 78. Duties of Prime Minister in respect to furnishing of information to the President, etc. 85. Sessions of Parliament, prorogation and dissolution 111. Assent to bills passed by the Parliament 112. Union Budget, Annual Financial Statement, 123. Power of President to promulgate ordinances 143. Power of President to consult Supreme Court notes and references 1. This provision was added by the 70th Constitutional Amendment Act of 1992 with effect from 1 June 1995. 2. According to the 84th Constitutional Amendment Act of 2001, the expression, population, means the population as ascertained at the 1971 census, until the relevant figures for the first census taken after 2026 have been published. 3. Constituent Assembly Debates, Volume 4 P73736. 4. The Presidential and Vice Presidential Elections Act of 1952, as amended in 1997. 5. The President's Emoluments and Pension Amendment Act of 2008. 6. No person except Dr. Rajendra Prasad has occupied the office for 2 terms. 7. So far 2 presidents, Dr. Zakir Hussain and Fakhruddin Ali Ahmed, have died during their term of office. 8. For example, when President Dr. Zakir Hussain died in May 1969, the then Vice President, V.V. Giri was acting as the President. Soon after V.V. Giri resigned to contest the election of the President. Then the Chief Justice of India, M. Hidayatullah, worked as the officiating President from 20th July 1969 to 24th August 1969. 9. For details in this regard, see Chapter 16. 10. Veto is a Latin word that connotes forbid. 11. Cooper v. Union of India, 1970. 12. The definition of law, contained in Article 13 expressly includes ordinances. See Chapter 7. 13. Constituent Assembly Debates, Volume 8, p. 213. 14. D.C. Wadhwa v. State of Bihar, 1987. 15. Constituent Assembly Debates, Volume 7, p. 32-34. 16. In the original constitution, there was no such specific provision in Article 74. Vice President. Vice President occupies the second highest office in the country. He is accorded a rank next to the President in the official warrant of precedence. This office is modeled on the lines of the American Vice President. Election. The Vice President, like the President, is elected not directly by the people but by the method of indirect election. He is elected by the members of an electoral college consisting of the members of both houses of Parliament. 1. Thus, this electoral college is different from the electoral college for the election of the President in the following two respects. 1. It consists of both elected and nominated members of the Parliament, in the case of President, only elected members. 2. It does not include the members of the state legislative assemblies. In the case of President, the elected members of the state legislative assemblies are included. Explaining the reason for this difference, Dr. B.R. Ambedkar observed, 2. The President is the head of the state and his power extends both to the administration by the center as well as to the states. Consequently, it is necessary that in his election, not only members of Parliament should play their part, but the members of the state legislatures should have a voice. But, when we come to the Vice President, his normal functions are to preside over the Council of States. It is only on a rare occasion, and that too for a temporary period, that he may be called upon to assume the duties of the President. That being so, it does not seem necessary that the members of the state legislatures should also be invited to take part in the election of the Vice President. But, the manner of election is same in both the cases. Thus, the Vice President's election, like that of the President's election, is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. 3 Qualifications to be eligible for election as Vice President. A person should fulfill the following qualifications. 1. He should be a citizen of India. 2. He should have completed 35 years of age. 3. He should be qualified for election as a member of the Rajya Sabha. 4. He should not hold any office of profit under the union government or any state government or any local authority or any other public authority. Table 18.1 Elections of the Vice Presidents. 19522012. SL No. Election year. Victorious candidate no of votes secured. Runner-up candidate no of votes secured. 1. 1952 Drs. Radhakrishnan, unopposed. 2. 1957 Drs. Radhakrishnan, unopposed. 3. 1962 Dr. Zakir Hussain 568 N. Samant Singh 14-4. 1967 VV Giri 486 Professor Habib 192. 5. 1969 GS Pathak 400 HB 156 Kamath 6. 1974 BD Jatti 521 Eni Horon 141 7. 1979 M Hidayatullah, unopposed, 8. 1984 R Venkatraman 508 BC Kamble 207 9. 1987 Dr. Shankar Dayal Sharma, unopposed, 10. 1992 KR Narayanan 700 Kaka Joginder Singh 0111. 1997 Krishna Kant 441 Sojik Singh Bernala 273 12. 2002 VS Shekhawat 454 Sushil Kumar Shinde 305 13. 2007 Mohd Hamid Ansari 455 Najma Heptullah 222 14. 2012 Mohd Hamid Ansari 490 Jaswant Singh 238. But, a sitting President or Vice President of the Union, the Governor of any state and a Minister for the Union or any state is not deemed to hold any office of profit and hence qualified for being a candidate for Vice President. Further, the nomination of a candidate for election to the office of Vice President must be subscribed by at least 20 electors as proposers and 20 electors as seconders. Every candidate has to make a security deposit of 15,000 in the Reserve Bank of India. 4. Oath or affirmation before entering upon his office. The Vice President has to make and subscribe to an oath or affirmation. In his oath, the Vice President swears, 1. To bear true faith and allegiance to the Constitution of India, and 2. To faithfully discharge the duties of his office. The oath of office to the Vice President is administered by the President or some person appointed in that behalf by him. Conditions of office. The Constitution lays down the following 2 conditions of the Vice President's office. 1. He should not be a member of either House of Parliament or a House of the State Legislature. If any such person is elected Vice President, he is deemed to have vacated his seat in that House on the date on which he enters upon his office as Vice President. 2. He should not hold any other office of profit. Term of office. The Vice President holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the President. He can also be removed from the office before completion of his term. A formal impeachment is not required for his removal. He can be removed by a resolution of the Rajya Sabha passed by an absolute majority, i.e., a majority of the total members of the House, and agreed to by the Lok Sabha. But no such resolution can be moved unless at least 14 days advance notice has been given. Notably, no ground has been mentioned in the Constitution for his removal. The Vice President can hold office beyond his term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of terms. 5. Vacancy in office. A vacancy in the Vice President's office can occur in any of the following ways. 1. On the expiry of his tenure of 5 years. 2. By his resignation. 3. On his removal. 4. By his death. 6. 5. Otherwise, for example, when he becomes disqualified to hold office or when his election is declared void. When the vacancy is going to be caused by the expiration of the term of the sitting Vice President, an election to fill the vacancy must be held before the expiration of the term. If the office falls vacant by resignation, removal, death or otherwise, then election to fill the vacancy should be held as soon as possible after the occurrence of the vacancy. The newly elected Vice President remains in office for a full term of 5 years from the date he assumes charge of his office. Election disputes. All doubts and disputes in connection with election of the Vice President are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as Vice President cannot be challenged on the ground that the Electoral College was incomplete, i.e., existence of any vacancy among the members of Electoral College. If the election of a person as Vice President is declared void by the Supreme Court, acts done by him before the date of such declaration of the Supreme Court are not invalidated, i.e., they continue to remain in force. Powers and functions. The functions of Vice President are twofold. 1. He acts as the ex-officio chairman of Rajya Sabha. In this capacity, his powers and functions are similar to those of the Speaker of Lok Sabha. In this respect, he resembles the American Vice President, who also acts as the Chairman of the Senate, the upper house of the American legislature. 2. He acts as President when a vacancy occurs in the office of the President due to his resignation, removal, death or otherwise. 7. He can act as President only for a maximum period of 6 months within which a new President has to be elected. Further, when the sitting President is unable to discharge his functions due to absence, illness or any other cause, the Vice President discharges his functions until the President resumes his office. 8. While acting as President or discharging the functions of President, the Vice President does not perform the duties of the office of the Chairman of Rajya Sabha. During this period, those duties are performed by the Deputy Chairman of Rajya Sabha. Indian and American Vice Presidents compared. Though the office of the Indian Vice President is modeled on the lines of the American Vice President, there is a difference. The American Vice President succeeds to the presidency when it falls vacant, and remains President for the unexpired term of his predecessor. The Indian Vice President, on the other hand, does not assume the office of the President when it falls vacant for the unexpired term. He merely serves as an acting President until the new President assumes charge. From the above, it is clear that the Constitution has not assigned any significant function to the Vice President in that capacity. Hence, some scholars call him His Superfluous Highness. This office was created with the view to maintain the political continuity of the Indian state. Emoluments: the Constitution has not fixed any emoluments for the Vice President in that capacity. He draws his regular salary in his capacity as the ex-officio chairman of the Rajya Sabha. In 2008, the Parliament increased the salary of the chairman of the Rajya Sabha from 40,000 to 1.25 lakh per month. 9. In addition, he is entitled to daily allowance, free furnished residence, medical, travel and other facilities. During any period when the Vice President acts as President or discharges the functions of the President, he is not entitled to the salary or allowance payable to the Chairman of Rajya Sabha, but the salary and allowance of the President. Table 18.2 Articles related to Vice President at a glance. Article No. Subject Matter 63. The Vice President of India. 64. The Vice President to be ex officio Chairman of the Council of States. 65. The Vice President to act as President or to discharge his functions during casual vacancies in the office, or during the absence of President. 66. Election of Vice President. 67. Term of office of Vice President. 68. Time of holding election to fill vacancy in the office of Vice President and the term of office of person elected to fill casual vacancy. 69. Oath or affirmation by the Vice President. 70. Discharge of President's functions in other contingencies. 71. Matters relating to, or connected with, the election of Vice President. Notes and references. 1. The original Constitution provided that the Vice President would be elected by the two Houses of Parliament assembled at a joint meeting. This cumbersome procedure was done away by the 11th Constitutional Amendment Act of 1961. 2 Constituent Assembly Debates, Volume 7, p. 1001. 3. This method is discussed in Chapter 17. 4. Presidential and Vice Presidential Elections Act, 1952 as amended in 1997. 5. Drs. Radhakrishnan was elected for a second term. 6. Lakshmi Kant was the first Vice President to die in office. 7. When two Presidents, Dr. Zakir Hussain and Fakhruddin Ali Ahmed, died in office, the then respective Vice Presidents, V.V. Giri and B.D. Jatti acted as President. 8. The Vice President Drs. Radhakrishnan discharged the functions of the President in June 1960 when the then President Dr. Rajendra Prasad was on a 15-day tour to the USSR, and again in July 1961 when he, Dr. Rajendra Prasad, was very ill. 9. The Salaries and Allowances of Officers of Parliament, Amendment, Act, 2008. Prime Minister in the scheme of parliamentary system of government provided by the Constitution, the President is the nominal executive authority, de jure executive, and Prime Minister is the real executive authority, de facto executive. In other words, President is the head of the state while Prime Minister is the head of the government. Appointment of the Prime Minister. The Constitution does not contain any specific procedure for the selection and appointment of the Prime Minister. Article 75 says only that the Prime Minister shall be appointed by the President. However, this does not imply that the President is free to appoint anyone as the Prime Minister. In accordance with the conventions of the parliamentary system of government, the President has to appoint the leader of the majority party in the Lok Sabha as the Prime Minister. But, when no party has a clear majority in the Lok Sabha, then the President may exercise his personal discretion in the selection and appointment of the Prime Minister. In such a situation, the President usually appoints the leader of the largest party or coalition in the Lok Sabha as the Prime Minister and asks him to seek a vote of confidence in the House within a month. This discretion was exercised by the President, for the first time in 1979, when Neelam Sanjeeva Reddy, the then President, appointed Charan Singh, the coalition leader, as the Prime Minister after the fall of the Janata Party government headed by Morarji Desai. There is also one more situation when the President may have to exercise his individual judgment in the selection and appointment of the Prime Minister, that is, when the Prime Minister in office dies suddenly and there is no obvious successor. This is what happened when Indira Gandhi was assassinated in 1984. The then President Zail Singh appointed Rajiv Gandhi as the Prime Minister by ignoring the precedent of appointing a caretaker Prime Minister. One later on, the Congress Parliamentary Party unanimously elected him as its leader. However, if, on the death of an incumbent Prime Minister, the ruling party elects a new leader, the President has no choice but to appoint him as Prime Minister. In 1980, the Delhi High Court held that the Constitution does not require that a person must prove his majority in the Lok Sabha before he is appointed as the Prime Minister. The President may first appoint him the Prime Minister and then ask him to prove his majority in the Lok Sabha within a reasonable period. For example, Charan Singh, 1979, VP Singh, 1989, Chandrasekhar, 1990, PV Narasimha Rao, 1991, A.B. Vajpayee, 1996, Deve Gowda, 1996, I.K. Gujral, 1997, and again A.B. Vajpayee, 1998, were appointed as Prime Ministers in this way. In 1997, the Supreme Court held that a person who is not a member of either House of Parliament can be appointed as Prime Minister for 6 months, within which he should become a member of either House of Parliament, otherwise, he ceases to be the Prime Minister. Constitutionally, the Prime Minister may be a member of any of the 2 Houses of Parliament. For example, 3 Prime Ministers, Indira Gandhi, 1966, Deve Gowda, 1996, and Manmohan Singh, 2004, were members of the Rajya Sabha. In Britain, on the other hand, the Prime Minister should definitely be a member of the lower house, House of Commons. Oath, term and salary before the Prime Minister enters upon his office. The President administers to him the oaths of office and secrecy. 2 In his oath of office, the Prime Minister swears 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. 3. To faithfully and conscientiously discharge the duties of his office. And 4. To do right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. In his oath of secrecy, the Prime Minister swears that he will not directly or indirectly communicate or reveal to any person, any matter that is brought under his consideration or becomes known to him as a Union Minister except as may be required for the due discharge of his duties as such Minister. The term of the Prime Minister is not fixed and he holds office during the pleasure of the President. However, this does not mean that the President can dismiss the Prime Minister at any time. So long as the Prime Minister enjoys the majority support in the Lok Sabha, he cannot be dismissed by the President. However, if he loses the confidence of the Lok Sabha, he must resign or the President can dismiss him. 3 The salary and allowances of the Prime Minister are determined by the Parliament from time to time. He gets the salary and allowances that are payable to a Member of Parliament. Additionally, he gets a sumptuary allowance, free accommodation, travelling allowance, medical facilities, etc. In 2001, the Parliament increased his sumptuary allowance from 1,500 to 3,000 per month. Powers and functions of the Prime Minister. The powers and functions of Prime Minister can be studied under the following heads. In relation to Council of Ministers, the Prime Minister enjoys the following powers as head of the Union Council of Ministers. 1. He recommends persons who can be appointed as ministers by the President. The President can appoint only those persons as ministers who are recommended by the Prime Minister. 2. He allocates and reshuffles various portfolios among the ministers. 3. He can ask a minister to resign or advise the President to dismiss him in case of difference of opinion. 4. He presides over the meeting of Council of Ministers and influences its decisions. 5. He guides, directs, controls, and coordinates the activities of all the ministers. 6. He can bring about the collapse of the Council of Ministers by resigning from office. Since the Prime Minister stands at the head of the Council of Ministers, the other ministers cannot function when the Prime Minister resigns or dies. In other words, the resignation or death of an incumbent Prime Minister automatically dissolves the Council of Ministers and thereby generates a vacuum. The resignation or death of any other minister, on the other hand, merely creates a vacancy which the Prime Minister may or may not like to fill. In relation to the President, the Prime Minister enjoys the following powers in relation to the President. 1. He is the principal channel of communication between the President and the Council of Ministers. 4. It is the duty of the Prime Minister, a. to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation, b. to furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for, and c. if the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. 2. He advises the President with regard to the appointment of important officials like Attorney General of India, Controller and Auditor General of India, Chairman and members of the UPSC, Election Commissioners, Chairman and members of the Finance Commission and so on. In relation to Parliament, the Prime Minister is the leader of the lower house. In this capacity, he enjoys the following powers. 1. He advises the President with regard to summoning and proroguing of the sessions of the Parliament. 2. He can recommend dissolution of the Lok Sabha to President at any time. 3. He announces government policies on the floor of the House. Other powers and functions. In addition to the above-mentioned 3 major roles, the Prime Minister has various other roles. These are: 1. He is the Chairman of the Planning Commission, now Niti Aayog, National Development Council, National Integration Council, Interstate Council and National Water Resources Council. 2. He plays a significant role in shaping the foreign policy of the country. 3. He is the chief spokesman of the Union government. 4. He is the crisis manager-in-chief at the political level during emergencies. 5. As a leader of the nation, he meets various sections of people in different states and receives memoranda from them regarding their problems, and so on. 6. He is leader of the party in power. 7. He is political head of the services. Thus, the Prime Minister plays a very significant and highly crucial role in the politico-administrative system of the country. Dr. B.R. Ambedkar stated, "If any functionary under our Constitution is to be compared with the US President, he is the Prime Minister and not the President of the Union." Role descriptions. The various comments made by the eminent political scientists and constitutional experts on the role of Prime Minister in Britain holds good in the Indian context also. These are mentioned below. Lord Morley, he described Prime Minister as primus inter pares, first among equals, and keystone of the cabinet arch. He said, the head of the cabinet is primus inter pares, and occupied a position which, so long as it lasts, is one of exceptional and peculiar authority. Herbert Marrison, as the head of the government, he, Prime Minister, is primus inter pares. But it is today for too modest an appreciation of the Prime Minister's position. Sir William Werner Harcourt, he described Prime Minister as inter stellas luna minors, a moon among lesser stars. Jennings, he is, rather, a sun around which planets revolve. He is the keystone of the Constitution. All roads in the Constitution lead to the Prime Minister. H. J. Lusky, on the relationship between the Prime Minister and the Cabinet, he said that the Prime Minister is central to its formation, central to its life, and central to its death. He described him as the pivot around which the entire governmental machinery revolves. H. R. G. Reeves, the government is the master of the country and he, Prime Minister, is the master of the government. Monroe, he called Prime Minister as the captain of the ship of the state. Ramsay Muir, he described Prime Minister as the steersman of steering wheel of the ship of the state. The role of the Prime Minister in the British parliamentary government is so significant and crucial that observers like to call it a prime ministerial government. Thus, R.H. Crossman says, the post-war epoch has been the final transformation of cabinet government into prime ministerial government. Similarly, Humphrey Berkeley points out, Parliament is not, in practice, sovereign. The parliamentary democracy has now collapsed at Westminster. The basic defect in the British system of governing is the super-ministerial powers of the Prime Minister. The same description holds good to the Indian context too.
Relationship with the President.
The following provisions of the Constitution deal with the relationship between the President and the Prime Minister. 1. Article 74. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. However, the President may require the Council of Ministers to reconsider such advice, and the President shall act in accordance with the advice tendered after such reconsideration. 2. Article 75. The Prime Minister shall be appointed by the President, and the other ministers shall be appointed by the President on the advice of the Prime Minister. B. The ministers shall hold office during the pleasure of the President, and c. The Council of Ministers shall be collectively responsible to the House of the People. 3. Article 78. It shall be the duty of the Prime Minister, a. to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation, b. to furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for, and c. if the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chief Ministers WHO became Prime Ministers. 6 people, Morarji Desai, Charan Singh, VP Singh, PV Narasimha Rao, HD Deve Gowda and Narendra Modi, became Prime Ministers after being Chief Ministers of their respective states. Morarji Desai, Chief Minister of the erstwhile Bombay state during 1952-56, became the first non-Congress Prime Minister in March 1977. Charan Singh, who succeeded him, was the Chief Minister of the undivided Uttar Pradesh in 1967-1968 and again in 1970. VP Singh, also from UP, became Prime Minister in the short-lived National Front government, December 1989-November 1990. PV Narasimha Rao, the first Prime Minister from South India, who held the post from 1991-1996, was Chief Minister of Andhra Pradesh between 1971-1973. HD Deve Gowda was Chief Minister of Karnataka when he was chosen to lead the United Front government in June 1965. Narendra Modi, BJP, was the Chief Minister of Gujarat when he became the Prime Minister in May 2014. He served as the Chief Minister of Gujarat for 4 times during 2001 to 2014. Table 19.1 Articles related to Prime Minister at a glance. Article No. Subject Matter 74. Council of Ministers to aid and advise President. 75. Other provisions as to Ministers. 77. Conduct of business of the Government of India. 78. Duties of Prime Minister as respects the furnishing of information to the President, etc. Notes and references. 1. On the death of Jawaharlal Nehru and Lal Bahadur Shastri, when the leadership was contested, the President made temporary arrangements by appointing the senior-most minister as the Prime Minister, until the formal election of the leader by the party. Both the times, it was Gulzari Lal Nanda who acted as the Prime Minister. 2. The form of oath of office and secrecy for the Prime Minister is similar to that for any Union Minister. See Chapter 20. 3. For example, VP Singh in 1990 and Deve Gowda in 1997 resigned after defeat in the Lok Sabha. 4. Article 78 specifically deals with this function of the Prime Minister. 5. The Hindu, 6th April 2009. Central Council of Ministers as the Constitution of India provides for a parliamentary system of government modelled on the British pattern. The Council of Ministers, headed by the Prime Minister, is the real executive authority is our politico-administrative system. The principles of parliamentary system of government are not detailed in the Constitution, but two articles, 74 and 75, deal with them in a broad, sketchy and general manner. Article 74 deals with the status of the Council of Ministers, while Article 75 deals with the appointment, tenure, responsibility, qualification, oath and salaries and allowances of the ministers. Constitutional provisions. Article 74, Council of Ministers to aid and advise President 1. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. However, the President may require the Council of Ministers to reconsider such advice, and the President shall act in accordance with the advice tendered after such reconsideration. 2. The advice tendered by ministers to the President shall not be inquired
into
in any court. Article 75. Other provisions as to ministers.